Let's settle down, please. Good morning, AJP.
Good morning, DCJ, and all commissioners.
How are you?
I'm okay, and you?
I'm fine, thanks. How are things in the kingdom of KwaZulu Natal?
Well, there's peace and tranquility at the moment in the kingdom.
AJP, your voice has always been soft, so and I'm hard of hearing. I'm going to ask you to bring the mic as close to you as possible and try to speak as loudly as possible, just for me. Before we start, I need to disclose that you and I have a close relationship. I've even written the foreword for 2 of your numerous publications, your 2 books on customary law. Or are you denying that you are friends?
I beg yours?
I'm asking if you are denying that we are friends.
No, I don't deny.
Oh, okay. You are a veteran judge, well known for your diligence and efficiency. You've produced legions of judgments all the way up to the Constitutional Court, where you recently acted as a judge. And you are a prolific author as well, as I've already alluded. Now, you have been in the leadership of the KwaZulu-Natal division of the High Court, first as a DJP, a Deputy Judge President, and more recently as an acting Judge President when the former Judge President, DRP, retired. I just want you to tell me when you were appointed as the Deputy Judge President and when you started acting as the Judge President that you are now.
Oh, thank you. I was appointed in 2016, June 2016, as a DJP. And at certain times when the former JP was absent or on leave, I will act as a Judge President. And when he left at the end of November 2021, because he started by going on leave, and thereafter he retired, I took over as from the 1st of December. But I was officially appointed as from January until now. When I took over in terms of the statute of the Superior Court Act, that whenever the Judge President is not available, the Deputy Judge President must take over.
All right. Well, you were very recently interviewed for this very position in the last session in April, and I know that you were given a very thorough questioning. But just to refresh our minds, I'd like you to give us your vision for the division, but remember that we have the record of your recent interview with us. We have a fair idea of what that is. We just want the highlights, and we will ask questions for you to expatiate if there is need.
Yes, thank you, DCJ. I'll just highlight, as you have said, and if you ask me how to achieve that, then I'll do so. The first thing which is in my mind is judicial transformation, a creation of an access to justice or to courts, the reformation of the civil justice, with a view to providing effective, efficient, prompt, affordable, equal, and quality justice to all. The creation of a diverse bench, the continuous education and training of the members of the bench, and also other stakeholders whose professional role is indispensable to the efficacy of the court system and case management. Also, to ensure the active involvement and participation of the members of the bench of the division in the provision of equality justice to all South Africans. Also, the transfer of skills, affording all the members of the division equal opportunities, and encourage them to use their talents and abilities, and also to promote the use of the information technology. As we have seen recently that we had problems because the shortage of or lack of the knowledge in that respect during the pandemic. Well, roughly, those are that is my vision, because the last vision now is that eventually we must have a court, maybe partly online and partly on paper for the people, for indigenous people to be able to have an access. But the time has arrived now that we should embrace technology as it has taken the center of everything at this time and age. Thank you.
Thank you, JP. Have you been able to lay the foundations for this plan of yours in the time that you've been in the leadership seat? And if so, I want you to tell us precisely what measures you have implemented towards that end.
Well, I have, since I've started, I've done all this, though maybe I may not enumerate them one by one as I have mentioned them. The first thing I started with is to help those who are less advantaged or less experienced in the bench to have an exposure, to acquire knowledge, legal knowledge, experience, and skills. And you may be one of the people who know better about that, because I liaise with you to help me assist those people to get the acting appointments in your court. And also I talked to the Chief Justice, who was then the DCJ. There were people who were, because of the list of the years on the bench, they could not have been looked at, but I afforded them that opportunity to show themselves. And some of them, they managed to take that advantage and ran with it. Also, as far as the creation of a diverse bench, I have gone out of my way to recruit acting judges across the racial divides. So as a result, then I ended up having more than 30, of whom 18 are females, and the rest, they are males, across the racial divide, to ensure that our bench is diverse and be able to deal with any matter across the diverse legal field, and also to be a representative of the diversity of the society of the division. And with regard to the reformation of civil justice, I have been very instrumental in making ways and efforts to be able to provide a speedy, affordable, and simple process for the resolution of civil disputes. And more so, the simplification, harmonization, and alignment of our rules of practice, procedures, common law, even customary law, to the values of the Constitution. I've done that. I have been written articles, legal articles, which are published, and books, and in my judgments, I have done that. And the transfer, I've started with the transfer of skills, but I may go back to it as well, because we created a pool of proteges where the appointments will be drawn. And that helped to address a number of issues. The issue of gender representativity, racial, training, experience, etc., and a diverse bench out of that pool, because we draw these people from various talents, advocates, attorneys, magistracy, academia. So to put all these people together and ask them to work towards the achievement of the common goal for the optimum benefit of the division. I don't know whether I have left some things, but also the question of visuals, hearings, video conferences, and telephones. Though most of the people are not conversant with this modern technology, but we are trying to introduce that, even though the funds, the availability of funds or unavailability of funds for bids, but we are trying, because we have learned a lesson from the COVID pandemic, where the courts had to come to a standstill as the people could not come together. So I've covered a lot, and also to assist all the members to acquire the necessary skill, even if they want to go to special courts. I assist them and allow them to do so, or the SCA or Concord, or wherever they want to enhance their legal knowledge, and also to know the purpose that people must have access to justice, and they must be committed to serving and protecting all the people of South Africa, unlike under apartheid era, where the law was serving and protecting a section of the population. So I've done that, all that at the CJ and commissioners. Yeah. If I miss up some of them, but as I move along, maybe I'll remember.
No, thanks for that elaboration, AJP. I can just say that, just mention that in the heads of court cluster, I know you are one of the heads of court who have clamored the loudest for assistance regarding the infrastructural challenges that bedevil the judiciary across the board, especially the lower courts. But those are common problems, I suppose, for the entire country. But I won't dwell much on that. During your last interview, a sticky matter arose concerning one of your books, and you, attached to your application form, is an explanation where you seek to address the concerns that were raised with you and your suitability as a, not just as a leader of court, I suppose, but as a judge too, if you hold the views you were said to hold. You know what I'm talking about. Would you like to address the commission on the submissions you have sent in to address that concern?
Yes, briefly, because some have been stated in my questionnaire, but I'll do so. Firstly, after realizing how some of the commissioners interpreted the portion of the book complained of, I said to myself, I have to review this section and see if I can be able to bring some clarity to bear on it and try to put it in its proper context and perspective. Because the way it was interpreted was not the way, is not what I intended to convey. That concerned me much, to such an extent that I was accused of being homophobic. So I said, let me look at this thing and see how I can address it, because I didn't want to be offensive. Maybe I made a mistake somehow. Let me look at it, and I did so. I corrected what they were complained of, so that I would not be offensive. And furthermore, I wanted to establish that maybe somehow I have unconscious bias. So if that unconscious bias, if were to be found to exist, to be addressed as soon as possible, then I enrolled with the Cape Town University for the Leading Diversity and Inclusion at Work course, which is a 6-module course, so that I'll learn more about this, and also to enhance my leadership skill, because that is a leadership course also. So to be able to address the situation, if anything of that nature exists. So that's what I did out of my own volition, because I think that, or I submit that it's better if you see there's something wrong or a mistake, we acknowledge the mistake and correct it, rectify it. That's what I have done to ensure that what happened was not what I intended to happen, and the interpretation of that portion, maybe some other people can also continue interpret it in that version. So I had to address those issues.
Are you saying you made changes to the text of the book?
Well, I made changes to what they were complaining of, or my comments, because they said my comments, if they interpret them, they can mean this and that, they can mean this and that. So just to remove that.
You removed the text that was found offensive.
That they complained of.
Yes.
Yes,
That's
I
what
did.
I mean.
I did.
All right. And what is this course you say you took?
It's a leading diversity and inclusion at work, where we deal with a number of people from the walks of life, different sexuality, different gender, different races, different a number of things, where how to deal with those people who are in a management position, and how to be considerate of people, and so on. Because part of this thing, even in my article I referred to, I forgot to say that when I was at home after this interpretation, I looked through and see, I published an article where I was dealing with the very same issue, where I was urging the judges to be considerate and sensitive when dealing with the matters relating to the people I have referred to in that book, because I recognize that they were previously marginalized and discriminated against and so on. That should not continue. So when the book was interpreted, it's interpreted as against that, I have said, only to find that that book is a contemporary publication with the article, so which indicates clearly that that's not what I intended to convey.
In a comment sent by Natal in respect of one of your colleagues who are also vying for this position, they make reference to what they describe as stark historic racialized tension in your division, racism and perceptions of racism in the division. And you did not mention that challenge when you spoke of your vision. Are there such challenges down there? And if there are, what have you done or intend doing to address them?
I'm not aware of a situation of that nature as they describe. You know that when the people are together, at times there are little differences, but this one is no such a thing which could be even pertinently addressed. We address it by combining even these people when they're performing duties. I used to pair all of them, more particularly when we're doing appeals, so that they should be used to each other and also learn to respect and accept others, but not specifically because there's such a racial tension I think that is blown out of proportion, because they don't even make any example of any incident of that nature, that this an incident happened and this and that. Well, there can be people who may have their own ideas and do things in their own way, but I make all effort that we should respect one another and also learn to work together, even if people are not, they don't agree on a number of issues, or they're not friends. They need not be friends, because they're not there to be friends, but to do the job. So I will be glad if they specify what they're talking about.
So to your knowledge, there are no race issues in your division?
Yeah, there are no race issues of that nature. There could be a subtle thing which I'm addressing, as I've said, but not of the nature they are saying, because it would be easier and more helpful if they indicate an incident, so that I'll be able to address myself to it properly.
The professional bodies have commented on on the three of you, and they all, without fail, acknowledge the enormous contribution they say you've made to the judiciary. But some of them have asked us to put questions to you, and I'm looking at the Law Society's comment where they say, although your track record as Deputy Judge President is beyond reproach, unfortunately, during the period when you've been serving as AJP from January 2022, you have not introduced any innovative or new procedures to enhance the delivery of justice in that court. And for that reason, they don't support your candidature. Would you like to respond to these comments?
Yes, yes, certainly. Firstly, I'm really humbled by they say what I'm doing is beyond reproach. The thing they did not do is to do a proper research of what they are saying. Because since April, after these interviews, I've done a lot of things. Firstly, the question was put to me whether is there any procedure and guidelines for selecting and appointing acting judges. At that time, there was none in existence, but now I've put it in place. That is there, and I involve all the legal bodies and all legal fraternity to comment and so on. That is in place. And secondly, as we have also mentioned, you yourself, DCJ, I have been vociferous at the meetings about the forensic laboratory, problems, default judgments. I've been fighting those things. That was not only my problem, but in my area, the problem was very big, to such an extent that we had more than 8,000 divorce judgments brought to our courts, and they were not attended. So I wrote a memo to address that problem, and the problem was effectively addressed. Also, in April, as we all know, that in KwaZulu Natal, we were engulfed by the floods, which took the lives of more than 400 people. As a head of court of the division, I initiated a project and appointed a special task team to address those problems, to prioritize the inquest related to the flood, so that the people, to ameliorate or cushion the pains and anguish people have suffered, that they should not suffer now waiting for the inquest to be finalized and to get some documentation if they want to file some claims for compensation. We're working with the chief magistrates in the area, Mr. Ngubane and Ms. Manyimore. We put up a task team comprising the police, the DOJ, the TPP, health, and magistracy, to make proper arrangements for that. As a result, as it is now, notwithstanding the fact that there had been some problems, some people could not be identified, and some coming up to claim corpses which they don't belong to them, they have to go through the DNA examination or analysis. But 123 of those has been done, and the people can get service now. That's what I've done. And also, I've dealt with the question of the appeals because there is a practice or tendency that the legal practitioners, they brought appeals cases or records, well knowing that the record is incomplete, but they don't disclose that. They wait until the date of hearing. Then on the date of hearing, these matters are adjourned for reconstruction. The thing which have been done, which could have been done some time ago, and avoiding people unnecessary costs. So I wrote a memo how to address those things at the first instance when they are brought to the registrar and the legal practitioner, applicant or appellant in question. They must look at the record and see everything is in order before the matter is set down. If there's any problem, then the registrar should bring that to the notice of the presiding judge, and the presiding judge will talk with the parties or the legal practitioners or legal representative and how to solve those problems before the date of hearing. That I've done. And also worried about the delay in setting down of the matters for trial, the finalization of matters, a delay in delivering judgments. I have drafted what I termed is a pre-trial procedure. It's a directive on that, which I've sent out to all the stakeholders to comment on it with the view to addressing these problems. I have also put a number of things in place that how to allocate cases equally and in a fair and evenly balanced way, because we had some problems at times, find that we are no longer having judges to deal with matters because they get a matter after a matter and we run out of judges. But that created judges and avoided the crowding out of matters. Maybe those things I've done recently. So if they say I've not done anything, I'm afraid they're not correct.
Yes.
Yes.
And Natal, in their submission, also acknowledge your valuable contribution to the judiciary. And they say that since you have acquired experience in senior leadership positions in the judiciary, you are indeed up to the task of fulfilling the role of JP. They don't doubt that. But now they have asked us to find out from you what your views on gender transformation are and whether it is not time for a woman to ascend to the position of JP in the division. And when you respond to this concern, if you choose to, I would like you to do that bearing in mind the general lamentation about the lack of women in South Africa's judiciary, which has not a single JP as we speak, except for Judge Mir, who is acting in that position in the Land Claims Court. You may go ahead.
Thank you, DCJ. I'll answer this question as follows. Firstly, it does not lie with me to decide and recommend which candidate to be appointed. It lies with this commission. However, in my submission, the appointment of a particular candidate should not automatically follow or flow from the gender of that candidate, but the potential, ability, capability, legal qualifications, experience, skills, legal knowledge a particular candidate possess. These are the things which make a candidate suitable for appointment in a particular position, more particularly this position of the judge president. Secondly, I would say I am an ally to the women in their pursuit for gender equality. And I have not only demonstrated this by words of mouth, but also by deeds, which is confirmed by all legal bodies commented in my questionnaire. I'll start from my home in the 80s. My wife went to the college and enrolled for a teacher's diploma. I had to remain at home looking after our children while she was still away. That was an unknown of thing to happen in the rural area, for instance. And secondly, as I've stated, I've gone out because when I started becoming a JP, I asked that why do we have a boys' choir acting judges? And the JP said that he could not find them, maybe I will find them. Then I looked for them, I found them, as I've stated, that I managed to get more than 18, and some of them, they're judges, and some of them are in your court, and some are in your court now, in your recent court, that through that effort. And mind you, those people they had at the time the least experience, but I managed to spot their ability and capabilities from them, and I said, try them. Then they showed themselves. That's what I've done. And in the annals or the records of our division, I'm the first acting TJP to appoint, acting judge president, to appoint a female acting deputy judge president, with a view to giving them a way to the leadership position. And now, the critical moment is that at the moment, as I've been discharging my duties or judicial responsibilities with a vision. So I think I'm uniquely positioned and best placed to leverage a smooth and seamless transition to ensure stability and continuity of court leadership. So I have nothing against women getting positions, but I'm paving the way so that when I go, I leave this in the able hands, not just leaving it in the hands of a woman, but of a person who's able, and that is a woman, that is a bonus. So that is my view and submission, that's how we should do it, and I'm doing it, even presently.
So in sum, you are saying you have put in place a succession plan that will ensure that when you do retire, it will be possible for a woman to take over. Is that what you're saying?
Yes, we have a solid succession plan in place. Recommending these ladies to your court that was intended to be a build-up. And now appointing them in this position, that's what we are intending to do, to achieve at the end. And we are about to achieve, because we already now have had an acting deputy judge president, and from there the judge president. So, because if she's appointed now, that will mean all what we have done, maybe they wasted effort, because we'll rest with her whether she will listen to us or not, to me or to whoever afterwards. If I say something against the grain, she will decide whether to take it or not. But now, I want to have this transition and to ensure that when she takes over, she's fit and proper person, not only a woman, but a fit and proper jurist.
The lawyer in me is turning this proposition around, and I'm thinking to myself that it may very well be argued that it is actually possible to ensure that transition by seeing that you already have these good intentions, having you in this position you now hold as Deputy Judge President, assist a woman Judge President if the Commission recommends one and they are subsequently appointed, assist that woman to, to find their feet in the position, so that this constitutional imperative, its implementation, this constitutional imperative that says the judiciary must be diverse in terms of race and gender is fulfilled. Now, its implementation is not delayed and wait until you retire, whenever you do. What would you say to that, to that argument?
Well, my answer to the argument, as I've said, is that that will make it not feasible to leverage a smooth and seamless transition and to ensure the continuity of leadership. Because once I will be a subordinate, she will decide whether to take my advice or not, or maybe I'm saying grapes are sour or something like that. I don't see it feasible in that way, other than creating an unstable condition, other than having a smooth transition, as I'm doing. And it's not that the long time that I go that can be addressed in the near future. So there's no need now. This can be done now, whereas it can be done tomorrow in an efficient way, in a peaceful fashion. Why should we now disrupt what is happening? Unless they give me a bigger reason to disrupt what is happening with the intention to achieve the very same purpose.
Which takes me to the other concern raised by Natal, which sounds caution that is the JSC, may have to ponder whether it is not in the interest of the judicial system for a younger candidate to ascend to the position, mindful that you are close to mandatory retirement age with only a few months left to serve. What do you say to that?
Well, I'm not aware of a few months, but I'll answer the question.
When do you retire?
Well, it could be the end of next year.
In November 2023?
At the end of November 2023. If I count October, that could be about 14 months. But I'll answer this question in this fashion. Firstly, the time remaining to me is more than adequate to accomplish what I've set out to do. Secondly, there's no law principle or rule which says if a judge has so much time remaining before retirement, he or she cannot make himself or him or herself available for a management position or an appellate court position. There's nothing like that. Even the advert is silent on that. And thirdly, this is not an entry-level post. It's a continuous management post. And in my submission, it is against that background that judges are appointed in this management position, even if they have a short time remaining before the retirement. I have many of them. Starting from the Chief Justices. We have the Chief Justice Strat Court. He was appointed for 1 year before he retired.
Chief Justice, sorry, who was that?
Stratford, James Stratford. He was appointed in 1938 and he retired in 1939. Recently, we have, even though this one is a foreign jurisdiction, Judge Pascoe of Australia was appointed Chief Justice of the Family Court of Australia in 2017 and retired in 2018. We have the former Chief Justice, Ngobo, who was appointed, whereas he had a short period remaining before the expiry of his mandatory period at the Crown Court. We have the current serving Chief Justice also in the same category. Those are Chief Justices. Then I come to the JPs of our division. We have Judge Van Heerden, who was even appointed for a very short period. He was appointed in January and retired in August 1988. We have also Judge Williamson, who was appointed in March and retired in December 1961. And we have also judges who were appointed to the appellate courts, like Galgat. He was appointed in 1975 and retired in 1976 because of this mandatory term, as the TCJ is referred to, but he was appointed, even appointed thereafter as the acting judge at the appellate division. We have also Bosov, who was also in a similar position. So I don't think those created the precedent in law. I don't think that precedent should be applied. In my submission, let me say, that precedent should not be applied selectively. And more so, during this period, there are a lot of things I have to do. Look what I've done since April. So these 14 months, I will achieve what I've set out to do. So, and also, what is important, as I've said, I'll repeat it again to say, we need the smooth and seamless transition, ensure stability, and the continuity of court leadership for the achievement of transformative goals in our division. Depends not only on leadership, but on a continuity or on a continuous leadership. So if we disrupt that, we must have a bigger reason to do so. And also, in terms of our constitution, The Constitution makes it unfair to exclude one on the basis of one's age. It's clear on that. So I'm still a vehicle to take some people, the less advantaged people and less experienced people to empowerment, to the world of empowerment. And also to ensure that all this I've started are firmly in place. Otherwise, what I've done all along will be a wasteless effort. So that is my submission with regard to this question.
Well, the lawyer in me, once more, is turning and twisting this proposition that there is ample precedent for the appointment of a leader when they are just on the verge of retirement, which should not be disturbed. And I'm thinking to myself that maybe back in the day of Stratford in the 30s, the process of appointing a Chief Justice would not have been as convoluted as it is now. There would not have been a JSC with as many members as we see in this room, which has to be convened for a sitting, for a hearing session, when a judge has to be chosen at great cost to the fiscus. And that it may very well be argued that questions of practicality and cost effectiveness and the like may not stand you in that proposition of yours in good stead. I don't know what you'd want to say to that.
Thank you, TCJ. I will start by saying that I've mentioned even the recent ones, not the old ones. And also, I would urge the Commission to do whatever it intends to do, it must be in the best interest of the division, not of a particular individual. Because if you cut your face in order to cut your throat in order to spite your face, it's something else. Because simply because you want to see a certain person leading, a younger person leading at that time, well, that person has to be taught the ropes. If you kick out an experienced driver and you put in the driver which just acquired a learners 2 weeks ago, what do you expect? What do you expect? The disaster which will occur after that, who will be responsible for it? So we are doing this thing in a proper way so that even if a person takes over, that person will earn a respect that is there in the position because he befits. Not because some people, they thought that it will be good, maybe it will be correct to do this, but not looking at the outcome or the consequences of what they're doing.
Thank you, Acting Judge President. But before I hand over to my colleagues, I just want to acknowledge the presence of MEC Simelane, who represents the Premier of KwaZulu Natal. Thank you, ma'am, for joining us. And Judge Ngoni, who represents Judge Mganti, sorry, my brother, who represents the head of court of the division. You're welcome. Colleagues, Judge Mngadi, it's your turn to put questions to AJP Madondo, if you have any.
Thank you, DCJ, and good morning to all the commissioners, and good morning to you, Judge Madondo, Acting JP.
Good morning, Judge Mngadi.
Well, I'll try and avoid dealing with those issues that the DCJ has raised with you and we have addressed. And I will also try and avoid rehashing the issues that you dealt with in the April interview, as we have been provided with a transcript and we have perused it and we have seen the issues that were dealt with during that interview, which is still fairly recent. And to you, acting AJP, I've known you over many years, and of course, currently I'm serving under you as a judge. So when I put questions to you, it is on the basis of that. Let me first start with the comment which is said to have been made by the LLSA. Talking from experience, I've been close to that division for more than 20 years as a practitioner, and of course also for about 5 years now as a judge. I am there daily. I heard you, AJP, addressing the question, but I think you did not address it forcefully, and it cast a completely wrong impression about the division, that in that division there is racism. I have, as a junior judge, I have been guided by senior white colleagues in that division. And you, through your leadership, I've seen you being supported by senior white colleagues in the division, or even senior Indian colleagues in the division. Naturally, as people differ in that there are Indians, there are blacks, there are whites, that is the natural thing which is there, which cannot be avoided. But to say that there is racism in the division, that is completely not correct. I do cases with colleagues, and I can say emphatically that generally there is no racism in the division. There could be cliques based on some other common identities, but there is absolutely no racism in the division. Do you agree with me on that, Acting JP?
Yes, as I've answered that, there's no such thing. Well, people may have differences. That's why we have to learn to accommodate and appreciate the differences. But to have that difference does not mean that there's a racial tension. I'm not aware of a racial tension, because even those cliques we are talking about, they are of a mixture. It means that some people maybe they side with their view, so and so. They're a mixture. They're not in a sense that we find only African or only judges of Indian origin or white judges grouping themselves up in that fashion. I have not seen such a thing. And also, I dilute that situation, even if it may arise by pairing these people in whatever they're doing in that fashion. I put one, a white, an Indian, or an African together to work on the case on a regular basis. As you know, I've done it even to yourself.
And for the record, CJ, I might have attributed that comment to a wrong organization, but nevertheless, I just wanted to address the issue that was raised. And then again, Acting JP, the issue relating to the LGBT community. Well, I accepted that people might have different perspectives, But what I want to commend you for doing is to, once the issue is raised, to reflect on it and to
Judge
seek.
Nguni, we have time constraints. So we have a role. I'm sorry you would not know about it because you are not a JSC commissioner. We limit what we say to questions. We don't make comments, and we try to abide by that rule strictly. So I'm going to ask you to please just ask AJP questions, direct questions.
I'll take note of that,
Thank you.
ACJ, but at times I need to give context to my question. And
All
this is
right.
my only second question.
Okay.
What I wanted clarity on is just a short issue. Firstly, that when you reflected and you dealt with this issue, you enrolled and you did a formal course for which you submitted assignments, and the assignments were marked and you were allocated marks. And if I am not mistaken, the general average of those 6 courses you did, it's about 75%. And you did this whilst you were doing your duties as acting JP, and during that period too, you were also doing your work which you had to do because you were acting in the Constitutional Court just prior to that. Is that correct?
Yes, it's correct, except to say it was the aggregate percentage is 87, not 75.
And thank you for that correction. And lastly, on that issue, again, despite that this issue was raised with you in April during your interview, and it enjoyed wide publicity, but right here before us, we have overwhelming evidence that you are supported, that you be appointed as a JP by a number of professional organizations, traditional leaders, and in fact, one can hardly find any entity or person who is against your appointment as a JP. You agree with that?
Yes, I agree, as I have said, that what steps I took to remedy the situation, so that I would be what the people have always known me to be. And it's against my nature to do something or say something which impedes negatively on other person's dignity. That was not my intention. So I wanted to show, I think my submission is that if we are a leader, if you see that something has not gone right, you accept that and you rectify it in the way the people will be happy. And you properly convey what you intended. That's what that has been my approach and thinking.
Thank you. And again, you are, that is now the LLSA. You are accused of not introducing any innovative or new procedure to enhance delivery of justice in the High Court for the province of KwaZulu-Natal. Firstly, you agree with me that to introduce a practice directive, usually you do that on the basis of need. There must be a need for it before you introduce it. And again, you, during your, as part of the leadership, or you as a leader, you, during the for the last 2 years or so up to now, there's a time when you introduced a practice directive dealing with judicial case management issues, a practice directive dealing with COVID, how to deal with matters during COVID-19 pandemic, and you also introduced a practice directive dealing with RAF matters, how to deal with those matters so that they are not delayed to be dealt with, especially those which are not seriously opposed by the Road Accident Fund. And then, as you indicated recently, that there is that directive, part of it which deals with dealing with high-profile matters, media access relating to that, a directive which guides judges and advises the parties what will be the way forward. So I don't understand this concern or accusation that you are being accused of, that you did not introduce any innovative or new procedure.
Is that the question, or I'm not sure. You remind me of some I've omitted, as I've indicated to the DCJ that I might have omitted some, just like those directives pre- and post-COVID period, or pandemic period. There are so many, as I said, that they are mistaken or they did not do their research properly.
And again, as evidence of you driving empowerment, transformation in the division, and in particular empowerment of women. Today we have got women from the division who are competing for the JP position. And do you think it will make any difference to appoint a woman as a JP now, rather than appointing a woman as a JP about a year or so down the line? And and again, isn't that it is a practice in the division, KZN division, that usually a person who is a DJP is appointed a JP. A person who is a DJP is appointed a JP. That is a practice of a number of years. Can you comment on that?
Yes, on the first one, I think I've said it quite mindfully when I responded to the questions put to me by the DCJ. The second one about the established tradition there is, at some stage when the former JP applied, I decided not to contest against him and to support him instead. Firstly, because there is an established tradition in the division that if the JP goes or retires, the DJP should succeed. Should I contest it and appoint it at that time, that will cause an unstable condition and disunity, in the sense that there will be people supporting me, because even at that time, there were people who felt strongly that I was equally qualified for the position. There will be people supporting me, another group supporting JP, and the middle group, disgruntled though. Then it will be very difficult to harness these three groups together and make them work towards the achievement of a common goal for the benefit of the division. So I decided, no, let me arise above my parochial interest and ambition, personal ambition, in the interest of division. Then I supported Japi fully, and I told him that I support him, and I went along also trying people to rally behind him as a JP. That's what I did in the interest of the division.
Okay, this is my question before my last question. Well, you as acting AJP, it might not be easy for you to comment, but there are comments that the candidates who have made themselves available for the JP position, they are junior judges in the division. And according to the date of appointment, if I look at in the division, you have got about 28 judges, and Judge Boyo Dlwati, she comes at number 19, so she is still a junior judge. And Judge Steins comes somewhere in the middle. Do you agree with that comment by those who have commented to that effect?
That I appoint junior judges. Well, that one I do, as I said, I afford all the judges equal opportunities so that the people will be able to show themselves. Because if you are going to seniority all the time, there will people who never see the light. But if you look at how the people perform and how their abilities are and capabilities, and you identify that person and you task or recommend a person, I recommended the Boyo Dlwati to the SCA because I identified some abilities and capabilities, and I said, oh, this should be modeled up and nurtured. She can eventually have the leadership position. So, but if I had to go according to the seniority, as people say, she will not be where she is today.
But what I'm saying is that, as I indicated to you, that clearly in the division there are strong personalities. Then if they see you as a junior judge and you have not been guided properly, then you might not command respect of those individuals. What is your comment relating to that? That is the impact of seniority in commanding respect.
Well, as I have said, I should be allowed to accomplish what I've set out to do, because that will be smooth. That's what I'm talking about, the smooth transition. And that's what I'm talking about, stability and continuity of leadership. Because if it's done in that way, there will be no incidents of that nature.
And lastly, in your previous interview, acting JP, you addressed in some detail your leadership style, which indeed enforces respect in the division, and which is a leadership style which determines the culture that should prevail in the division. And you, as a leader, in other words, you serve as an example, and you enforce that should be the culture which will prevail in the division, and it will create cohesion and unity in the division. You confirm that you still follow that leadership style?
Yes, certainly, and that is the only one which will prevail if you want to see better things coming out of our division. Because I also want our division to rank amongst the highest divisions in the country. It must not be lagging behind. We must produce jurists from our division. We cannot do that if we don't put these practices in place and ensure that everybody gets an opportunity like any other person, and it depends how one uses that opportunity to better oneself.
Thank you, DCJ.
MEC Simelane, do you have any questions for AJP Madondo?
Thank you very much, DCJ. Good morning to you, commissioners and Judge Madondo. I do indeed, I have just two questions that I would like to ask. The first one, Judge Madondo, good morning to you. The first one,
Premier,
is in relation to the Traditional Courts Bill that is currently being discussed. I would like to find out what is your attitude in relation to this bill. Should it be implemented or should it be made into an act? what is your attitude in relation to the implementation? Here, I'm worried about, or I'm speaking in relation to the rights of women in rural areas in particular. And the reason why I'm asking this question is now, looking at the bill itself, it seems the opt-out option has been removed from the bill. So what do you think will be the impact of the implementation of the bill to rural women?
Thank you, Acting Premier. Firstly, people are really dealing with this issue, I don't in an unclear manner or unclear understanding of the whole thing. Because some people, they move from the premise that the Castleman law should have no place. According to my knowledge, the opt-out clause is there, but not in the way it was before. Before, it was like this. If a person is summoned to the traditional court, will simply say, no, I'm not coming there. And then that will be the end of the matter. So then one wonders, what is the purpose of this court if they can be defined in that fashion? Because when the magistrate court summons you, you cannot say, no, I'm not coming there, and that's the end of the matter. And when we look at a case which was decided by Judge Cameron, at the time he was at the SCA, he said these courts should be accorded the same dignity as any other courts. So if you do it like that, are you still giving them that dignity? What is being said now is that the person should come there and raise an objection that, no, I don't want my case to be decided here. Maybe I want to take it to the magistrate court or wherever. But coming to where the person is being summoned, that's my understanding of it at the moment, not that it's out altogether. And also, the question of women participating, that is provided there, that women should participate in this proceeding and all other activities. They are not excluded. But some people, they say, no, this thing is still following the boundaries of the apartheid and so on. I don't know. They look it from other premise, from the Western style. But whatever one says, the people still adhere to their customary practices. Even you, acting premier, if your daughter marries you, you receive lobolo. What is that? That is dealt in terms of the customary law. You cannot get lobolo dealing with the civil law, whatever. Even the civil law in our African culture, a lobolo is paid. Why is it paid? Because it should be abolished if that's the case. So we should not be something else, but if we are Africans, we have got our traditions, our customs, which we should follow. If they clash with the Constitution, that's where the problem arises.
So, Judge Matondo, my question is saying, do you think this bill or the act, when it becomes an act, will be able to protect the rights of women in rural areas? Because we know women, in as much as in paper, in rural areas are given the right, the equal status like everyone else, but practice in other areas is not always the same. So how are we going to ensure that they get that protection?
Well, people there in the bill appointed as commissioners and do that and that will do supervise and inspect these courts and to see to it that they adhere to what they're expected to adhere. And also, there's no law which is perfect. Let this promulgated, and we see the deficiencies in it that should be addressed. If you say people should not have this, look in the rural area. The primary law they have is the customary law and the traditional courts. There's no other. So if you deprive them that mechanism to access justice, it means now they should be forced to go to the magistrate court and hire the services of the legal practitioners and pay with what they're going to pay because they don't have money. But this court provides a simple, speedy, and inexpensive remedy for them to resolve their disputes. But if you say, no, let's throw the baby with the water because simply of one issue, whereas the 99% of the people will benefit after the whole thing. Because some people, they talk about this, they have never been in the rural area, they have never been part of that life, they just talk right from the theory. But in the practical sense, that is a primal mechanism which provides justice to the people. So if there are deficiencies in it, they should be corrected if they are. But I support the traditional court bill subject to amendment if the need arises.
Thank you. My last question, DCJ, to Judge Madondo is in relation to the efficient functioning of the court. Are there any initiatives that you have implemented or you have introduced to ensure that the court actually runs efficiently?
Yes, there are. And there are a number of them. We start having the stakeholders meetings where all the people who contribute to the administration of justice in one way or the other, we form a committee where certain issues between those members are resolved, failing which then they are taken to the PEC, which is the Provincial Efficiency Enhancement Committee. We have case flow management committee. We have pre-trial conferences where matters are discussed and you see there's an opportunity also to narrow the issues on those matters. In the case of criminal matters, whether the accused is defended or not defended and what will happen. And so as the civil proceedings also, and these matters are only set down when they are certified ready for trial. There are also procedures, as I've said, there's the one moving around where I'm waiting for the comments by legal fraternity just to address the issues relating to that enhancement of access to justice and to provide a speedy and affordable process of resolving disputes. Because another problem is what is created is litigation costs, the throat cutting, more particular for indigent people. So that's why we provide these things so that these matters should not take long. So there are many of those which I've put in place. As I talk about default judgment, this and that, as I've said earlier on. There are too many. But it's not that every ills will be cured in one day. So that's why we move along, but we have some things in place and we see the results.
Thank you very much, and thank you, DCJ.
Thank you, MEC. Colleagues, Commissioner Makonish.
Thank you very much, Deputy Chief Justice. Good morning, Judge Matondo.
Good morning, Commissioner.
I have 3 quick questions. One is in the form of an observation. When you were answering questions from the Deputy Chief Justice and Judge Mngadi, I got a sense that you have a succession plan that is centered around you and not independent from you. That is one. You kept on saying that this plan, seemingly you have developed it from April. You will correct me if I'm wrong. I believe that a duty of any leader is to start a succession plan on the first day he or she assumes office and not wait until the end. I believe that the succession plan, like any plan, should have a risk matrix. Now, if the unfortunate which would not want it that to materialize were to happen, God decides to have an appointment with you, which means we're just going to have a crisis. Because everything just centers around you and you finishing the term as a JP. Is my assessment correct?
Commissioner, even though I think we have more than one question, we are not correct to say it centers around me. At present, I'm a leader there. And secondly, it's not correct that I started after April. I started in 2016. What I've been talking about after April, I was talking about things I have done since April, not that it centers around me because of that. Because if you look at the people I've developed there, starting from somewhere. So those people, they're part of the plan. I'm not that it centers around me because the part of the plan, everything has got a leader. So then if you can't, a hand's head, and you wanted to continue laying eggs, it's another story. So the head is very important in that hand. So, and this is very important. If I die or if I retire, there will be somebody who will get into my shoes, who's being prepared at the moment. That's what I'm saying. It's not that centers around me. If it centers around me, I would not be preparing other people. I will be content that I'm the only one who can run this thing. So I'm preparing other people, even other commanders, they confirm that what I'm doing. So I would say we are somehow mistaken to say it centers around me. And I've addressed that one of April. Thank you.
Now, the risk matrix of the plan, as I've said, that you said that if you were to leave now, in fact, if you were not to be appointed and other people are appointed, there might be tensions there. Now, my issue is, if that were to materialize, not through the JSC, like the risk that I'm talking about, which we don't want to happen, what is going to happen there? Which means if you are not appointed, there's going to be a problem.
What problem? May you maybe clarify the problem?
If I listened to you, when you were being asked questions by both Deputy Chief Justice and Judge Mngadi, the impression was that because you are still implementing this plan, you would want to finish it, and other people are very junior, they might not be accepted. Am I correct?
We are not correct because I've stated all along that I developed even the junior people. Even Mngadi pointed out one of the candidates here, and some others I've developed. So then it could not be correct to say that. I developed those people for the purpose Because I know that I will not stay there forever. There'll be a time where I have to exit. That's why I'm doing that. So if you start something with a vision, you want to see it ending up in that vision. That's what I'm saying. It's not that if I'm not appointed, there will be a chaos, there will be a mistake, whatever. No, that's what I'm saying, that should I be allowed to finish what I set out to do? Because I'm doing a sterling job. But if I'm not doing that, I'm not doing anything right, then we'll have a point to say, no, this man should be kicked out and someone else must take over.
No, thank you very much. Let's move to this next one. Do you think that the current LLB degree is fit for purpose?
Current what?
LLB degree, is it fit for purpose?
Well, I have a problem, which I have identified myself. Maybe, I don't know whether, because I did a different LLB. That the present one, if you look at the drafting in courts, it's appalling. Just drafting in courts and the papers is appalling. So I don't know what went wrong, but I see maybe the period or the curriculum, I'm not sure where the problem is, but it's not.
Thank you very much, Judge Madondo.
Follow-up, DCJ?
Thank you, DCJ.
Follow-up, DCJ? Oh,
I don't have a follow-up.
thank you very much. Good morning, Judge.
Good morning, Commissioner, though I don't see
Marumo Akai.
Marumo.
Akai.
Achai. Which one is surname here? Is Achai?
It is one word.
Oh,
Yes.
okay, they're both.
No, not both. It's one word.
One way.
Yes. These are
Marumo Achai.
This is not a separate, it's one word, Marumo Akai.
Okay. Yes, Commissioner.
I just want to pick up on the question of the LLB curriculum. Because I think the debate sometimes get lost in translation. You have the 4-year LLB program where you have substantive courses and you have procedural courses and you have the timeline within which to teach and prepare students. And post-LLB, you have an internship program. You have articles on the sidebar, and you have pupillage on the within bar. Now, what I want to ask you in relation to your observation in terms of the critique of the LLB, what is the role of articles and what is the role of pupillage? Are people being taught the practical or introduced to the practical nuances that are necessary for them to practice during that period? Or are we solely going to look at the LLB within the university and then disregard that which has to be done in the 2 years of articles or the 1 year of pupillage?
Commissioner Marumo Achai, I would say, I'll put two things. I did the privilege for 6 months after doing LLB for 5 years. And these people, they do LLB for 4 years. I think now they do privilege for 1 year. But if we don't have a solid foundation, when you come to do privilege, they concentrate on how are you going to do in court. But there's something missing somewhere, though I'm not a teacher to know exactly where the problem lies. But if I compare the two, The one with the shorter period of privilege and one a longer period, but the one is more quality, the first one. Then that draws me to the conclusion that the problem must be in the degree itself. Because how the people with a shorter period had to be people of equality. That shows there's something wrong somewhere. But during matric, during the university period, is not with how they are trained. Though I don't know how they are trained, but because since it's a long time since I've been trained. But I feel one should look both ways, try to diagnose what is happening there in the degree, and also what type of training is being offered to them after completion of that degree. Then we may come up with a solution.
Thank you very much. Thank you, DCJ.
Thank you, TCJ. Morning, Deputy Judge President Matondo.
Morning, Commissioner.
I must say I was part of the interviews of 2016 when you were recommended to be the DJP and the previous one, so I was not going to ask questions, but I was tempted when you were responding about the comments about the legal bodies. As somebody that has been on the side interviewing, representing the division, so for me not to have wrong conclusions and assumptions, what value must we attach to comments that we're getting from legal bodies as the Judicial Service Commission?
Thank you, Commissioner. I think there should be a great value should be attached, because they are the people who are in contact with us on a daily basis. Not only because we are here before the Commission. They're in contact with us throughout. They know what is happening at all times. They appear before us. They see how we behave, what we do, how are we performing our work or work ethics, and so on. So if they comment in the way they comment, they just convey what they see on daily basis. So if the Commissioner cannot pay any or attach any value to that, it will mean that in any way there is no need for commenting by people who are knowledgeable about how are we performing our duties and what our behaviors are.
My second question is in relation to the example you have made about an experienced driver and the one that might be having a 3 months license. In South Africa, it's legal to have the one with a license, and the other one might be having a learners in the same car, and it's legal to drive. Are you going to be able to be that experienced driver if this commission can decide, recommend either Judge Stein or Judge Boyodlwati as an experienced driver so that you can lead them through in terms of your vision that you have explained to us?
Thank you, Commissioner. Well, that falls within the parameters of the Commission if it deems that appropriate and in the best interest of the division. But for a person to have a license does not mean that that person is experienced enough. And for me to be placed in the position which the Commissioner says I should be it would be just like cutting my legs and you say I must run as much as I could. Because now I would not be in a position to give them any instruction whatsoever. That's what I'm saying. So in that way, it will rest with them whether they take my point or not. Or maybe they see it, if I say this is wrong, they may say, no, this man says grapes are sour, or because grapes are sour, it's not really wrong what we are doing. So that it makes it in a position where I could not even myself be able to transfer what I have to transfer to them, or what I have to do as you suggest, because there will be those hindrances, whether they can take whatever I say or they cannot take. So that's a problem. That's why we say, let me finish, and then they take over in a proper fashion. Why should they jump the gun now? Because anyway, I'll leave, and at that time they'll be well prepared. Because now, even though they have abilities, as you want me to comment on them, but that still need to be nurtured. That's why I want to be satisfied that, okay, if we leave this thing, we leave it in the able hands. Because if that driver gets into an accident, and you are fine there sitting as an experienced driver, a person coming to that car after the accident, what will think of you? That's the problem. It's not that I'm against them being appointed, whatever. I'm busy preparing them for appointment. So it would be something else if I'm doing nothing, I'm not helping them anyway. I'm helping them with a vision. Why should they snatch it from my hand because I have to give them freely? Why do they have to snatch it? Huh? I'm giving them freely and voluntarily so.
My last question, Acting JP Madondo. When Judge Mugadi was talking about what is happening in KZN, I got a little bit worried about my little understanding of the judiciary in our country. So I thought maybe you'll assist me to have a better understanding of the judiciary with specific reference to what's happening in KZN, because here on Monday, probably you might have seen it's in the public domain now. We recommended a judge in Limpopo to take over to be the JP, even though the difference is that the DJP was not interviewed on that day. So when he was explaining that, no, if you're a JP, it's like it's automatic, and or there's an arrangement judiciary that if you are the second in charge, then the process might be failed by this body. So your comment on that?
Though maybe I'm not clear. Maybe the commissioner says that it should be automatic, or...
No, when Judge Mugadi was putting to you that in KZN, if you are a DJP, you are expected to be the JP. It has been a norm. And then I was just asking myself about what we have done this week with Limpopo, where we had to have somebody who was not even a DJP to take over whilst there is a DJP in that very same division, but the same judiciary in South Africa. So that is why I'm posing it to you, so that you can assist my little confusion about it.
Well, I would say the judiciary, in fact, is not like politics, where somebody will come up and say, I'm leading now. the ethics, there are also a number of things which should be taken into account. I would not say that you may not put that person in that position. I don't know under what circumstances the person was put in the position. But in the best interest of that division, we have to look at the consequences. You may not know the consequences now, but the person will put the person maybe in a boiling seat. It's got a lot of problems, and people said, no, you can solve this problem yourself because you are the one who have to solve them. By saying that the person who's a deputy judge president should succeed, it doesn't mean that that should automatically follow. That person should be interviewed and be established that he's a proper and fit person to succeed. But this is just an understanding amongst the colleagues. It's not that is a law or is a rule or principle, but it's just a tradition of that division. It may happen otherwise, but that's what the people expect. It's not everything happens as the people expect. It can happen otherwise, and it will take a time to adjust, for them to adjust to the new situation with repercussions or serious consequences. So why should we scupper the boat where there's no need to do that? Whereas we can do it freely and so on. Unless if the person who's ahead is not fit, then there's a reason now to take and put somebody else. As you say, someone was ill or could not attend whatsoever. Appointment maybe should have been done. It's done in that fashion. But under normal circumstances, we should find out how these people live, how they operate, so that you must not cause a dysfunction or cause a problem or ruction amongst them where there's no need to do so.
No. Thanks, Acting Judge President. One thing for sure, we'll do what is in the best interest of the division. Thank you.
Thank you.
Thank you, TCJ.
Okay, thank you, Deputy Chief Justice, and good morning, Acting JP Madondo.
Good morning, Commissioner.
As a practitioner and a woman practitioner, I really appreciate you as a transformation agent. We have seen it, and we really appreciate you. I don't want you to misunderstand that the profession does not appreciate all the gains that we have made. But having said that, I'm looking at, would it not be possible to show your true leadership when a woman ascends the position whilst you are still there? For me, it actually says you are really a true leader. And guide her. I understand that you are worried that they will not maybe listen to you, but in our culture and in our profession, seniority means a lot, and we respect the advices that we get from our seniors. Don't you think it will be really to the best interest and a constitutional imperative that you let them ascend whilst you are still there, and by the time you leave, then the waters will be settled?
Yes, Commissioner, even though I'm really puzzled as to what is the need to do this now, because this is going to happen. It's a definite thing. If you want to get a person is cooking food in order to serve you, and want to take it still in the pot, whereas it's preparing dishes to dish. So what's the need of that? Well, but if the commission sees it in that fashion, well, I cannot say anything, but in my view, I've stated them that, look, as much as I need these people to take over, but let's prepare them. Let's give them credibility and acceptance. Let's not push them in because there's a shortage of women at this stage, there's what. They must be fit, they must be proud in their position. That's what I'm trying to do. If that is not the appropriate way, I'll leave that in the hands of the commission.
Okay, thank you. The second question is the one in the last interview you indicated that the slow pace of the court online system because of connectivity problems is actually making your division quite difficult to be fast track court online processes. How far are you with it?
Commissioner, we have a serious problem. As you know, there's a load shedding every time. That Wi-Fi system we have, it has even deteriorated now, its effectiveness. And when we talk about attending to these things, we talk about the budget. There are budget cuts at the moment, this and that, but we are trying to solve that problem. That's the only way we can improve our operational efficiency. So it's the center of my heart and the heart of other members of the division. We are working on it, but the problem we're having in my moment, load shedding, lack of funds, as it is happening there, the public works undertook to install a generator in the case of a load shedding will take over, and also do some repairs. At the last meeting, when I asked them when are they going to do this, because they've been promising, but that promise have never been fulfilled. And they said, no, we don't have funds. And then what will happen? The justice said, no, let's try something else until we get funds to address it. Though I may wish to do things as speedily as possible, but the hindrances at times is the budget and the people who should implement this.
Okay, thank you. Thank you, Deputy Chief Justice.
Thank you very much,
Sorry,
DCJ.
Commissioner Lokis.
No, somebody. I don't know who was talking. Oh.
You want to ask questions?
Oh, I thought,
It's your turn. Do you want to forgo it?
no, I'm asking questions. Thank you.
Oh, okay.
Okay. Morning, thank you, DCJ. Good morning, Judge Matondo.
Good morning, Commissioner Nochesi.
Yeah, look, must first state up front that Judge Matondo, you are one of those JPs or leaders in the judiciary that we look up to, that really, personally, I would give every support I could possibly to give, and I hold you in high respect. But today I have difficulties. First, you debate with Judge Mgandi here that Judge Boyo is number 19 in the list of your judges, that is in terms of seniority, and Judge Steyn is somewhere in the middle. Where is Judge Mgandi in that list? Where is he ranking in terms of the seniority?
It's below Boyo.
It's not number 3, it's not number 4, it's not number 5, it's not number 19, it's not number 20, it's maybe it's at number 27 or 29. Why that should be an issue here?
Yeah, it cannot be 27, but it's before that. And the question is,
The question is, in an important occasion of selecting judge president of the division, you jump all the judges there and ask for the division to be represented by a junior judge from your division. Why do you make the issue of seniority a key issue that we must consider here when you talk about other judges who have availed themselves in respect of position, when yourself, you have always overlooked the issue of seniority, even here today?
no, maybe Commissioner Lodges, you are mistaken.
Yes.
I've not been arguing about seniority. I stated clearly that I'm affording everybody an opportunity. If a person is a judge, that can be given a task to perform.
Yes.
I didn't say that Boyo should not be appointed because he's junior. I didn't say that.
Yeah, but the debate was, that's why I don't follow. You say she's number, you debate this issue with Judge McCarthy, that she is number 19, and whilst the other judge is just somewhere in the middle. When here in these proceedings, you jumped all the other judges for the representation of the division to this interview. So I find that troubling to me. But let's move on.
Okay, let me clarify, because there's something wrong there. It's not me who said it's number 19. It's Mgadi who said so.
Okay.
And if that is the position, I appointed her an acting GJP ahead of people who are seniors. If I have that mind, I've not done that. So that did not come from me.
Yes.
Yes.
Let's move to the next question. As far as I understand, when this post of the judge president is put out on advert, essentially it means somebody even from the Western Cape, from anywhere in the country, could have applied to be the judge president of the KwaZulu-Natal division. Do you agree with me on that?
Well, they could have applied, but the people who are managing that process is the JSC.
Yes. Now, if anybody could have applied for the position, such people it would be expected that they could be appointed. So this notion of the deputy succeeding the president, it just does not arise. It just has no basis. But if a person is a deputy in a division, it simply puts him in a good position in terms of understanding that division. But if another candidate comes and impresses the JSC must be free to appoint that person, to recommend such a person.
Yes, but must have considerations of that. Because if you come to a new environment, let's say a person from outside the division coming to head the division, well, it's a problematic thing on itself. But if there's a reason for so doing, you can do it, but there must be a valid reason. And that will be in the best interest of the division. Because if it's not in the best interest of the division, it may create a problem, because you appoint a person, you end there, you don't know what is happening, where the person is working, and what problems the person is encountering. Maybe in order to prevent that happening, that's why we say the person knows how to do these things. Not necessarily that it should be appointed. I indicated earlier on that it's not automatic that because we are a DJP, then we should be appointed an acting a JP, no.
Yeah.
But
And
this is what is expected. But if there are circumstances demanding that should not be followed, then That's where the position, that is where somebody from somewhere else can come and take over if the need arises.
Yeah. And also, like this theory of the deputy taking over, which is seemingly in KZN, you seem to elevate it to some form of principle. Where is it based? Where is it based? Is it not that the JSC is guided in the appointment of judicial officers, including the leaders of the judiciary, by the Constitution? Is it not that the starting point for the JSC is to consider the Constitution, the provisions of the Constitution, particularly Section 174? That section must guide the JSC and then move on to the criteria that it has developed to determine whether the candidate that is recommended for appointment for such an appointment is an appropriate candidate in these circumstances. Is it not that the position that the JSC should be guided?
Yeah, but let me put this thing clear to you. In the first place, I didn't say it's a principle. It's what is expected from the previous JPs and DJPs, what happened. Yes.
Yeah,
But
yeah.
that does not mean, as I said, this is not automatic. That does not mean that if the JSC sees otherwise, that cannot be done.
I'm asking you this question because in your discussion with the Deputy Chief Justice, she pointed out to you, for instance, that in the country, because the JSC, this is a national institution, unfortunately, it's not a provincial body, it's a national institution that performs constitutional function. She demonstrated to you that in the country, out of 9 provinces, there's not even a single judge president who's a woman, for instance. Let's make another example. There's none at present. Is it not that a matter which should be a concern to the JSC in view of what the public expect of this body and what the Constitution instructs this body to perform its functions? Is it not that an issue that as a starting point must be considered?
Yeah, that could be an issue, but depending on the circumstances. The circumstances is where there's a preparation to achieve that purpose, to disrupt that preparation and interrupt the preparation because we want to be seen to have done something. I don't think in my submission that will be correct. But in the situation where there's nothing happening and there's nothing even going to happen in the near future, well, you'll have a point on that one.
Now, let me put it this way. We have a situation in the country where we don't have any woman who is appointed as a judge president to that leadership position. There is a vacancy that is created. You have a candidate who's about to retire. I know you don't want that, but the fact of the matter, you have a candidate who's about to retire. You have women who are availing themselves to the position. Should the JSC took into account of all those factors in deciding on this position, would you encourage the JSC to take into account of those factors, those facts, in fact?
Well, I would encourage the JSC to do so, but it must not automatically flow from the agenda.
Yes, I agree.
They must satisfy some other requirements for a person to be appointed in a particular position.
Yeah.
But if it's purely for the agenda, I would not support that anyway.
Lastly, with your leave, The point I want to make here is this. In April, when you interview on the 8th of April, it seems as if, in fact, you were the only candidate at that stage. And it seems that we downplay the fact that at that stage, there was an objection raised against you, your candidature, based on the remarks of that, based on what was in that book, the perception that were created, let me say, perceptions that were created by what appears from the book. Those were not our perceptions. Those were perceptions from the public. Hence, there was the objection from the public, and the JSC took into account of those factors. Combined with that now, if you count from April to now, that is it's about a few months. At this stage, somebody, that is Natal and other institutions, say, take into account that this candidate is almost at a retirement stage. That's the second point. We haven't finalized even this first one. You have put up you have tried to clarify, but we don't know how that controversy, whether that controversy has been resolved. That you must take into account. Second, I want you to comment. Second comment I would like you to. This attempt to regionalize appointments of judicial officers, regionalize judicial officers, and try to create some best rights in relation to this position. Is it not dangerous on its own to the stability of the judiciary? And lastly, so that to deal with those questions, my last point. Lastly, I was worried when you put as a proposition that if you are not appointed, there may be factionalized division there. There will be supporters of whoever who is appointed and supporters of another candidate. Is it not your responsibility as a senior in that division to ensure that there are no such factions by simply supporting whoever is appointed to the position? I'm putting those for you to comment. Thank you.
Okay, will remind me, because some of them, I've lost them somewhere. Firstly, I have to state that there was no objection. I'm aware of there was no objection even at that time. What was given to me about 2 to 3 days before the interview, that they want to put some questions. I've never seen any objection. That's the first thing. And the second thing, you talk about that I'm about to retire. Well, I have indicated earlier on that there are judges who were about to retire, but they were allowed to complete what they were doing. So that should not also apply selectively. And that if I'm not appointed, there will be some group of people. I didn't say that. I said at the time when the former JPRP applied, that's what I visualized will happen. I didn't say that if I'm not appointed, there will be that thing. I was asking me about the sense. That's why I did not contest with him for that reason. That was my own reasons for that period. That does not mean that these other people, if they want to apply, they should not. They should be forbidden to do so. That's not what I was saying. I was saying at the time that was my consideration. And as a result, I decided not to contest.
Thank you, DCJ. DCJ, I think I'm covered in most of my questions here, but I've got only one. I think it's a follow-up. Good morning, AJP Madondo.
Good morning, Commissioner.
AJP, during your BLA time, we knew you as an activist of transformation of judiciary. But I'm worried the way you responded to your questions that were posed to you regarding the ascending of a woman in the position that you are interviewing for today, where you indicated that you are still preparing them, they are not ready. Does that mean, forgive me if I heard you wrong or I'm analyzing it wrong, does it mean that you are saying women will only be ready to ascend to that position after you have been appointed as a JP and you have retired?
No, I'm not saying that. I'm really not saying that. But what I was asking in that context, I was saying in that context that what I'm presently doing. But if the JC sees otherwise, I'm not against that, because even my record, as you say, shows that I'm the activist to get the people where they belong. I'm not against that. So what I'm saying that maybe at the moment, would it not be fair and just to allow me to accomplish what I've set out to do, because I will accomplish it not in a long time. That's what I was saying. But if the JC sees that fair and just to appoint somebody else, well, I didn't say that they should not be appointed. I was just explaining.
Thank you, AJP. Thank you, DCJ.
Thank you, DCJ Sanbonan, acting Judge President or Deputy Judge President Madondo.
Yes, Mr. Good morning.
Yebo. Mine is on the question related to the fiscus that the DCJ asked you earlier on, that if you are appointed and you agree that you will retire in November 2023, it means that you will have served a very short period and you will retire at a higher salary. Shouldn't that be a consideration for this commission, that you will have served for a very short period of time and then you retire at a higher salary?
Minister.
I'm raising this, that it does have an impact on the fiscus.
My answer would be that it may have that, but there are other people who have been appointed having a short period, and the difference between the JP and DJP in salary is not that much.
Yeah, I agree with you that there are others that have been appointed, and the fiscus since that period and now has since deteriorated, and you will be aware because of the current economic situation and the issues of your remunerations that the commission was also not able to recommend what will have been desired.
I don't know whether my answer now.
Yes, I'm just trying to say that the situation is not the same that it will have happened now. is deteriorating the fiscal situation of our country, and it's in the public domain.
That will be the first thing to happen in that fashion, to consider that if this person is going to ascend to this position, will retire the higher salary, because it has not been done before. That will mean that it's applying selectively. Well, with me, it's not a question of getting a higher salary, but is to see things happening. And when I exit as well, I must be sure that what we have started is in the able hands. I will be happy even where I will be, but I'll still have some time to do things. I may not be in a position to say it is right to cut me off because of fiscal considerations this time, in the light of what I've said. If nothing has happened, because even some of the things has happened even during this time, during this year. During this year, the appointment has been made this year, not any other year this year, or where we are talking about fiscals this year. So that consideration was not taken into account. So I will have a problem why it should happen to me. Because if the new president starts, then everybody should know beforehand that this is now the position. Not when I come here, then said, no, okay, we are not going to take you because of fiscal problems. So
Yeah, no, I do take your point, Deputy Judge President, that you are not doing it to retire at a higher salary, and I'm not insinuating that. I agree with you. I don't think you are doing it for that purpose. I was just relating to the fiscus side, and I take that point. My last question relates to what also other commissioners have canvassed on this issue, that you are preparing this to enable the commission to appoint someone who you believe at the time will be ready. And that time will be in a year's time. I'm struggling to grapple what will have changed. I mean, it's just a year. Why can't we do it now? The same way you are saying it, that why do we snatch it while you are doing it anyway? On the flip side of it is that why can't we do it now if you believe that there could be someone who is fit, proper, capable, and ready to do it?
Minister, I think I have stated what we want to achieve for the benefit of the division, to have a smooth and seamless transition and continuity of leadership. But if the commission wants to do it now, taking out the food before time, well, I will not stop it from doing that, but I was indicating what in my submission will be fit and proper or fair and just.
Thank you. Ngiyabonga.
Uyabonga nami.
Yeah.
Commissioner Clark?
Thank you very much, DCJ, Deputy Chief Justice. Yes, I was correct. And good morning, DJP Madondo.
Good morning, Nongosi.
Thanks. I've known Justice Madondo for many years, and we have served together in the legislature of KwaZulu Natal at some point. DJP, I came across an article you penned in one of the journals, law journals, and it's tackled the role of the legal sector in developing a legally conscious society. You have actually listed it as one of your publications attached to the questionnaire. In that article, you say that women and girls have less social power and influence or control over resources and participation in public life as a result of socially determined gender roles and structural inequality between men and women. And you conclude by saying that the communities should be educated and trained on the law relating to women's equal participation in all aspects of life. And when did you write this article, DJP?
It was in 2019.
2019.
I'm sorry, 2019.
2019, thank you. Do you think that our education system, let me include the legal system, is resolving this intractable question?
The education generally.
Yes.
Okay. Well, though I'm not that much conversant with what they're offering at schools, but that should be addressed. And progressively until it is achieved, if it is not addressed right now. Well, legally, it is being addressed. It may not be quick as it should be, but there are a number of legislative measures put in place to address these problems since the inception of the constitutional democracy. Though we still have the post-constitutional challenges and so on, which we should address. Well, I'm dealing with that in other article, not in that one, which we should address. And to address those things, we need the cooperation between the women and men, because there's a danger also to single out a certain group in a way which will create problems. But if you put those people together and help them to find a solution to the problems and how to develop this and how to achieve that, how to do that, that to me, it makes sense and indicates that, in fact, you'll come to something concrete which will be durable and to the optimum benefit of those people.
Thank you, Judge. And I must confess that since I've known the judge, DCJ, I've not found him to be homophobic. And I said I've worked with him, and I've also gone through a number of his judgments, and that I have not picked up. And but my last question to the judge, DCJ, is you say in your CV that your father passed away when you were 14 years of age, and that you had to seek peace jobs to fund your education and provide for the needs of your family. You worked as a farm worker and a construction laborer, etc. Now, the question, how has this life experience, prepared you to be the person that you have become, Judge Madondo, that we have come to know? That you have come to know? Over to you.
Thank you, Commissioner Klaba. For correction, my father passed away whilst I was 7 years old. When I went out to market in the ordinary language, it was at the age of 14, around about 1967. And my mother was uneducated and unemployed. So I have to do something. And my grandmother, who kept me at school with old age pension at the time, they were earning R4 bi-monthly. So if I say bi-monthly, it means after 2 months they were earning R4, and she passed away. And I was forced to do something to earn a living. That's where I came to practical realities of life when I came to the farms, where I was earning 10 cents per day, and I found old men who were earning just peanuts. And I realized that if I will not be educated, that will mean that I will be in this situation for the rest of my life. So I committed myself that even though I didn't have money, but because God gave me mind and the brain, I can make it. That which propelled me, and also to help my mother, who despite her condition or position, she stood by me. She helped me with everything I wanted to have, even though she did not have anything. That's why I have a soft spot in developing women. And so much so, when I got married, I deemed it appropriate that my wife should go and get something so to able to support my children if I happen to die, and to give her independence as a human being, that she must also be independent, not that because she's married to me, she can't do anything. So I was the first person to do that in the area. Some people will say, I lacked money because I allowed my wife to go and study. But afterwards, they started also sending their wives. I didn't know whether they were not lacking money at the time or what their position was. So, to me, as I grow up, I have a number of experiences. Even in our area, we have faction fights, we have this and that. In our area, in Msinga, there were faction fights every time throughout the year. So, through the mercy of God, I'm still alive. So, whatever I gained, I want to transfer to the coming generation. So, to benefit out of my experience. And the commission here, nobody can say what I'm doing is not laudable. There's nobody. Even what you say about the homophobic thing, there's nobody who has lodged any complaint or allegation that I've done anything of that sort all these years as I'm here now before you. There's nobody. So that should be crucified for something who has got no accusers, no evidence, nothing whatsoever, and I've done everything possible to show that this is not what I'm capable of. I don't know whether I'm answering your question or I've gone astray.
No, you have done, you have DJP, and I want to end, it's not a question, but I want to end by saying that with all the achievements, Judge Matondo never saw the need to leave his people in Umsinga. Umsinga is one of the deepest rural areas of KwaZulu-Natal. And you're still with them. For that, you remain a model to many people, especially those that have, just like yourselves, pull themselves up by the boots, by their bootstraps. Thank you so much.
Thank you. I don't know, maybe I answered that. Well, I've helped a number of people, more particularly orphans, females. In one instance, my neighbors passed away, the father and the mother. I had to take over and look after that girl. Now she has got a PA owner, she's employed, and a number of others I'm helping out of my own coffers, because I know the problem or the plight in which they are. So if nobody stretches a hand to help them, there will be nowhere. And even in the professional judicial functions, everybody says what I'm doing is beyond reproach. So why should I be crucified?
Thank you so much, DCJ.
Thank you, Commissioner. Commissioners, I really need to make a plea with you. We made an agreement on how to ask questions and how many questions those should be. We've been sitting until very late every day, and we keep candidates waiting. We still have 6 people waiting to be interviewed, and the way things are going, I think we're headed for another late night, and we can't afford to keep candidates waiting indefinitely. So please, let's just stick to the agreement we made. It's not my...
DCJ?
Yes, is that Commissioner Malema?
Yes, I wanted to say we are now waiting for the 3 hours interviewing the same candidate.
Sorry?
We are almost going for 3 hours interviewing the same candidate.
Yes. All right. I hope the message is filtered through. Commissioner Moimang?
Thank you, Deputy Chief Justice. Good morning, Acting JP.
Good morning, Commissioner Mola.
Just one question from my side. Part of what you reported in your acting stint since January, you reflect the guidelines that you have drafted on the acting judges. What are the defining features of this policy on the appointment of acting judges? Because you have not done like you have done with other progress areas that you have recorded. Thank you.
Well, identifying features and how are they found, there are bodies, legal bodies, who can recommend, they put a list and recommend certain people for consideration. They submit to us. There's also a committee working on that. And then there's the first thing, it depends from which talent a candidate comes from. And secondly, you look at the experience, at least must have 12 years experience, more particularly in whatever that person does, must experience also even if they little experience, litigation experience, that person should be given an opportunity to act under guidance and supervision. And the question of gender representativity also taken into account, and the racial issue also, that there must be a balance, or there must be a representation all people in this country in terms of the constitution, demographics of the country. So, I don't know, but mainly those things, and if a person meets those requirements, recommended, or at times also that the head of court is a prerogative also to support somebody, or the members of the bench, they can recommend somebody for acting appointment. And then if that person satisfies those requirements according to guidelines and procedure, is given an opportunity, but must be supervised and working with senior or experienced judges, so to be able to know what is happening or expected of him or her.
Thank you, Acting JP. Thank you, Deputy Chief Justice.
Thank you, DCJ. Good morning, AJP.
Good morning, Commissioner.
Yes, I have two questions. The first one, you were appointed, as I understand it, in 2016 to the position of Deputy Judge President. And you were not the most senior candidate at that time that, in terms of seniority, would naturally be selected for Deputy Judge President, as I understand it. And yet there hasn't been a suggestion, at least in this session, that your appointment at that time created disruption because of your lack of seniority, because you were appointed ahead of people that were more senior. So I assume, for purposes of our session today, or your consideration, that there was no disruptions that happened. It was accepted, or whatever disruptions happened, they were managed eventually. Now, from that premise, I am concerned, I got concerned and deeply uncomfortable when you did not contradict Judge Mngadi when he put to you, and how he expresses it is that he talks about the impact of seniority in command and respect, that if someone who is junior to you is appointed JP today before your retirement, that would cause destabilization. They will not be respected. Now, what it presents for me is, well, either things have changed so much since you've been appointed that now we have to be concerned that an appointment of someone junior to you to Judge President will lead to instability. And if that is a valid proposition that was put to you, which you didn't contradict, it seems to me that then it's fair to say this is a reflection, there must be a reflection on your leadership there. If you don't contradict him, and what I had hoped for, AJP, when that was put to you, was you would say, no, you don't, nobody should have any concerns about this. I have a succession plan in place. I have led and managed the division in a way that if I should drop dead tomorrow, there will be a seamless transition. If somebody is appointed ahead of me, there will be a seamless transition. That's how the culture I have created in that division for life to continue beyond me. What do you comment to that? And what I'm asking you to comment about specifically, AJP, is, isn't this a bad reflection on your leadership if what Judge Mngadi says is correct?
Well, that will be contradicted by what is happening. Because I have appointed, I have signed in the first, I have recommended junior judges for acting appointment at the SCA. That's the first thing I did. The second thing, I have appointed a junior judge to be an acting DJP. If I have that in mind, I wouldn't have done that. Maybe it missed me when Mngadi was saying that, because it was too long. So I'm not, I'm not along those lines, and that is also confirmed by the practical events I have done in my leadership, which nobody had done before.
Yes.
So-
Sorry, I beg your pardon, sir, I thought you finished.
So then it could not be correct to attribute that to me. Because if you attribute that to me, look at what I've done since then.
All right, so can the JSC proceed on the basis that if someone else, if of the two candidates, if they were appointed ahead of you, you would ensure that they seamlessly receive the support of the division, and that there is, at least you do your part to ensure that there is no instability as a result?
Well, I really don't want an instability, even before I could appoint a DJP at one stage, and when I was interviewed for DJP, the judge Yapi, the JP Yapi even said that I created cordiality amongst all the judges. They all agree. So even some people had problems at the time, I could help them resolve those problems. If they will be open that I can assist them, I can do that. I have no problem when I've done it, and I'm doing it, and I'm going to do it when I'm still alive, provided I'm accepted to do so.
Thank you. The second one, DCJ, with your permission, is there's a concern, obviously, you've picked up about continuity because you have only the remaining part, almost a year, 11 or 13 months that you have to before you retire. So that is a concern that has been expressed with you, and it's a concern that I raise. But before I put to you what I would like to hear from you, maybe let me start off by putting what I would like to believe are truths that we must accept. The first truth is that the position that you are being considered for, it's a vacant position, and it's a false narrative to say it's to take the pot or the food out of the pot before it is ready. The position is vacant. You are acting. There should not be an expectation that you will be appointed to the position. So the position is vacant. For me, that's the first truth. The second truth that I think we must accept is, well, age is not a disqualifier. Your age, that's not one of the criteria that the JSC should be looking at. That in itself is not a disqualifier. The question must be, are you able to do the job? And you've indicated you are able to do the job, and so we shouldn't disqualify you for that. Also, that you'll be acting for a short period. You have given examples of people that have been appointed, for short periods. We don't know the facts of their appointment. For my purposes, it's irrelevant why they were appointed for short periods. But that fact alone should not be anything that disqualifies you. Now, for me, it seems to turn on this. And maybe before I say to you, this is what it turns on. I got comforted when you said you have a succession plan that you've worked on since 2016, and you concluded that engagement by saying, well, if I drop dead tomorrow, there is a plan in place. Somebody will take over and run. So there's no vacuum from what you have said. What I haven't heard in this discussion that has been raised by everybody is, what is the compelling reason that we should, notwithstanding the time that you still have left on the bench, notwithstanding that, but also because we are interested in long-term stability of the division, the JSC must be concerned about that, the long-term stability. What is the compelling reason that you should be retained in the position? Or rather, you should be appointed, because as I've said, the position is vacant. And I haven't heard, at least for my purposes, what you say I should consider as a compelling reason why I should or I should consider that he should be appointed to that position. Thank you.
Thank you, Commissioner, even though it's too many. The Commissioner has made a reference to the position being vacant. Well, theoretical is vacant, but in practice is not. I have started being a DJP in 2016. I have acted in the JP position for about 2 years now, adding some other times I acted. So this is a continuous management position. The fact that maybe I may retire in a certain period does not mean that everything, or maybe that at this now there's no full JP. That doesn't mean that what should be done by the JP is not being done. I'll not be starting afresh. I have things I'm busy doing, which I had hoped that I'll see their fruition. And taking into account what I've done for the judiciary, whether it will encourage other people to dedicate themselves and be committed, as I did, if things turn around in the way you suggest. I'm not sure what will happen to that, but it's just a painful exercise where you drive something, when it is about to get home, you have your neck cut off. That is a painful exercise. I must not be heard as saying or interpreted as saying, if the JSA finds some candidates suitable for appointment, it should not appoint them. I'm not saying that. I really don't say that. But what I'm saying is that all what I've done, and there's evidence that I have enough experience, expertise, this and that, which all the legal bodies agree. Why should I not be allowed to transfer this thing to the next crop of leadership, or allow me to prepare for the last time now a fertile ground that these people should continue in the way they want to continue. So I should not be hurt as if I'm removed or if I'm jumped over, the sky will fall. No, I'm not saying that. But I'm putting that in the honest way, in the light of my commitment and dedication, that to me, it would not be a right thing to do, unless the Commission finds a more compelling reason for doing that, not just to do it for the sake of doing it. And then the last one, you say...
Before you move on, DJP, what I don't understand, what do you mean the position is vacant only in theory? I don't understand that. If that is the case, what are we doing here then?
No, it's vacant because there's nobody who's fully appointed in it.
Yes.
But I'm acting in the position. What is supposed to be happening is happening. That's what I'm saying. But what is looked for is somebody who will be anointed or appointed that now we are full JP. But that doesn't mean that all the duties of the JP are ceased. That's what I'm saying. They're not ceased. When you consider that in my state, because some people think that I will start working after, if I'm appointed, that will be the first time for me to start working. No, I've been doing it all along, and I'm doing it. Even if there's no full JP, I'm doing it.
All right.
Yes.
Okay, sorry, I interposed. Carry on.
So I know I wanted to find out what I didn't The other question the commissioner put to me.
No, you have answered my questions, AJP, thank you.
Okay, thank you.
Thank you, DCJ.
Thank you, Commissioner Bedoy. President Pete.
Thank you, Deputy Chief Justice. Good day, Acting Judge President Matondo.
Yeah, good day, Acting President, Commissioner.
Whatever beliefs, disbeliefs, inclinations, predispositions that judges might have, they are expected to have the capacity to put their personal convictions aside and decide cases on the basis of evidence and argument presented to them. And in the light of what transpired in April this year, I want to know from you whether you have got or you possess that capacity to a sufficient degree to reassure the nation that you would decide cases on the basis of the evidence before you. And due to time constraints, I would be satisfied with either yes or no. Thank you.
Now, if I say yes, because the question is just in two ways. I would say I'm satisfied that I can discharge my functions fairly and impartially as I've been doing. And since now there's no complaint that I do something opposite to what I'm supposed to have done. So there's absolutely nothing. So to answer a question like that, that may create an impression that maybe there was an allegation, there was a complaint. No, there was nothing like that. It was a matter of an interpretation of what I was saying, which I've corrected because I saw there's some way it lacks some clarity. If I happen to do that, what can prevent me from doing what acting president says? Because if I fail to do so, then that will be clear that this man is up to something, is not the right person. But I did that, and I'm still prepared even to do it. Even the legal bodies, they say, why my performance and what that is beyond reproach. All of them, even those who have an opposite view, how would they say that if they see that I'm not a fit and proper person, or I'm doing something which I'm not supposed to do, or anything change in me? No.
Thank you, Acting Judge President. I'm satisfied. Thank you, Deputy Chief Justice.
Commissioner Marumakhai.
Thank you very much, DCJ. Good afternoon again, Deputy
Good afternoon,
Judge President.
Commissioner.
Initially, I wanted to speak to you about a case that really has troubled me ever since it was handed down, the CASAC versus the Ngonyama Trust. But earlier on, there is an issue that came up that reminded me of one of your judgments that I read some time back, and I was fortunately able to get it. And I want us to deal with it because it goes at the heart of the debate about the LLB and all those things, and I'll give you context. This is a case where, and unfortunately, it has been listed in your documents at page 74. It's case number 44 in your documents. M3 carrier CC versus Ramo Tar. I'm not sure if you remember that case. It was a motor collusion case.
Well, I cannot remember by
Let me just give you
heart.
briefly the facts. It was a motor collision case where the two trucks collided. I think it was in Durban. And of course, you dealt with the facts, and ultimately you reached a decision that one party was, actually they were both negligent, but one party was 70% negligent, and the other party was 30% negligent. I'm not sure if you remember that case.
I don't remember. I've written so many cases.
All right. No, it's fine. But let me just put a certain proposition to you, and I just want to understand. And in the context of it's fine. We ought not to get into the case itself.
Okay.
One of the issues that concerns me is this judgment. It is based on the facts. It is decided on the facts, and the conclusion is on the facts. On the case, there is no law that you seem to be applying. There are no cases that you seem to be relying on. But somehow you get to a decision that one party is 70% negligent, the other party is 30% negligent. And I was just concerned as to how you were able to achieve that kind of apportionment of liability under those circumstances. Because I also did some research in the very same case, and I saw that there are a lot of cases that really set out the test for negligence in relation to motor accident collusion cases. But most importantly, the test for the doctrine of sudden emergency in relation to these cases. Now, the problem that I have to put to you is, sometimes we receive these kinds of judgments from the courts where the outcome cannot really be justified when one looks at the reasoning that has been adopted. And it creates a challenge in relation to teaching students. Because I always say that judgments are a teaching tool, are not only for the parties. I just want to understand, is it correct for judges to decide, and I'm just speaking generally now, is it correct for judges to decide cases and not rely on authority and just dispose of the matter without giving us a step-by-step process as to how they reached a particular conclusion?
Well, Commissioner, I have a problem because I don't know the circumstances. There are many circumstances in court to find that everything is common cause. It's not that all the time you have to make references to a certain law. So there are various ways in which the cases are dealt with. Because in any event, if the parties are not happy with that, they have a way to appeal against that decision. So in the moment, I'm not really in a position to say what really happened in that case as it's coming now. I don't even know when the case was heard. So that put me in an awkward position.
No, it's fine. I accept it. Was delivered a long time ago in 2011, but it was very interesting.
So I would not be in I would say something wrong, and you say, hey, we have said this and that. It was not that, because I will be guessing. And
okay, no, it's fine. I will leave it there. But I think the point that I'm trying to underscore is it is really important for judges to really understand that their judgments are not for the parties, and their judgments are not for the other judges, but they are for the public at large. Most particularly, there is a particular interest group in those judgments, students and lecturers, and we use these judgments as teaching tools. But I will leave it there. Thank you very much, DCJ.
Okay, maybe let me say something. I don't think, are you saying there were no reasons for judgment?
No, there are reasons. It is reasoned, but on the basis of the facts themselves. So the reasoning is not arising from the interpretation of the cases that came before, but most importantly, the quantification or rather the apportionment of liability is not clear as to how you got to 70-30 as opposed to 50-50 or 60-40. So it's not clear as to how you quantified that kind of liability, but I will leave it there.
Well, it's not all the time that we have to refer to the law in that fashion. It depends on the circumstances of each particular case. As I have said, if it's common cause, you silent the facts, and maybe the evidence shows this one is 30 or 70%. Unless those people, they don't agree, then we can go to that extent.
Are there any questions from the virtual platform?
Yes, DCJ.
Yes, Commissioner Singh.
Thank you very much. I've had my hand on for some time, but thank you very much for the opportunity. Good afternoon, Acting Judge President Matondo.
Yes, good afternoon, Commissioner Singh.
I'll be very, very brief because I'd like to ask the other candidates a similar question on the succession plan. Now, it's very good to have a succession plan. I can recall us, and I think probably the Deputy Chief Justice will assist. I'm not sure whether it was the Free State or the SCA where we had other judges within that division fully supporting the candidacy of the applicant at that time. Now, this brings me to the succession plan. Has the succession plan been canvassed with other judges within your division? And has there been a buy-in to the succession plan? Because I would really like to ask this question of the other two applicants that come before us. So that's my first question.
Well, the succession plan is, let me start from this so that we'll have a background to it.
And DJP, may I ask that you try to be as concise as possible? Of course, I don't want you to leave anything, leave out anything you think is important, but just try to keep your answers crisp. We are seriously running out of time.
Thank you, DCJ. I will do so by affording everybody an opportunity to do something or to act or do something. That's where you pick up a person who's capable, and you talk to other senior people and find out how do they rate that person, and then from what their response is, then you get that. That's not merely say that that's the only person to be considered, but when we are looking at the succession, that we have 1, 2, or in the worst scenario, maybe 3 people, depending on the circumstances. It's not that we convene a meeting and say, now we have a succession plan. No.
No, thank you for that. The second question, short question, is I want to test the validity of an observation you made in 2011 when you were a candidate and Judge Chiman Patel was also a candidate at that time. And I remember, and I've seen through the records, that Commissioner Koos van der Merwe at that time asked whether the time was not ripe to appoint, and in inverted commas, an Indian as judge president. And you responded as follows, and I quote, "I don't think so. We still have things to address, imbalances, all kinds of things which need more insight, which a person who is not a black African cannot be privy to," I close quotes. Given that we have a white female that we are going to be interviewing a little later on in the day, would that observation that you made in 2011 still be relevant today in 2022? Thank you.
Well, I would not say it be relevant because it did not carry a day even on that at that time. So it cannot be relevant anyway. If it carried a day, then it would be relevant.
So what you are saying is if the commission decides to appoint a white female as a judge president, there wouldn't be any problem in that? Okay.
Well, that's within the rights of the commission. If the commission deems that fit, then that's okay.
Thank you very much. Thank you, DCJ.
Thank you.
Thank you, Commissioner Singh. Commissioner Bernard, Commissioner Malema, Commissioner Bredenbach, anything from you?
I must get some time to pass.
How about DCJ?
Commissioner Barnard has a question, DCJ.
Yes, go ahead.
Thank you. Good afternoon, Deputy or Acting President. My first question is on leadership. Is as a leader in a court or a society of an organization, or in the family or wherever, have you ever been in a difficult situation where there's serious animosity or differences in those you lead? How does one deal with that? You know, for example, maybe even in a division with judges in your division or legal practitioners, how do you go about it?
Thank you, Commissioner Barnett. Well, it depends on the nature of a dispute. But if a person gives me a side of a dispute, then I want to hear also from the other side and put the two people together and find out where the problems are. Then I'll indicate to them, is this not the problem, and make some proposal if they agree to it and what each wants to see happening. And then find out from the other, if that is the position, how are we going to resolve this thing in an amicable way, but not in a meeting, but maybe the three of us, and point out to those people how this thing is going to disrupt the proper functioning of the institution and so on. And then we, in most instances, we agree and resolve the problem in that way. That's the first step of doing it.
Thank you. The second question then, the judge is often a leader in court. Now, when there's litigation on behalf of a minor and it's run for a number of days, if in mid-trial then the matter of recusal comes up, what factors should the court consider and how should the process unfold before the court makes a decision on recusal?
Well, the question of recusal, because the matters relating to minors are given first priority in any way. So if the judge feels that cannot do that matter because of APC, you have to find another judge who will deal with the matter quickly.
But will the judge hear the parties on that before making such a decision?
Let's say if a judge is of the view that he wants to recuse himself or herself, they find out and indicate to the parties that, well, this is the position, or how do you feel? If they feel, no, you can, it's not automatic, you can recuse yourself, then you do it and you make preparations how to see to it that the matter is done. Or they object, they also lodge an application for the judge's recusal. Then it's dealt with there, and at the end it's realized that no, this judge cannot proceed with the matter. Then the matter is given to somebody else.
Thank you, Judge.
Thank you.
Thank you, Commissioner Bernard. Anyone else, commissioners on the virtual platform? All right. DJP, I have just one final question for you. If one of the other candidates is appointed in this vacancy, will you support her to ensure that the welfare of your division and the people it serves is safeguarded?
Yes.
Thank you. Well, we've reached the end of your interview. Thank you. Thank you very much for availing yourself. And unless there's anything more you want to say to us, you're excused.
TCJ, maybe I thought you'd give me a closing submission.
I just said.
It's very short.
No, I just said, unless there's something else you want to say to us, you are
Okay.
excused. So you still have an opportunity to.
Oh, thank
to
you.
speak.
Maybe I could not hear you properly.
Yes.
Sorry for that. No, I don't have too many things to say, but I would say the following facts or the following things, they stand out in my application, which in my submission ought to weigh in your deliberative process. On the question of my suitability in terms of ability, capability, experience, expertise, and the like, there's nobody says I'm lacking in that, which I could submit it. On that ground alone, I have demonstrated that I'm more capable or I'm more equal to the task that lies ahead of me if I'm appointed. And secondly, as I've mentioned, and some think that maybe I don't want to vacate the position, whatever, is that, in my view, I submit with respect that the smooth and seamless transition, stability and continuity of the court leadership is essential. And the last thing, or the other third thing is that as some commissioners also have been alluded, there's no basis to conclude that I'm somehow homophobic. And lastly, with regard to my age, which seems to be a big issue, I've indicated a number of judges who have been appointed in the position. I will not repeat that. But in the light of my work and my ethics and what I've done, even for those who are less advantaged or experienced, in my submission, I feel that it would be proper and just to say, in fact, it would be fair and just. Let me take out proper. Fair and just to allow me to finish this thing in a way which also I would feel that I've made a contribution and the contribution has been recognized. And I still have to do things. As I've indicated, that since April I've done a lot of things. So the 14 months is a lot of time. I can do a lot. I remember when I was applying for DJP, one commissioner said, I'm old now, I can't do anything. Why do I not give way to the young people? Had that carried the day, I wouldn't have done all these things I've done now. Because I was said to be old, I could not do a thing afterwards. I did a lot. Even now I can do it. Look, I passed the certificate in flying colors more than other people who are younger than me. Then I can still do something in the period I have, which will make me also feeling happy to have done something for the nation. So that is my submission, and also I want to emphasize, I'm not saying that somebody must not be appointed, but what I'm saying that the achievement of transformative goals, they don't only depend on leadership, but in the continuity of leadership. Because if the continuity, that shows that we have started somewhere And the person have to finalize that and start something new depending on the challenges one is facing at the time. That's what I'm saying. I'm not saying that anybody should not be appointed if the commission deems that fit. Thank you, DCJ. Thank you, Commissioner. Commissioners.
Thank you, Acting Judge President Matondo. Go well.
Thank you.
Colleagues, should we not take a short tea adjournment just to stretch our legs and refresh? All right, it's 12:25. We come back at 15 minutes? 15 minutes. All right, we'll come back at 22. Okay. Good afternoon, Judge Boyorot.
Good afternoon, DCJ and the commissioners.
How are you this afternoon?
All is well. That's what I
Good.
can say.
That's what we want to hear.
Yes.
You hold a BProc degree and you have a postgrad diploma in tax and a certificate in commercial law and yet another one in mediation, not so?
That is correct, DCJ.
You were a teacher at some stage, I did not know that.
For 1 month. I couldn't stand the kids. I was too young, so they were
Yes.
just joking as I'm teaching, so I thought, no, I can't do this.
They did not take you seriously.
No, not at all.
Yeah. Maybe before we continue, I should just disclose that Judge Boyorot and I are comrades in arms. We work together in the South African chapter of the International Association of Women Judges. She is my deputy, so we work very closely together. You did a whole lot of things. You were a casual worker at Truworths. I did the same when I started when I was 15, working at Edgar's, and I found that builds character, these experiences. So you did all that, but your legal career proper started in 1997.
That's correct, DCJ. I did my articles with Jenny Badro and Associates for a year.
Yes.
And thereafter, I ceded my articles to Hoskins and Ngobo attorneys. And that's where I completed my articles.
All right. Then from 2000, you practiced on your own account with other co-directors?
With my 2 co-directors. That's correct, DCJ.
For 14 years?
Correct, DCJ.
What kind of work did you do in your practice?
I did mainly conveyancing. I did also estates. But later in the years, one of my partners resigned, and I had to take over his commercial litigation, and I did that. But most importantly, I was the managing director of the firm since 2000.
You mean since it started until you left?
So the firm's name was Hoskins and Ngobo, and Hoskins had to move to Durban because he was interested in rugby. And Ngobo incorporated us into being his partners with Didrix. We had done articles there. So the firm name changed from Hoskins and Ngobo to Ngobo Poyo and Didrix attorneys.
So how long did you play that managerial role in the firm?
Since 2000 until 2014 when I got appointed.
Okay. And from October 2012, you started acting in the KZN division of the High Court?
Correct, DCJ.
And had intermittent stints until your permanent appointment in June 2014?
Correct, DCJ.
And 6 years later, in June 2020, you acted at the SCA?
Correct, DCJ.
How many stints, how many terms did you do?
It was 4 terms from 2020 May until end of May 2021.
As I recall, there were calls to try and keep you, force you
Yes,
to take a permanent appointment. Why did you not stay at the SCA?
At the time, DCJ, I did not feel that I was ready for the SCA, and I felt that I could do with more acting appointments. But I also still had an interest in my division. DCJ.
All right. How long have you been acting as Deputy Judge President in that court?
Acting Deputy Judge President from April to end of September, 6 months, DCJ.
You are no longer acting now?
No, unfortunately, it ended on the 30th of September.
I see. You've had involvements with various law bodies, the BLA, the SAULA, SADC Lawyers Association.
Correct, DCJ. Soon after I started my articles in 1997, I joined the BLA, and that is the body that enabled me to be involved in all these other various associations. Because in most instances, I was their representative.
Yes, and you were in the executive until you ultimately became chairperson.
Correct, Sitchay.
And you held an executive position in Saula as well.
I was the founding member of Saula for the KZN chapter at Sitchay.
You were vice president and president of the SADC Lawyers Association.
Correct, Sitchay.
For how long was that?
That was a year. I was asked to stay on for a second term, but I felt we had a policy of rotation, and I felt that I should not break that.
And you were also vice president and president of the KZN Law Society.
Correct, Sitchay.
And you co-chaired the Law Society of South Africa.
Correct, Sitchay.
And now you are the vice president of the SAC IWJ.
Correct, Sitchay.
Okay. Do you have any reported judgments?
I do, CJ. I have got about 8 reported judgments in the law reports.
And on estimate, how many written judgments, reported and otherwise, have you procured?
Probably more than 200 or 300, CJ.
Do you, well, I know from your time at the SA that you worked quickly and efficiently, and you delivered your judgments properly, promptly. I don't know how you fared in the High Court. Have you been as efficient there?
I'm always efficient. I'm scared to fail.
Do you have any reserved judgments?
The ones that are
Old ones,
listed
that
on
is.
my questionnaire, they've all been delivered, but there's just one that I dealt with towards the end of July. So it was an opposed motion, which I had over 2 days. I'm busy with it. It will come out before the end of the 3-month period.
Okay. Well, you've applied for a leadership position in your division. You want to be the judge president.
Correct, CJ. I was asked to make myself available, and I agreed. And I do want to be the judge president of the KwaZulu Natal division of the High Court.
Okay. Well, I would imagine that during your acting stint as DJP would have given you, well, that stint would have given you an opportunity to gain insights into the challenges, if there are any, in the running of the division. And if such is true, would you take us through that and just tell us what your vision is on what do you intend to do with that division if you get appointed?
Thank you, TCJ. Yes, I got exposed to various challenges, and some I started to address during my acting appointment. I have prepared a vision, and I have just been trained as a mediator, so they say we must rent optimism. So you'll pardon me if I sound too optimistic, because I'm not going to talk about if I get appointed. I will talk about when my appointment is made. Under my leadership, TCJ, I envisage an accountable, diverse, and united division that will offer efficient access to justice to the people of KwaZulu-Natal. My vision is underpinned by 5 pillars, namely accountability and efficiency, adequate resourcing, court modernization and digitization to provide better access to justice, visible, felt leadership, and transformation of the judiciary with emphasis on diversity. Through the various organizations that I have successfully led, my leadership style has been collaborative and consultative. I'm mindful that within the setup of the judiciary, I am not the boss, but the first amongst equals, a team leader. In addressing accountability and efficiency, the norms and standards in the Judicial Code are the instruments that make the judiciary accountable. My role is to facilitate and ensure compliance with them. The first challenge that we have with regard to this pillar of accountability is the long reserve judgments, which I intend to address by engaging the colleagues involved. One of the factors that lead to colleagues picking up more reserve judgments is when they do back-to-back civil sessions. This can be avoided through deliberate and focused allocation of work, including alternating between civil and crime session. We also have a backlog, particularly in criminal matters, and this has been exacerbated by the COVID-19 pandemic, as well as increasing number of long criminal trials, which need to be accommodated. To address this, during my period as acting Deputy Judge President, I had discussions with the DPP, Advocate Zongo, and her deputies to discuss ways and means of alleviating backlog, as long-awaiting trial prisoners also deserve justice. The first solution, DCJ, will be to reopen all circuit courts that were closed because of budgetary constraints. In addition, I requested the DPP to monitor indictments, as at times judges are of the view that some matters could have been dealt with at the lower court. I'll also engage the acting regional court president and his team on improving on court hours. On my last check in the previous Provincial Efficiency and Enhancements Committee meeting, the average that was advised there was 2.4 hours a day. Also, mediation will be another way of dealing with matters expeditiously and alleviate the court roles. I have in mind family matters, traditional disputes, RAF, and Department of Health matters that can be referred to mediation. In 2019 DCJ, 7 South African judges were sent to the USA for mediation training. I was privileged and honored to be part of that delegation. This team recently conducted a successful training in Cape Town through SAJE, and we are working on recommendations to the Chief Justice for implementation of mediation in the courts. Furthermore, the profession is being engaged to buy into voluntary mediation whilst we await for legislation to make mediation compulsory for certain cases. Some of the judges in the division are keen to assist in mediation. Another option is to introduce 2 special courts, one for family matters and a second motion court, as the waiting time to place matters on both the unopposed and opposed matters is increasingly long. Furthermore, DCJ, and I think more the minister, the pressing need is the employment of more judges for our division, which also talks to the pillar of adequate resourcing of the division. I know that a request was made by JP Patel, followed up by JP Chapi, and also followed up by AJP Madondo for appointment of more judges. If we make comparisons, something I don't like because I'm the second born of 11, so the other ones always want to make comparison, and I don't like comparison. If you compare KZN and other bigger divisions, the need is justified. For instance, as of July 2022, Gauteng's population is estimated at 16 million by State South Africa and is served by 85 judges. This means one judge services about 180,000 people. Western Cape's population is estimated at 7.2 million and is serviced by 33 judges. One judge services 218,000. KZN's estimated population is 11.5 million, served by 30 judges. We currently are 28, but the full complement is 30. One judge services 366,000. Based on these statistics, at least 63 more judges are required, but I think we can do anything that we can get because 63 might take long. In addition, more court space is required, particularly in Durban. Commissioners might know that we are currently based in the Durban Magistrates Court. The space is inadequate, very limiting. Also, the training of registrars at least twice a year, and by some of my colleagues, and some have shown keen interest, will assist in the resourcing of the courts. I believe that when the registrars know what we expect, it will also contribute to the smooth running of the court. The Judge President, as it is known, chairs the PEEC, which is responsible for ensuring efficient running of the justice system. I will ensure its optimum functioning so that it becomes a problem-solving body and not a mere reporting body which can play a role in adequate resourcing of the division. I'll ensure the functioning of the help desks, as these are key to assisting the unrepresented litigants. In addressing the modernization and digitization of the courts, this will be another way of ensuring efficiency of the courts. But digitization will also assist in the lack of space that we have. I think it's well known that Judge President Mlambo is continuously assisting with case lines. However, we need a proper rollout throughout the country. I have had engagements with him about training, especially for the judges of my division, and he said when we are ready, he is. I learned during my acting stint at the SCA that more matters were heard virtually than when a physical courtroom was needed. This will also assist in cutting costs if it is implemented in my division, especially fuel costs, and minimize dangers which we face on the entry because judges travel between Maritzburg and Durban. Our IT needs serious revamp. There is no Wi-Fi connectivity in Durban. Judges have to use their own routers or go home if they have to hear matters virtually. PMB's Pietermaritzburg's Wi-Fi is unstable. Working online for various matters will also improve efficiency as we continually have a problem of non-functioning recording machines. This will also assist in the access to justice because many people have access to data and they can switch on and hear their matters without necessarily traveling. It will cut on costs for them and counsel because counsel or attorneys will not have to charge for traveling time. In addressing visible felt leadership, I will ensure the smooth running of this division by having everyone included through the work of the various committees that will be revived. We had committees, but I think since COVID, I think something happened. Some of the committees that we had was Finance Committee, HR, Practice Directive, Library, Building and Acting Judges Committee. As soon as my appointment is confirmed at DCJ, it is my aim to convene a meeting with my colleagues to engage and address various issues that have led to the divisions that are currently at play. During my acting stint as DJP, I got to understand that some colleagues believe that there is a move for Africanization of the court. Some are of the view that senior members of the bench have been excluded on various issues. I am confident that once we engage each other and talk openly, we will find each other. My colleagues are reasonable. We might, if necessary, consider having a diversity training as it has assisted in some of the courts. Going forward, these issues will be avoided if we meet often and discuss various challenges faced by the division, as required in any event by the norms and standards. The meetings will also assist in evaluating our own performance and keep up to date with the ever-evolving requirements of the people and the legal profession. Ideally, at least at the end of every term, again, something I learned from the SCI. In addressing transformation, Deputy Chief Justice, I will ensure and prioritize the appointment of more women to the bench, as currently out of 27 judges, 11 are women and 1 is retiring at the end of the year. That remains to be 10. All acting appointments will be diverse with focus on demographics, skills, experience, gender, and age. Again, I emphasize nobody will be excluded. I will introduce an induction and mentoring committee to offer support and guidance to acting judges, something I learned from the SCA again. Our division must have a greater role in the development of jurisprudence. The SCA and CC, Constitutional Court, must think of KZN first when they need acting judges. I have led by example DCJ during my acting stint as the acting DJP, in that I was visible in court and to my colleagues. I allocated work to myself despite the demanding administrative duties. In that way, I got to be up to date with challenges faced by my colleagues in courts. I personally went to colleagues when allocating work to them, which gave me an opportunity to speak to colleagues and get a sense of their well-being. My aim is to have judges out of court at least once or twice or 2 days a week, so that they can draft, even if it's skeleton judgments for the matters that they would have just had. And this will also assist in reducing the reserve judgments. I am aware, DCJ, of the concerns regarding my age. However, my age and experience should not be an issue if one takes into account all the leadership roles that I have held in the profession and as the acting DJP. During my acting appointment, I was not inducted into the position, and this demonstrates the leadership qualities that I have. I sought guidance from my colleagues where necessary. I distributed work fairly, and I was never disrespected once, particularly by my colleagues, particularly the senior colleagues. I can say without a fear of contradiction that I have the support of the majority of the judges of the division of KwaZulu-Natal. My age and my warm personality, to those who know me, will assist in bringing stability to our division. And in conclusion, DCJ and commissioners, I was 20 years old when I obtained my BProc degree, 24 years old when I was admitted as an attorney and conveyancer, 25 years old when I became a partner at Ngobopoyo and Dietrichs and managed the firm for 13 years, or 14 years, sorry. 28 years old when I became a member of the management committee of the LSSA and a SADC councillor representing South Africa in the SADC Lawyers Association. Perhaps I can diverse a little bit here, DCJ, and tell you that rules had to be changed by the KwaZulu-Natal division of the Law Society for me to become a councillor because of my age. I became the council member of the management committee of the Law Society in 2003, and it had no restrictions. But for the KZN, you needed to have practiced for 5 years on your own account to become a councillor, and I had not attained 5 years. They had to change the rules, and I became a councillor.
Why did they change the rules for you? Not as a
It was
favor, I hope.
compelling. It was compelling from the BLA, but also they saw that I had the potential to do what was required, DCJ.
Did you do it?
Without any doubt, I have never failed, and I am not afraid to say. And the reason why I have never failed is because people put me under a spotlight because I am a woman, because I am young. I want to be able to tell people that it doesn't matter whether you are old or you are young, you can do the job, especially if you are blessed with the grace to lead. I haven't finished the CJ.
Carry on.
33 years old when I became the president of the KwaZulu-Natal Law Society. And might I add, the first woman president of the Law Society in KZN. I was 34 years old when I became the co-chairperson of the Law Society of South Africa. 35 years old when I became the president of SADC Lawyers Association, which had about 14 countries under its belt. And DCJ, again, if I may digress a bit there, when I was the president, I introduced a principle because in the SADC Lawyers Association, we had to come with 2 delegates. So I suggested that one of whom must be a woman. That has been carried throughout. My successor was a woman. The current president of SADC Lawyers Association is a woman. And at 39, I was appointed as a judge. And again, TCJ, I will not fail. I am afraid to fail. Thank you. That is my vision for my division.
Thank you very much, Judge Boyotlot. You have a long CV. You've achieved quite a lot of stuff. And I could not, for the sake of time, I could not go through everything that's in here. But I just want to mention one, which I think is important because you played a leadership role there for 5 years. That's where you chaired the Endumeni Evaluation Appeals Board, which you did between 2009 and 2013.
Correct, TCJ.
I just want to put something to you that one of the law bodies who have sent in comments on your candidature asked us to ask you, and It's a question I put to the candidate who was here before, AJP Matondo. They say the candidate should be asked about how she would ensure transformation of the KZN bench, which I suppose you've done in your vision, with particular emphasis on race and gender in light of the stark historic racialized tensions in that division. She should also share her ideas on how she would deal with racism and perceptions of racism in the division. Well, you've alluded to a fear that the the division is being Africanized, so I suppose that's what that means. But would you tell us just a little bit about that? Are there race tensions, are there race issues in that division?
Not that I know of, not race tensions. The tensions that really are there are really between, are caused by the fact that some seniors feel that they are not consulted or they are excluded in certain things. And those are not race-based, they are across board.
All right. So how would you make sure that no one feels excluded?
I will be inclusive and I will consult, but I will make the decisions.
As you described before?
Yes.
All right. Well, I may be unfair to you, but we're running out of time. My heart rate was at 60 when we interviewed AJP Madondo, and now it's at 120, so you'll forgive me, but we're running late. I'm going to hand over to the floor to put questions to you. Judge Mngoni, Judge Mngadi, I'm sorry.
Thank you, DCJ. Good afternoon, my sister, Poyolot.
Good afternoon, Judge Mngadi.
Well, maybe it's how you express yourself. When you say...
Judge Mngadi, would you please pull the mic closer to you so that we can hear you clearly?
Thank you. I say maybe it's how you express yourself. When you say, telling us of the things that you'll do once your appointment is confirmed, are you saying that the Judicial Services Commission is the body that will confirm your appointment?
No.
Oh. And again, when you are saying that once your appointment is confirmed, are you suggesting that you have been given an assurance that you'll be appointed as a JP?
No, and I explained that I've just been recently qualified as a mediator. And you know, when you have recently qualified for something, you use that with eager. And I said, I am renting optimism. It's one of the things that we do when we're mediating. You don't say if, you say when. That's why I explained, and I asked for pardon, because I don't know what this body will decide.
And I see that this organization of which you are the deputy president.
I'm struggling to hear you, Judge Mngoni. Ngati, forgive me, may his soul rest in peace.
Thank you.
Yeah. Just pull it even closer to you. You see how mine is right on my mouth.
Thank you.
Thanks.
I'm saying this body, the South African chapter of International Association of Women Judges, what are its objectives?
Its objectives are to ensure that women are empowered, women are given opportunities to be in the leadership of the judiciary. We have to ensure that we assist the communities, especially in issues relating to gender-based violence. Yeah, those are some of the objectives.
And the deputy CJ, she indicated that you are comrades in arms. So when you were nominated, shortlisted, and now being interviewed, during that period, you were comrade in arms with the Deputy Chief Justice.
I think that question is for me, Judge Mngadi. Let me answer it very quickly. I'm not involved in the nomination processes of that body. I'm recused.
But DCJ, I'm directing the question to the candidate. I'm saying during that period, again, you were the deputy president and the DCJ was the president.
Yes, Judge Mngadi. And in the SAC IWJ, we have a committee that deals with judicial appointments. And the DCJ is not part of that committee. In fact, I am the chair of that committee. But when the decision was made that they want to nominate me, I recused myself as well.
But that is the organization which nominated you, and that is the organization which has in fact written a letter now, a comment, recommending that you be appointed.
Yes. Because I'm their deputy president. And who better
But is
can
the
represent them?
No,
than
all
me?
what I'm saying is that
Yes.
that organization, the DCJ is the president. So
She is.
it's your own organization.
She is the president. And might I tell you,
Don't you see any conflict in that?
no, I don't see a conflict. Let me also tell you why I don't think there is a conflict. The previous candidate is also a member of the SACA AWJ, AJP Madondo. So I don't see any conflict.
But I'm saying for the DCJ, a president wants a candidate to be involved in your shortlisting and to be involved in your in the
I don't
panel
know.
which is dealing with you as a candidate for the JP position.
I don't know how to answer that question regarding whether she was involved in the shortlisting and what did she do there. But the fact of the matter is that the association has got a nomination committee that nominated me, and I have no difficulties with that.
Thank you. Well, you have outlined again your vision generally for the division, but from what you said, I could not hear you say.
Sorry, let me just say this one thing, Judge Mgati. The DCJ has got one vote in this body. So I don't think that it should have any problem again there. And she has disclosed that she knows me from that association.
But she is actively participating in the proceedings.
I think you can then argue that in the deliberation.
I'm simply responding to what you are saying. Let us move on. As far as you have addressed this committee, and I'm raising these matters not on anybody's instructions, but I'm part of this body, and the record must indicate what role I played relating to that. And I've got nothing personal against you or personal against the DCJ.
Why do you think I must think that you have instructions?
No, I'm simply placing that on the record.
Oh, okay. No,
Yes.
sorry. Yes.
Yes. What I was saying is that when you address this body, I could not, from your address, gather what culture do you intend to put in place in the division, for what purpose, and what challenges do you foresee relating to that? Can you talk a little bit about that?
I'm not sure when you talk about culture, what do you talk about? Because I said my leadership will be collaborative and will be inclusive. That is the culture that I will have.
No, it's fine if that's all what you can say about the culture, I take it. And then as
But
far
I'm
as,
not sure if I'm understanding the culture. What do you mean by that?
well, I can unpack it further. If you say that's all what you want to say relating to culture, I take it.
I will have a culture of including everyone in the division.
Thank you. Then again, for the division and for what purpose, what values do you intend to implement in the division, and what challenges do you foresee relating to that, and how will you deal with those challenges?
Those questions are not clear. I'm not sure about the values. I have outlaid my vision, and I have said, I don't know if the values will be equal to the pillars that I have described about accountability and efficiency, which is one of the core values as demanded by the norms and standards. And also, and adequate resourcing. Because
Yes.
all of those things that I have listed, Judge Mgati.
Again, I'm not blaming you, but is it correct that you don't have a formal leadership qualification?
What do you mean by formal?
Well, it will be a qualification you received from an institution like a university. That will be a
No,
formal
I don't
qualification.
have. And quite frankly, I don't think those are necessary. When you are a leader, you are a leader. It doesn't need education. You might have that qualification, but you will make a poor leader. So you don't need any qualification in my view. But I think more importantly, Judge Mgadi, I think I'm a born leader, if I may say. I'm the second born, first daughter of 11 children. I am what they call deputy parent, and I'm proud to say I have done a great job. And that shows that I'm a leader, and as an African, you would understand the importance of Utadobao or Rahadi, and I've played that role superbly. And I've played a very good role as a leader when I was leading the division as an acting deputy judge president.
And again, I'll raise this question. I would not have asked you maybe some of this question if we were dealing with the position of a deputy judge president.
Yes.
But is it correct that whilst you were there in the division and being part of the leadership of the division, during that period, the Madondo was there either as an acting JP or a deputy judge president?
Correct.
So in other words, you have not had an opportunity to run the division as a whole on your own.
So as you know, our division has got 2 seats. Durban, the local division, Maritzburg, the provincial division. I ran Durban on my own. Nobody told me how to do a roster. Nobody told me how to do roll call. Nobody told me anything about leading. So I led Durban on my own. In the next session, I led Maritzburg on my own. So I'm not sure if when you say the whole division, because this is how it operates. When one is a JP, they get to be in one center, and when one is a DJP, they get to be in another center. So in my own view, I have had an opportunity to know what it would be like to lead the division.
And as you have indicated again, in the division, we have got some colleagues with strong personalities. I accept it.
No, I haven't said that. I haven't said that I have colleagues that have got strong personalities.
Well, that is my view. You might differ from it.
No, I was
But,
just correcting you.
Let me finish then.
Oh, sorry.
But I accept that generally you are liked in the division. I'm also one of those who liked you.
Thank you.
In fact, I remember that when I joined the division, you as being senior to me, you guided me, you were very respectful. And in fact, there are instances you are known that you yourself, you have got a strong personality. And there are instances where you intervened when other colleagues were saying something bad about other colleagues or other people who were not present in that forum. So we appreciate that, and I take it that indeed you do have a strong character. But don't you think that for you to manage the division properly, it might have been better for you, at least in the division, to be a deputy judge president for some time before you become a judge president?
If I was allowed to ask questions, I would ask you why. But let me try and answer the question. I acted as the deputy judge president, and I said I ran the court, Durban Center, Maritzburg Center. So I don't know the value that I would have obtained if I became the deputy judge president. So in my own mind, maybe, when I was in Durban, I was the JP. When I was in Maritzburg, I was the JP, because all the problems came to me and I had to address them. And not once did I say, I can't deal with this.
No, all I'm saying is that if you had an opportunity to be the deputy judge president, you will have had an opportunity to prove yourself as a leader of a division. I'm not blaming you that maybe, you did not have that opportunity. But I'm not of the view that these short stints acting as a deputy judge president were enough for us to see you proving you as a leader. I'm not saying that you can't be a leader, but what I would say, you have not yet proved yourself as a leader.
I think that's your view, with respect, and there are many colleagues that are senior to me that have approached me and said, I must make myself available. Even before, for your benefit, even before the position of the judge president was advertised in April, already there were people asking me to make myself available, but I did not pursue that. And I don't know what the benefit would have been, with respect, Judge Mgadi, of me becoming the deputy first. I think people need to have confidence in people that they can do the job before being the deputy. There are many people that never became deputies before they took the roles. The Chief Justice, Arthur Chaskalson, never became a deputy before he was the Chief Justice. And there are many other examples. Judge Mbenenge from the Eastern Cape never became a deputy before he was the judge president of a division. I can list many. In my acting stints as a DJP, I think I've proved myself.
Well, in my view, even from your comment, it seems to me you don't fully appreciate the challenges of leading a division as a JP. I hope I'm wrong.
But what will be those challenges that you don't think I'm appreciating, that you think I can't solve, especially after your comment that said I have a strong character?
Again, at the SCA, I must appreciate again and say without hesitation that as far as your work ethic, I appreciate it. And of course, as far as your personality also is very, very positive. I am supportive of it. At the SCA, you were at the SCA for about a year.
Yes.
And you had an opportunity to pen, is it 4 judgments?
Yes.
Is it correct that 2 of those judgments acted dissent from some of your colleagues?
Not to my knowledge.
Well, I don't know why, because I can refer to the judgments. For instance, one of them is XTN versus Road Accident Fund. The other one, you'll remember, is Ndabeni versus Municipal Manager of OR Tambo District. You remember that
Or
now?
where they dissented, the other,
yes.
yes.
So do you say that you have not yet reached a stage where you can persuade all of your colleagues?
You know, the beauty about that is that I had 3 senior colleagues of that court in Ndabeni, the acting president being one of them, agreed with me on one hand, and unfortunately in the other one he did not agree with me. So I don't think it has anything to do with how I wrote, but it's the nature of the judiciary, as you know. Some agree, some don't agree, and that's why they take them to the CC. And might I say, in the CC, the Ndabeni one was partially confirmed. Only a little bit of it was not confirmed. So it means I was right, Mr. Judge Mngadi, sorry.
Yes, thank you. And again, in the judgments that you attached to the questionnaire, you refer to the case of State versus Mtetwa.
Yes.
Maybe I did not read the judgment properly, but what I found being omitted in that judgment, which to me is of significance, it should not have been omitted, is the circumstances relating to how that crime was committed. Because for one to determine whether an appropriate sentence was imposed on the accused or not, one needs to know in reading the judgment what were the circumstances relating to how the crime was committed. Do you have any comment on that?
I'm trying to get to it. It's a reported judgment, isn't it?
It's one of the judgments that you refer to in the questionnaire, State versus Mtetwa.
Yes, I'm trying to find it. So your complaint is that I did not summarize the facts?
That's correct, yes.
How would I have, I wonder how I would have gotten to the conclusion if I didn't summarize the facts. Can I have a look, please?
I accept it might have been just an oversight on your part.
No, I don't want to accept an oversight that I don't know.
The expiry of the 40 minutes we allocated for the candidate. So going forward, let's keep in mind that we are using bonus time now. We're completely out of time for Judge Boyolwat.
Thank you. I'll ask
So
the last
wrap up,
question.
please, Judge Mngadi.
Thank you. With your
Sorry,
permission, I'll ask only one question. Yes.
No, but the first paragraph in that judgment says the appellant was convicted in the High Court of 1 count of murder and 1 count of attempted murder. At the time of commission of the offenses, he was 16 years. And so you're saying I should have dealt with how the
circumstances under which or how the crime was committed.
We were dealing with a sentence.
Even for sentence purposes, the person is sentenced for the crime he has committed.
That's how I dealt with it, and it's a reported judgment. 2 of my colleagues who are senior agreed with how I structured the judgment, and I did not see it necessary, I would imagine.
And in the last one, that is my last question, in State versus N,
Yes.
2016,
Yes.
again, it's one of the judgments you're referring to.
I actually had 2 judgments, if I can brag to you about that.
Yes.
I had two judgments in the 2016 Volume 1 SACR.
Okay, thank you. But in this matter, maybe I'm wrong again. the accused was convicted of murder,
Yes,
but you sentenced him to correctional supervision.
yes, and did you read my judgment?
I read it.
Okay.
And just a minute, let me go on. I just wonder if it was the same circumstances of the case and the accused who had murdered her partner because she was terminating the relationship with her, if it was the man who had murdered the woman, whether we would have imposed the same sentence. Because if you imposed correctional supervision, it means she went away scot-free, having murdered a person.
No, if you read the facts, and this is one of my most valued judgments, which has been referred to in the Dutoy Criminal Procedure Act, and some of the scholars felt that I did well by evaluating what was before me. What was before me was not about a man or a woman who had murdered each other. It was a woman who had murdered a man. This man was the father of her child. This woman had been employed as a police officer. There were reports that were done to the SAPS that said of this nature of her mental health, but the SAPS still gave her the firearm. Let me finish. And the nature of her background was that she had been raped. She had lost her parents at a very young age. An uncle took over, but that uncle took over purely for the purpose of abusing her. So she had been raped, and she left and went and raised her siblings because both parents had been deceased. And she had tried to end a relationship with this man, but he refused. She was pregnant earlier, but that pregnancy terminated. She got pregnant again. She wanted to end things with this man, and he didn't agree. And when this man then rejected her, and that was based on the expert evidence, that when this man rejected her, it triggered all of her circumstances. It was a very unfortunate case. And the person had pleaded guilty. Crime was committed in Pietermaritzburg. She went and handed herself over in Vryheid. And that is how, at the time when the trial started, she was about a size 32. That was her physique. But when I sentenced her, she was about size 42 because of the depression and everything. But more importantly, Judge Mgadi, she was the caregiver of the child. I recall that when the counsel argued they presented arguments for sentence, it was on a Thursday, and the counsel said it's the child's birthday on Tuesday, and for that reason, could I consider sentencing after the child's birthday? So it was a very involved matter, and it had nothing to do with man, woman, or me trying to feel sorry for a woman.
Yes, but she happened to be a woman, and she had murdered the person who was her partner.
I think the case has been discussed sufficiently, Judge Mgadi. Thank you.
Thank you.
Follow up.
Yes, Minister.
Good afternoon.
Good afternoon, good afternoon, Minister.
Yeah, my follow-up is just on the last question from Judge Mgadi, that don't you see this as to let someone as scot-free, kind of? Do you think that correctional supervision can be equated to be letting someone scot-free?
It's not, it's one of the available sentences in the Criminal Procedure Act. I don't know how it can be scot-free. It was 276, is it I or H? I'm not sure. So there was going to be a custodial period, and then if she behaved, then she would get correctional supervision. So it was not like a out-of-prison sentence altogether.
No, thank you.
MEC Simelane, do you have any questions for the candidate?
Thank you very much, DCJ. Indeed, I do. But in light of the previous discussion, I think I must also disclose that I do know Judge Boyo Dlwati from my student days when I was a chairperson of the student chapter BLA. By the way, I met both Judge Dlwati and Judge Madondo at the same time. So I actually do know both of them from back then. Let me just start with the last question I was going to ask you. Understanding our province and the nature of it, it's a very traditional and patriarchal society. And that goes without saying that the bench itself is not immune from that. How would you deal with the resistance that would come should you be appointed from the bench?
Thank you, Acting Premier. In the context of our province being maybe patriarchal, there's a cycle of change in KZN, Acting Premier. The Premier is a woman. The Speaker of Parliament is a woman. The chairperson of AFT in KZN is Advocate Sipoka Zichikela SC, is a woman. Chairperson of the GCB in KZN is Advocate Sandhya Mahabir, is a woman. The DPP is a woman. The head professor at the University of KZN, Professor Reddy, is a woman. The provincial head of legal aid is a woman. I don't think that I will get any resistance in KZN because I am a woman. And might I say, I think most of them are around 50 or less.
But from the bench?
I've acted as the acting DJP, and I haven't had any resistance. And as I said earlier, some of my colleagues who are men, older, have not shown any resistance.
Thank you very much. When you were presenting your plan, one of the things that you indicated, or one of the pillars that you said you will implement, was the re-establishment of the circuit courts. I must say that I like that idea very much, considering the topography of our province and the vastness of the province. But what my question is in relation to this is, how would then you operate, or how would this operate in relation to the more rural parts of the province?
So the circuit courts are actually more in the outlying areas. We've got one in Newcastle, Matadeni. It covers the northern side. We've got one in Mtuba. It covers that area. We had one in Pongola, which was closed some time ago. And then we have one South Coast, Scottburgh. So the circuit courts do cover the outlying rural areas. But where necessary, Acting Premier, the regional courts at times do act as they do provide us to sit as the High Court, which brings access to justice for the people.
All right. Finally, I know you spoke about your plans for the court, but I want to know in detail what initiatives do you think you would put in place to ensure that the court is efficient in its functioning? Or what do you think should be put in place?
I think I have alluded to that in my vision. But more importantly, once there is a buy-in in my division, most of the judges don't have a problem with working. They work hard. And also the registrars, if we can get proper training for the registrars, that will also assist. And again, the monitoring and evaluating ourselves more often will ensure that we look at the areas where we fall back and then try to improve that. I hope I've answered.
Thank you very much, Judge Lwati. Thank you very much, DCJ.
Thank you, MEC. Commissioner Lukas?
Thank you very much, DCJ. Good afternoon, Judge Boyle.
Good afternoon, Commissioner.
For reasons of the debate that started between you and Judge Mkanti, let me disclose that out of the three candidates, that is yourself, Judge Matondo, and Judge Stein, I know very well both of you, Judge Matondo, and yourself. The only person I don't know, but I admire her judgment, is Judge Stein. And that does not play any role in this commission. I want to put that up front.
Thank you.
In relation to this application, I'm happy with the outline of your plan, particularly that you deal with the issues of collegiality and acting appointment. But now there are these specific questions I want us to talk about. Suppose you are appointed and Judge Matondo was is your senior in terms of appointment, and the fact that you were the deputy to her. How would you manage such a situation? I'm just making an example about that, Judge Matondo.
Yes, we have a very long, good relationship with Judge Matondo. It started in the BLA. I was the chairperson, he was an ordinary member. He was chairing one of the committees under my supervision. So our relationship dates back from there. I might say that I actually, as a chairperson of the branch, then spoke to the JP Shabalala and asked him if he would allow him an acting appointment, and the rest is history. So we've worked well together. When I joined the bench, we have worked well, because one of the objectives that we wanted to do is to ensure the transformation of the judiciary. So I don't foresee any difficulties. I'm sure he will be fine.
Yes. And second question related to this, it just arose during these interviews. You are in the hierarchy of that division. I know now.
Yes.
You are number 19. And what I'm not too sure, but you explain. For the position of being a deputy judge president, acting deputy judge president, certainly you did not apply. There was no advert for those who are interested to be the acting deputy judge president. You were picked among the 28 or the full 38 judges. So I just want you to explain that process. How did you become an acting deputy judge president when you are number 19? There are 28 or 30 judges.
Yes, there are 27 currently.
Yes.
As I've said, we've had a very good working relationship with Judge Matondo, and I have assisted here and there, especially supporting his vision as well. So we've had a very good working relationship. So I think when he thought of somebody who could be his deputy, then he thought I should be the right person. And I think he knows that I have got good leadership qualities. That's why he thought I would be his deputy.
This is the last question. When you are
And can I just correct this number 19? We were appointed 4, and I'm not disputing that I'm number 19, but when I was appointed, it was 4 of us.
Yeah.
But because of my age, I was at the bottom again. So I'm really like number 16 or number 15, because we were twins. 4 of us were appointed at the same time. But I accept that I'm number 19, it's okay.
Yeah, yes. Now, when you are appointed as an acting deputy judge president, that's a senior position in the division. There were other senior judges. Because there's a suggestion that, for instance, if we are appointed, there may be some, there were even comparisons about drivers and learners. I don't know what that means. But the point is, when you are appointed as an acting deputy judge president, no heavens had fallen since then. The division operated as it was. Or are you aware of any incident where other judges were not happy with your appointment and that has caused some divisions? Just can you share, after you were appointed as an acting deputy judge president, did heavens fall in the case of 10 division? That's my last point.
Heavens did not fall. We there, all of us. There was some unhappiness, particularly because of how it happened. I think some felt that they should have been consulted or they should have been told or something. But I think it was the manner in which it happened. But heavens didn't fall. But more importantly, Commissioner Nokesi, after I got appointed and I went to Durban, it's one of the busiest courts. I myself was worried how the reception would be because I'm based in Maritzburg most of the time. But the collegiality was great. None of my colleagues showed any sign of disrespect. And when they did what they did when a senior was there, if they finished their cases, they came and reported and told me that they've done so that I can allocate more. So this notion that there might be heavens falling, they haven't fallen, they will not fall.
Thank you, Commissioner Kesi. Commissioner, Professor.
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
I will not accuse anyone of having said anything, lest I misstate what people said. But I'm just going to tell you about the impression that I got from the interaction with the head of the court now, or the representative of the head of the court. I got the impression that you lack intellectual ability to convince other judges who are sitting with you to produce a unanimous judgment. And I want to reject that. I want to reject that outright, to the extent to which my impression might be right. And in fact, when I see your track record at the Supreme Court of Appeal when you were acting, it is clear to me that you do possess the intellectual capability of convincing other judges to follow you. There is a judgment that I read, the Discovery Life Limited versus Hogan. I'm not sure if you still remember that judgment.
Yes, I do.
The presider there was the deputy president of the court, AP Pete, and one of the senior judges, Wallis J.A. You had two other acting judges, Potriel and Rogers, and you managed to convince them to rally with you in that judgment. So I just wanted to take that out of the way.
Thank you,
because it is important to also realize there's nothing wrong with anyone dissenting from another. Actually, we get more value from judgments when we have different perspectives. That should never be considered as if somebody lacks to some, and I'm not saying anyone said that. I'm just saying this is the impression that I got.
Yeah.
The second point that I want to raise with you, I think you presented a very clear vision and a very detailed vision for the division. And I want to probe your understanding of the concept of equality within the South African society generally, where black women in particular are constantly reminded of how not ready they are and should be provided guidance and affirmation. They should be walked through before they get to a particular point. But more specifically, I want to hear your view regarding substantive equality, which I believe requires an asymmetrical approach that really seeks to facilitate the creation of equality of opportunities. Having heard me saying that, what do you think should be done in South Africa in practice to allow particularly black females the opportunity to have the equal or at least some stake in the legal profession and the judiciary at large? We don't have any judge president in the country currently. We had one for a longest of time. And now we have an opportunity to present one. We are informed that they should be walked through up until whatever date. What is your view in relation to that?
Thank you, Commissioner, and thank you for all those compliments about my judgments. You know, I think it's time, and I think I must restrict myself because I'm a judge. It's time that women must fight for themselves. We must not be done favors by men in particular. That's why, as a deputy president of SAC IAWJ, we are ensuring that women judges and magistrates are capable, are competent. And I think it's just the political will sometimes of those that can make it happen, that do not have that. In the magistracy, they're doing well. There's so many regional court president, magistrates that are women. And the judiciary, we are lagging behind, especially in the leadership. But I think we focused as a country on transformation on race only. We did not focus on transformation as being inclusive. That's why now we must be held our hands in doing things, even when you have demonstrably shown that you can. So I think the short answer, women must start fighting for themselves.
Thank you very much. Thank you very much, DCJ.
Thank you, Commissioner Madam Mufai. Commissioner Nyambi.
Thank you, DCJ. Afternoon, Judge.
Good afternoon, Commissioner.
I must also join and indicate that your vision has covered most of the questions that I have for you. It was very detailed and clear.
Thank you.
My appeal is that in your fight as women, don't exclude men that are very clear that want to deal with this thing of fighting patriarchy. So it must not only be the fight of women.
Thank
You must
you.
also make us to be part of that fight. As this is a leadership position, mindful of time, I'll ask you just one question. It's in relation to your experience as we have acted as a acting Deputy Judge President. Probably if you can share something that can demonstrate how we have dealt with a critical challenge in that division to show that indeed we are definitely ready to be at the helm of that KwaZulu Natal division. An example that you experienced in the past whilst having that acting stint.
I didn't have too many challenges. Maybe one you might think is minor. There was one employee, there was this issue of COVID and masks. One employee was not vaccinated, and the particular judge apparently spoke in an inappropriate way to this employee, and he came and reported the matter to me. I went to this colleague, and he readily said, I was out of line. I will go and apologize in front of the others. And I thanked him for having done that, because I didn't have to then try to resolve that issue. So I didn't have so many challenges, because people were readily able to come and speak to me if there was a challenge.
Thank you, Judge. Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Dodo.
Thank you very much, DCJ. Good afternoon, Justice.
Good afternoon, Commissioner.
I firstly want to join those commissioners who commend your vision.
Thank you.
I think its conception is very solid, and I wish that it becomes a blueprint that many look at when they want to deal with the challenges of the divisions. Now, what comes out very clear to me is the fact that there are tensions, and in your vision, you acknowledge the fact that there are divisions within the division itself. Now, the position you are applying for is of leadership, and the word leadership is coming up very strong in this interview. Now, practically speaking, there are other challenges that are facing the courts in South Africa. One of those is the fact that judgments are delayed. Some people accuse judges of using combative language in their writings. You talked about transformation of women, which is okay, is a challenge. But in your respective view, what do you think you will do to deal with the challenges that are facing the judiciary, especially those specifically divisions amongst the judges, the language that you use, as well as fast-tracking the judgments? Thank you.
Thank you, Commissioner. So some of the challenges I got to know when colleagues came and spoke to me. And in my view, that was a sign of confidence that they have for them to come and open up and tell me what they perceive. We will engage, because I do not think, for instance, that there's a move for Africanization of the court. If I better understand where that came from, Because if you look on our history, it was Judge Patel, Judge Japi, and then acting JP. And in April, this body appointed a white man. So I don't know where this Africanization comes from. So I will have to have a better understanding. I think the engagement, because sometimes people are afraid of change. Let me just say it that way. And they think something that is happening is something that is going to be detrimental to them. And I don't think so. And I've said one of the challenges is the feeling of exclusion or not being regarded by the senior colleagues. But if we work together as a team, especially in the work of the various committees, I think people in their nature, they need to be valued, they need to be acknowledged. And I value and acknowledge my senior colleagues because some of them have vast experience in law. They will do well in mentoring. They will do well in ensuring that the people that come in to act get the sufficient assistance. And I don't see that there's going to be any hard issue in getting that. So I think when you have my leadership style of being inclusive, especially, it should not be a problem, Commissioner.
Thank you very much. In the interest of time, the CJ, I forego my other question.
Thank you.
Over to you.
Much appreciated. President Pete.
Thank you, Deputy Chief Justice. Good afternoon, Judge Poyelrat.
Good afternoon, Acting President.
I had 3 questions for you. 2 of them you covered when you presented your vision about your experiences at the SCA and your being alive to the need to render assistance to puny judges and legal practitioners who are invited to come and act. That then leaves one question. There might be those who have reservations about the length of your service on the bench. And taking my personal experience, I had the privilege to lead the Mtada Division of the High Court from 2008 to 2010. When I was invited to act as acting Deputy Judge President, I was on the bench for only 3 years, and there were colleagues who had 10 years on the bench. And I became aware of the fact that I had done a good job during my acting stint when I was approached in 2014 to make myself available for the position of the Judge President. What would your response be to those who say you have been on the bench for only 8 years and therefore too junior to lead the division?
Thank you for the question, Acting President. That view has got undercurrents of patriarchy, because I think the only reason why I'm regarded as junior is because I am female. I'll tell you why I say it so, and maybe I'm young. I think I'm being discriminated twice, woman and age. The Judge President of the Eastern Cape Division, he will forgive me, he was only a judge for 2 years, I think, and he became the Judge President. There were no questions asked. The Deputy Judge President of the Gauteng Division, Judge Mujapelo, was only a judge for 2 years when he became the DJP of Gauteng, one of the busiest divisions in the country. There were no questions asked. Why should that be asked of me when I've been a judge for 8 years? 8 years is not a short term, it is a long term. I'm looking forward to my second long leave, and that's the milestone we use in the judiciary to determine your seniority.
That's where I leave it. Thank you, Judge Poyozat, and thank you, Deputy Chief Justice.
Thanks, President. Minister, it's your turn.
Yeah, thank you, Deputy Chief Justice. Judge, my question relates to this matter first of this deeply entrenched view that the Deputy Judge President in KZN should be the President of the court. And I will tell you the reason I want to ask you this question is because in case you are appointed, you will have a more bigger role to play to extend a hand to the current DJP who is there. So what do you think will be your role in that regard, and also to ensure that there's harmony in the divisions, even amongst those that think you might not really have been the deserving candidate above the Deputy Judge President?
Thank you, Minister. This entrenched view about the deputy becoming the president, that then would disregard this body. Because why would you then have to make people apply and come and present themselves here when you know that you are just rubber stamping? Two, it could be that 2 or 3, no, not even 2 or 3, I think it was only Judge Japi that was not contested as the judge president when he applied, but all the other ones were contested. So in my view, it could be a convention, but it is not an acceptable convention by many, especially those that had applied in the past when judge presidents, and they were not deputies. So that notion really, I don't think it should be taken into account. More importantly, this body has got constitutional imperatives that it must comply with. I don't think you must be blinded by the, what if there was a deputy where nobody, and this is just, I'm just making an example, where everybody just didn't know why did this person become the deputy. Now you're going to make that person ascend to be the judge president because of a notion, because of a convention. Finally, Minister, we must check where these conventions come from. We must not be guided by conventions where that come from a particular side of the profession. And I know that I'm going to be in trouble with the advocates profession, but so many of these conventions are from their profession. And Minister, I was an attorney. We don't have so many of these conventions. And I think that's why we were able to transform easily as the attorneys instead of the bar. But I think we can work together and understand that despite the conventions, when there are constitutional imperatives that must be met, then your sense of duty must come first. I think.
Can I proceed, or we have to wait?
Commissioners on the virtual platform, are you still with us?
We're with
Can
you.
you hear
Yes,
us?
we're with you.
No, let's just give it a moment.
Oh.
We can see you in
Thank God
darkness,
is intervening.
Deputy Chief Justice.
You don't feel safe, Commissioner?
But load
Commissioners
shedding
on the
is
virtual
suspended
platform?
tomorrow morning.
That sounded like Commissioner Singh.
Yes,
Oh,
Deputy Chief
you
Justice.
can
I
hear
think
us.
load shedding is going to be suspended tomorrow morning, so they say. But we'll have to wait till it happens.
Yeah. Carry on, Minister.
Did you give me an opportunity to ask questions?
You
Or
need
is
a
it,
moment,
Minister?
Commissioner Singh?
Okay.
Yeah. Okay, thank you. My second question relates to the one you dealt with on your vision, the modernization and of the court. I know that it has always been raised by yourself and also Acting Judge President Madondo about the difficulties the division has. What do you see will be your role as a JP now to coordinate, because for sure you know the challenges are in between the Office of the Chief Justice and ourselves in the Department of Justice, to coordinate that indeed this vision becomes a reality, despite these budgetary constraints and the other issues that you are well aware of, which may affect the vision that you have becoming a reality of the modernization of the court.
Thank you, Minister. I have developed a good working relationship with the head of Department of Justice in KZN, and we have a very good working relationship. So I think if we put our heads together, the head of the department there and the head of the OCJ, and implore on the OCJ to make the resources available. But in the meantime, some of the colleagues are entitled, well, all colleagues are entitled to have the Wi-Fi routers. So I'm going to advise all of them to try and obtain those so that we can start going forward. And I've already said that I have spoken to Judge Mlambo about the training, and he's readily available. So once we've got those in place, because I think most of us have the compliable laptops that we can use. So that's what I can do, but I'm going to have to engage closely with the Office of the Chief Justice.
Yeah, lastly comment, I thought when you mentioned all the heads of stakeholders or entities, you will also mention that the head of the state attorney is also a woman. And that the regional head of the Department of Justice in
Is a woman.
is
Yes,
also a woman.
yes, I forgot to mention that.
Thank you.
Commissioner
Thanks.
Baloyi?
Thank you, DCJ. Good afternoon, Judge Poyoli.
Good afternoon, Commissioner Baloyi.
Yes. Maybe let me start off by saying that I hope, whether you get appointed or not, I hope that many a young black female lawyers, they come within your sphere and orbit and see and learn from you. I hope that.
Thank you so much.
My question to you is, in the last interviews that we did in April, and you represented KZN.
Yes.
I'm looking at the transcript. I don't know if you have it in front of you. And I just want you to clear something that concerns me, and maybe my concern is not well-founded, subject to your explanation.
Yes.
If you have the transcript of
No,
that...
I don't think I have it.
You don't have it?
No, but I can listen.
Yeah, let me try. I'll try. It's not a very long thing that I want to read for you. At page 67, and this was the discussion about the book that the acting judge president published. Do you remember that
Yes.
debate about
Yes.
what it means and his explanation?
Yes.
And you intervened in that discussion.
Yes.
And here's what you said. This is where you start. You say, for the first time when you speak, you say, thank you, Chief Justice. Judge Madondo, I just want a point of clarity on this issue, right?
Yes.
My understanding of the book is that it is addressed to those that intend to follow Christianity.
Yes.
And then you go on to say, and if you don't want to follow Christianity, you have no reason to concern yourself about the issues that are raised in the book. You only, for instance, all the repentance, all issues that were raised in Sodom and Gomorrah, those were the issues for those that are Christians and for those that intend to follow Christianity. Yes, she's been clearly stated in that book, something to that effect. That's what you say. Can I ask you to, would it be fair to say with that kind of intervention, it sounds like you're saying it's okay to say that to people who follow Christianity, to hold that view. If Judge Madondo said, yes, I'm directing myself to Christians and people that want to follow Christianity, they must repent. You know, you remember the words that were
Yes,
causing
yes.
all the offense. That it's okay to hold that view for him, you know, if it is limited to those. And now the concern is that what you were saying, and is that reflective of your own position on the issue?
No, not at all, Commissioner Baloyi. I was asking a question, and as you have correctly pointed out, my starting point was it was a question of clarity. I wanted to understand what he meant by that.
Reflective of your own views?
Not at all.
Okay, all right, thank you. Thank you, DCJ.
Thank you, Commissioner Baloyi. Commissioner Matolo-Lebu.
Thank you, Deputy Judge President. Good afternoon, Judge Boyod Dlwati.
Good afternoon, Commissioner.
Okay, I have to declare that I've known Judge Dlwati for the longest. And to me, in the profession, she's one of our shining stars, in the sense that as a young girl, she defied.
Mike, Commissioner Matolo-Lebu.
Can you hear me?
Yes.
I just want to say that I've known Judge Dlwati for the longest, actually. She was a young girl when she joined the BLA, and she defied all the conventions and made sure that the women are in leadership positions within the BLA. And I must say that you are a good story to tell. And I'm saying that because I'm older than you.
Thank you.
But yeah, what I wanted to find out, you know, when we interviewed the acting judge president, Madondo, he seemed to indicate that this succession plan will not be fulfilled should he not be appointed. I'm not sure whether the succession plan depends on his appointment, or is there anything that, since you are acting as a deputy justice, judge president, is there anything that you think you cannot do that he can do? I just wanted to clear that.
Is there anything that I think I cannot do that he did?
Yeah.
No. I did everything that he could do. I told you I ran the Maritzburg, I ran the Durban. I did everything he did. And as I said, Commissioner Matolo-Lebu, we have had a very good working relationship. So I know his vision. There are areas he knows himself, even before I got to apply, where we agreed to disagree. So we'll have to iron out those if I'm appointed. So I don't foresee any difficulties in working. And also, I will check what was on his agenda, he'll check what is on mine, and we'll try and put those together, and we should be good to go.
Secondly, one of the things I think his concerns was that if one of you ladies gets appointed, you are young and you may not even heed his advices, is that knowing you, I know with the respect that you have to your elders, is it, you know, I'll be surprised if you don't do it.
Yeah, I evaluate advices. I take into account criticisms, especially if they're constructive. So unless it is something that is wrong, I will not agree to something that is wrong, that is against these principles, this vision, this trying to build the division again. If it's something contrary to that, there might be issues there, we'll have to. But even then, we've got people that we've worked with together. If there's a difficulty, we will get somebody to try and mediate between the two of us. But Judge Madondo is going to retire next year, so I don't think it's going to be a very long period. I'm sure we can work together just for a year.
Thank you. Thank you. Thank you, DCJ. Good, good afternoon, Judge Boyo Lwati.
Good afternoon, Commissioner Shabangumdao.
I think I must also declare that we known each other for quite some time. We were together at the PLA.
Yes.
Judge, I appreciate the answer that you gave Commissioner Marumagai when he asked you about the readiness of women. And I challenge IAWJ, SAULA and DOJ to coordinate a dialogue where men will also be involved, as Commissioner Nyambi has said. Because every time when a woman has or is competing to be ascended to a leadership position, that question always comes up, the readiness of a woman. But when it's a man, that question does not come up. I think we really need to engage on this one. Otherwise, we will be failing our women. My question to you, when you were outlining your vision, you spoke about mediation. We know that mediation and arbitration is a buzzword in other countries. Do you think mediation can assist in dealing with a high number of cases which are placed on the court roll, of which some can be resolved in other ways, like the mediation and the arbitration? If you so believe, how can you assist in expediting this process?
Thank you, Commissioner. That's a subject very close to my heart of late, the mediation. As I have outlined in my vision, some of the matters that can really start, that's why we are engaging the legal profession to start voluntarily, is the family disputes. Those can be easily resolved, especially where custody issues are at play. The RAF matters, we know that RAF matters more often get settled on the day of trial. But if you engage the parties as soon as after the pleadings have been closed, then that has got a potential to resolve the issues. Matters involving the Department of Health also more often, but lately I think there is some more opposition, but also get to be settled. So even those ones, if once pleadings have been closed, you engage the parties, they can, so those, and in KZN in particular, the traditional disputes can also, and I might add that during the training in Cape Town, we also trained traditional leaders, and they were very grateful, and there were 2 from KZN, and we'll follow it up to see if we can, because if they could be able to resolve those disputes properly in their own basis, then they will not come to court. So we are trying to get recommendations done to the Chief Justice so that he can forward those to the Law Reform Commission, and if we can have some changes to the legislation to make mediation compulsory. That can alleviate the backlogs.
Thank you, Judge. Thank you, DCJ.
Thank you, Commissioner. Do we have questions from the virtual platform?
Yes, DCJ.
Go ahead, Commissioner Singh.
Thank you, Commissioner. I see Commissioner Barnard's hand is also up after me. Good afternoon, Judge Boyo Lwati.
Good afternoon, Commissioner Singh.
Yeah, thank you very much for availing yourself. I'm very glad that Commissioner Baloy asked the question on your intervention on the statements the last time, because when you read the transcript, it says, I quote, my understanding is that it is addressed to those that intend to follow Christianity. But I think you've cleared it now to say that you put it in the form of a question and not as a categoric statement from yourself. And I hope that goes on record. But having said that, you've outlined some of the issues that you've found that hamper the effective delivery of justice in the KZN environment. And one of them is circuit courts. And you said that one of the things you'll do is reopen all circuit courts, but you spoke about funding. I just want to know how you're going to practically implement that, because it's a very good idea that these circuit courts be open to allow access to justice. And then related to that issue is the question of delayed judgments and delays in setting up matters. Sometimes it takes between 12 and 18 months before a matter is set down for hearing. And I, as a layman, feel that is far too long for, one to say a matter is now going to be heard, next year, at the end of next year. How would you aim to try and correct some of these things to ensure that justice is meted out swiftly? That's my first question. Thank you.
Thank you, Commissioner Singh. The circuit courts, they were closed, I think it was in 2019 or 2018, thereabout. I don't know if budget permits now, because at that time there were cost-cutting measures. So I'm hoping that we have come out of cost-cutting measures. I will have to check with the office if the budget allows it, permits, then we can be able to do that. So that's going to depend on the availability of budget. But from my preliminary discussions with the court managers, I haven't found that there is no budget to do it. We're going to have to do it whether we approach the OCJ or the minister, because the backlog is bad, especially in Matadeni, and also I think in Tubatuba, and also in Durban, because we don't have space. So something has to be done if we want to save justice for the people of KZN. With regard to the delayed setting down of matters, we're not doing bad with trials, because as I understand it, in Durban, I think we're setting down in March or April next year, and in Maritzburg also around that time. In the normal in worst cases, usually you would wait for about a year or so, but now you don't, because we've got a role for RAF matters every Wednesday, and that has reduced many matters, taken out many of the RAF matters from your ordinary trial role. So we're not so bad, but we are getting bad with the opposed motions. Hence, in my vision, there's a suggestion that we open a second motion court, particularly in Durban, because they're setting down next year and also in October, which I find very disturbing. So if we were to open a second motion court, but also if we sit down as colleagues, because we do sit, and many of them do come up with ideas, even though they are not at management, they are very helpful. They come out with the ways in which we can try and reduce the backlog. So all we need to do is to sit and check how we're doing, and maybe in the opposed matters, because we're not doing badly again with the appeals. As a result, judges are going to be doing more opposed motions during January, because that's the period we do the full court appeals, but there are not so many that have been set down, and judges will be doing some of the opposed motions. So if we were to keep record, or rather monitor closely the workload, I think as we see that things are starting to get off hand and we implement some intervention, even if we say we're not going to deal with a particular, maybe a trial or whatever, but it's something that we once we monitor closely, we can try and implement those. I'm not sure if I've answered all your questions.
Yes, no, thank you for that. And if you are appointed, you will certainly get support on the circuit courts and the increase in the number of judges, because I like the statistics that you provided us. I mean, and for those of us that come from KZN, I think, Minister, you're going to find us at your door sooner rather than later, and OCJ, so that the DG there can deal with some of these matters. My last question would be, Well, in April, you came here in a different capacity. You had to, you represented the division. And you did support the candidacy of the applicant then. Now you are an applicant yourself. Have your views changed on the ability or suitability of that applicant at that time, now that you are an applicant yourself?
That's a difficult one. So what happened, you did not appoint Judge Madondo in April. And I thereafter got approached to make myself available. So I had to focus on myself. So I don't know about his suitability or not. That is what this commission must do. If you allow me to just say, I just focused on myself and what I think I can do after I had been approached by the people that approached me and implored on me to make myself available. Remember, I'm going to work with Judge Madondo if I'm appointed.
Indeed, indeed. No, thank you very much. Thank you, DCJ.
I make a follow-up on this question.
Yes, Commissioner, yes.
Just one. If Judge Madondo is appointed, let's say this one, are you prepared to support him?
Yes, I've always supported him.
Any further questions from the virtual platform?
Commissioner.
All right, thank you.
Yes, Dr. President.
Go ahead.
Thank you.
Commissioner.
Good afternoon, Judge. How are you?
I'm well, thank you, Commissioner Breitenbach.
Good. You're very confident and very forceful, and those are qualities that I admire. Would you tell me what you think the two most important qualities of a leader are? Thank you.
The leader must have an ability to listen to people, must have empathy, and must be kind.
Thank you very much. Thank you, Deputy.
Thank you, Commissioner Breitenbach. No further questions from the room. All right.
Sorry, DCJ, sorry, my hand's been up also as well.
I'm sorry, that doesn't show here. Oh, now it shows. Go ahead, Commissioner Burnett, please.
Thank you, DCJ. Good afternoon, Judge. First of all, it's clear from the interview you've been a leader in court, you've been a leader in society, you've been a leader in association, you've been a leader even in family, you've indicated. So have you ever been, you must have been in difficult situations where there's serious animosity or differences between those that you lead, and how does one deal with that as a leader?
Good afternoon, Commissioner Barnett. You talk to people. My brother who comes after me always say, everything is made well by talking and everything get distracted by talking. So if you talk to people, if you have empathy, I think more than anything, when people talk to you as a leader, they must see that you are listening to them and you understand their point of view. It doesn't mean that you accept that they are right or they are wrong. And you would have seen from my CV, I lead a couples ministry in my church. And that's an area where you really have to mediate between a wife and a husband. And you just have to show in a proper way why you believe it should not be that particular way. So you need to listen, understand them, understand their point of view, more importantly, and try to come up with a solution. I've faced various challenging situations, most of which I have been able to deal with.
Now, where there's litigation on behalf of a minor in a matter that's run for several days, and you're mid-trial, and then the matter of a recusal comes up, what factors should a court consider, and how should the process unfold before the court makes a decision on recusal?
We all know that matters involving children must be dealt with expeditiously as possible. So you have to consider whether the apprehension of bias is reasonable, or even the person that is making that application is reasonable themselves. And then you can decide from there as a judge. But you have to take into account that matters dealing with children are dealt with as expeditiously as possible.
And if no one, it's not raised by one of the parties, but it's a thought that comes up in the court's mind or the judge's mind, whether there should be recusal or not, should one listen to the legal practitioners and hear their input on such a matter? Bearing in mind you are mid-process.
Yeah, I would imagine that if you feel that you are conflicted in any way, I think it's something that you can put it out to the parties, allow them to make submissions. They might say, we don't think you should be recusing yourself. And at times it does happen that you're faced with a matter and you feel that you have because you have known maybe a person for quite some time, you disclose to them and they say, no, you can go ahead, they don't have a difficulty with that.
Thank you very much. Thank you, DTJ.
Thank you, Commissioner Bernard. Is that all from the virtual platform? Commissioners, I just seek your indulgence before the candidate leaves. There's an important matter, well, it's important to me that I think I should place on record. In the interaction between Judge Mngadi and the candidate, when they started that interaction, a suggestion was made that I may have conflicted myself because we work together in the Women Judges Association by being involved in her nomination process and the fact that I'm the screening committee chairman of the JSC and would have shortlisted her. I know that she answered the question, but I'm here and I'm going to answer for myself. I just want to make it very clear that I became the president of that association in 2018, and by that time I was already a JSC commissioner by virtue of being the SA president. And I immediately, it will be part of the records of that association because I made a formal declaration of my situation to cover myself, and I immediately distanced myself from the judicial nomination processes of that body. So I have absolutely nothing to do with that process. I am indeed the screening committee chairperson of this body, and I shortlisted her along with the rest of the committee. And I did not only shortlist her, I shortlisted Judge Madondo, who, as I declared when I started his interview, is actually a close colleague, and I do not see any conflict there as well, because a huge number of candidates who come through this process, not just in this session, but previously as well, some of them who have been recommended for appointment this very week are members of the same association, and no issue has ever been raised about that, and indeed none should have been raised. So I just want to dispel any misunderstanding there may be in anybody's mind that I may have acted improperly. I did not. Thank you very much, commissioners. I'm sorry to waste your time, Judge Boyodwati, but I felt I needed to say that while you are still here as well, because it affects you. Unless you have something you want to round up, I don't know, you want to say something to us?
No, not really, but I just want to thank everybody that supported me, that prayed for me. It was not easy, but I think it was worth it.
Thank you, you're excused. Are you ready?
I am ready.
All right.
Thank you, Deputy Chief Justice.
Good afternoon, Judge Steen.
Good afternoon, Deputy Chief
How are
Justice. Well, I was hoping to say good morning, but no.
Indeed, we owe you an apology for
No,
keeping you
no,
waiting.
no, not at all. I know it's without, it goes beyond everything one can do. These things are not predictable, so yes, I'm
Thank
I'm
you
fine.
for your understanding. All right. You hold 3 degrees, a BUris, LLB, and LLM.
That is correct.
All right. You joined the Department of Justice in 1980 already.
That is also correct.
You must have been fresh from high school?
It was in my year I finished matric. I think the results came out on the 16th of December, and on the 20th of December 1980, I exchanged my school uniform for work clothes, and I worked behind the counter of the maintenance court, yes.
So you really started at the very bottom rank. And you were with the department until 1995.
That is correct.
What did you do in that 15-year period?
In the 15-year period, I have been, well, starting off in 1980, I've been every clerk you can think of in the magistrates' court, or imagine even. And thereafter, I qualified in 83, so in 84 I became a prosecutor. I prosecuted, I worked through the ranks, I was promoted to being senior prosecutor. I've also then been appointed as a magistrate, and I've been in the court, various magisterial districts for about 4 years, plus minus, a little bit longer, because you start acting before, when you're still prosecuting, they use you on the bench. And thereafter, I went back to the prosecution after being asked by the then Attorney General to come and train prosecutors. So I've made the jump back from magistrate to prosecution in 1992, and I then led very big court, Weinberg Court, where you had a complement of about 38 staff. And in 1995, I was headhunted by UCT and then left.
So you did all your studies part-time while you were working?
All of my studies I did part-time, yes. I have never been full-time to a university at all.
Well, and it appears that you would have done exceedingly well, because you were snapped by UCT.
Thank you, Deputy Chief Justice.
You were a senior lecturer at the University of Cape Town for what, 9 years?
I've been there for 12 years. I joined UCT in 1996. I left UCT by December 2007. Strictly speaking, I was still employed by UCT when they granted me the opportunity to go and act as a judge in the Western Cape High Court.
And that was in 2008?
2008, I was given that opportunity.
And your permanent appointment was in 2009?
The 1st of January 2009.
All right.
Yes, Deputy Chief Justice.
You have written a number of a whole lot of judgments through your judicial stint. And I just wanted to find out if you were able to produce 1 or 2 during your acting stint at the Constitutional Court?
In fact, in the Constitutional Court?
Yes.
No. I think that is, I'm very glad that you referred to that. There's only one of the comments, I think it was the law teachers that referred to an acting stint in the Con Court. I have not acted in the Con Court, Deputy Chief Justice.
I wondered, because
I think
did not see that.
it was a confusion between me and
the
Judge
other-
Madondo, who had the opportunity to act in 2021.
No, there is another Judge Steyn who acted there, so they must have confused you with her.
There is an Elise Steyn in the Western Cape, yes. Okay.
All right. But you did manage to produce a good deal of written judgments in the High Court, nonetheless.
Yeah, in my year of acting at the Western Cape, 3 of the judgments that I produced were reported in the law books, yes.
and you don't delay your judgments. You have a certain reputation of being very hardworking and efficient.
Yeah, I don't believe in it. I think it's a slippery slope. Once you delay the judgment writing, you never catch up again. During my time of studying, I think one of the lecturers at Justice College always reminded us, you have no excuse not to study. On a Saturday, there's 14 hours, and on a Sunday, there's 14 hours, so 28 hours, and that goes also for your work.
You had occasion to serve as the vice chairperson of the National Council for Correctional Services, and you later became its chairperson.
That is also correct, Deputy
How
Chief
long
Justice.
were you with that body?
I was there from 2015 until October 2019, so that was for a period more than almost 5 years.
Well, the comment, even from those who don't support your candidature, is that you did very well there. What exactly did you achieve? What is this tremendous achievement that everybody is talking about?
Well, can I perhaps just enlighten the Commission? The National Council of Correctional Services is really a very difficult body to chair. You consist, and the Minister knows best about this, that of a group of members that come from various backgrounds, different disciplines, psychologists, you have at the same time people from correctional services, you have community members, and you have experts in the field of prison law. So we come from different backgrounds and cultures, and it was a tricky horse to ride at times because you have to convince everyone that a certain person who serves a life imprisonment is either ready and reformed to go out, particularly in certain instances, you also have to reprimand members if they were not pulling their weight. It is a lot of reading. Some of those profiles is easily between 100 to 250 pages, and at times we've done 150 in 1 week. So yeah, that was... In the end, when I left, what made me feel good is that when we handed over to Judge Desai, he had a well-oiled machine, and we worked harmoniously as a group.
Wow. All right. Let's not waste any more time. You are competing with Judges Madondo and Boyodloati for the leadership position in the KZN division of the High Court.
That is correct.
Why should the JSC choose you over them? What do you have to offer? What plan do you have for that division, if any?
Well, if the Commission allows me, I will go straight over to my vision for the division before presenting anything else as to what formed and shaped me before I get to this point. Let me just start off by saying, Deputy Chief Justice, that whomever gets appointed of the three of us, will have to have as a primary focus to reunite us as judges and get us all to work as a team again. I firmly ascribe to a team spirit in people that I lead. And my first vision for the KwaZulu-Natal division is to transform it back to an efficient division, delivering justice timelessly, and also serving the public. Second issue that I consider as a vision is the issue that is paramount to any judge president's heart, and that is acting judges. You have a constitutional obligation, and in order to see to it that you have a pool of acting judges that are capable and competent, you must make sure that those candidates can be identified. Now, the way that we've always worked is we do have an acting judges committee whereby individual candidates will be evaluated, and we will make recommendations to the judge president and the deputy judge president as to who's suitable. So in my view, You should go further as the judge president because you have the opportunity to liaise and consult with bodies like the Black Lawyers Association, Natal, the Society of Advocates, and also the Legal Practice Council, but also the law faculty. In that regard, you would be able to at least make sure. I understand that previously there was indeed a protocol in place, and the erstwhile judge president have liaised with both Advocate Skinner from Society of Advocates as well as Advocate Ghani in Maritzburg, that candidates will, if there are anyone from the bar, that people will be consulted. Now, I think it's very important that consultation takes place when you invite people to the bench. The third vision that is very close to my heart is the vision of gender diversity. Presently, in the complement of KwaZulu-Natal, we have 28 permanent judges. Those are the judges that fill the position presently, and 11 of them are women, 17 men. I would be thrilled when we reach the point where we would be equal in number. The fourth vision is that you as a leader should never work in isolation. We are a collective, and as the judge president, you should not make decisions in a silo. When you have to collaborate with colleagues, and that does not mean, please, I just want to be respectfully say, that does not mean that the decisions must be made by everyone else. The day-to-day running of the division, the administration, judges should not be burdened with that. That should be the work of the judge president and also the deputy judge president. My fifth vision, which is perhaps very equal to the other visions I have listed here, is communication. Since the appointment of the office manager in KwaZulu-Natal, the communication has improved, but there is definitely a great scope for improvement. The manager is also just as strong as anything that is communicated to her. So it is very important that the judge president makes use of a good communication system, and through that, intertwined, is that judges should meet on a regular basis. In fact, since January 2022, we have not had a single meeting. And at times there are things that are important to discuss because it impacts on the work of the judges. So my vision is that one should be hands-on and you should meet with colleagues, debate and discuss issues so that you can move forward. 6 is, for me, which I also consider highly important, is that the distribution of work should be equitable and fair, and work should be allocated and assigned to judges timelessly. It should not be allocated at the last minute, whereby the judge is deprived of the opportunity to give it its best attention. In my view, that judgments get reserved, particularly where there is not sufficient time in preparation. And with sufficient time, Deputy Chief Justice, is not days or months, but it is most certainly not 5 minutes before a matter has to be heard. 7, the issue of delayed judgments in our division is something that is very disturbing to me. Any good leader will attend to this first because of the sole reason we are here to serve the public as judges. We have a constitutional mandate to do so. An analysis of the Office of the Chief Justice report here in September 2022 will reflect that we have 19 judgments on that list that's outstanding for more than 6 months. Some of them go back to 2012. Still not...
2012?
2012.
10 years ago.
Yes. 2012. We also have 25 judgments that have been delayed for a period between 3 and 6 months. Now, the non-delivery of judgments has a direct impact, in my view, on the confidence that the public has in the judiciary. The issue of reserved judgment is not an insurmountable challenge to overcome. What it calls for is strong leadership, and whereby the norms and the standards of the Office of the Chief Justice need to be enforced. With that, I say that, of course, any judge president will not just storm in and reprimand a colleague and report them. You will analyze the situation, but for me, judgments not deliver show a lack of compassion to the greater public, and also just simply disrespect to the litigants. We are here to do a job, and one of that is they entitled to an outcome of a case. I'm not, in this regard, I'm not a leader that believes in a reactive leadership style. I always believe in being proactive. My whole track record in the years of leading staff, you can have more success by being proactive and by planning. So in my view, if we have a performance committee, and these things I say as my vision, I can't just say that it will happen tomorrow should one be so fortunate to become the judge president, but you will discuss this with your colleagues. A performance committee can assist you and analyze and look at judgments that are reserved before they become a problem. And accordingly, by being proactive, you will avoid the embarrassment of sitting here and saying, my division have judgments outstanding almost 10 years. Very close, and maybe that's the teacher in me that speaks. The transferring of skills in any division is very important. Particularly since you're the judge president, when you design, and what I've done in the past in being the senior civil judge does the same. You run the division in the absence of the judge president or the deputy judge president. You're doing all the work, and you're also receiving all the flack that they normally will receive. Now, the way you transfer is by allocating work and distributing work to the younger judges. Make sure, and younger judges, I simply mean judges that have not been on the bench for as long as the others. Make sure that they've been led by colleagues who can finally teach them. And this is not a formal teaching, but you learn through the process of osmosis. It's done in that manner. I've learned from many experienced judges, and I'd like to say that other judges have learned from me at times. When you show them how to write a judgment, you assist them. That's how you transfer skills. The issue of case management is an issue I think that we're all very familiar with. Case management and case flow is here to stay, and I have a lot of good things to say about that. For me, you should just monitor that, and you should improve on the system that we already have. We have a very good team in KwaZulu-Natal, a support team in dealing with case flow, and it's definitely brought us benefit. And I think it's all to the advantage of the public. The modernization of our division and the way we work, well, at least I can say that all of my colleagues in KwaZulu-Natal, we're all computer literate, but we don't have a modernized system because sadly so, we don't have access in both of the centers to internet. In Maritzburg, there is a half-baked access, but in where we are presently in the Durban Magistrates Court, there is no access unless you yourself make sure that you have some access in one form or the other. So we cannot move forward. We're always lagging behind. And this is something that I think needs to be addressed as soon as possible, so that you don't have one province that is the stepchild of the judiciary. KwaZulu-Natal is big enough and should not be the stepchild. We're entitled to be treated like all the other children. The 11th kind of vision, and forgive me if I have a long list, in fact it's much longer, I've condensed it,
All right.
is I feel very strong about a formal mentoring program for specifically for acting judges. I have designed a mentoring program at UCT as a law lecturer. We had great success in having lecturers that mentor students, as we refer to the mentees. And ultimately, if we have, and I say this because presently we attract judges from different backgrounds. Not each and every acting judge have practiced in the High Court. Not each and every judge has been familiar with the practices in the High Court. And for that matter, if you have a formal mentoring program, you will ease their time in when they come onto the bench, and at the same time, there would be an informal teaching between the mentor and the acting judge. I do not foresee any problem in designing it, and every judge that is a mentor would be able to advise the judge president as to the competency and capability of the acting judge. The pool can just grow, and we will eventually have a far greater pool to choose from. If I'm permitted to just have one more vision.
Yes, yes.
I know that you've already run over time, but again, sometimes you have to dream, and I believe in dreams that can come true. We don't have in our division a dedicated family law role. Now, the plight of women and children are close to my heart. And again, this is not something that any judge will just impose on his colleagues. You will have to discuss and debate it. There may be opposition to this very idea that I'd like to have. But if we have a dedicated family law role, then most certainly the cases that involves children in particular will be prioritized. It should not be up to the senior civil judge or the judge president or the deputy judge president to grant preference in a matter, because access to justice means absolutely nothing if that access to justice is delayed. That would be my vision in short, Deputy Chief Justice. As I say, I have many other, but I will stop here.
That sounds like a terrific plan, I must say.
It's a long-term plan.
Yeah, well, let me just understand a few things quickly. You said, the very first thing you said was that whoever is appointed will have to work hard to reunite us. What do you mean by that? Are there
I think one needs to be...
divisions now?
No, I don't think that we are not united, but there is definitely a lack of team spirit. And for me, I've always strived to have team spirit amongst previously the staff that worked for me, previously even my council members. You can't move forward if you not all have the same goal and not striving to make a success of the division. You can also, I think where the problem lies is if we have a lack of consultation and a lack of meeting with each other, then you have these pockets that are doing work, but there's no team spirit. I've tried over the years, I know there's some of my colleagues that will crucify me because they're independent and they're not team players, but I believe that with a team spirit, you are just so much stronger than working in isolation.
Of course. And may I ask, why have you not had a judges' meeting for almost a whole year?
Why have I not?
why have you not had a judges' meeting for almost a whole year?
Well, I cannot answer that question, Deputy Chief Justice. That is up to the leadership of the division to make sure that we meet on a regular basis. That's one of the things that a good leader do. You meet with people, you give them an agenda, you have your points, and you debate the issues.
But the leadership of the court is just, is just one of the judges. He's chief among peers. Judges are fully entitled to demand a meeting if they need one. Why have you not asked for it?
Well, I can say that there are emails to that effect where that has been stated in writing. This particular topic is important enough because it impacts directly on how we perform as judges, and we need to have a meeting. I think the response was that I'm not going to enter into a power play debate. So in that regard, Deputy Chief Justice, you cannot take the matter any further.
Yes. And you have a plan about improving the manner in which acting judges are selected. I imagine that what you suggest does not happen. The manner in which it is done is not optimal.
No, it has not happened. Let me elaborate on this. I serve on the committee of the acting judges. In the beginning of the year, shortly thereafter, we met and we decided that we need to revise the criteria for acting judges. And there's a reason for that. We need to be transparent. We need to tell, when anyone is asking us, why have you not invited me to come and act? You need to say, well, do you meet the criteria? Have you been in the profession for longer than 12 years? Do you have a good standing with your profession, et cetera, et cetera? So it took quite some time to draft that criteria. And the next thing that was then clear is it's chaired. This committee is chaired by one of the other senior judges, Judge Pillay. Was that there was already a document sent out to the professions, and that one cannot tell the leadership how to deal with this. So this is very important. I think we have committees for a reason. That is not infringing on the prerogative of any judge president or deputy judge president. It is simply to assist and them in their task. That is what it is. So yeah, the criteria that went out was not the criteria that we've all discussed, debated, read the Bangalore principles, etc. This wasn't, yeah.
The issue of delayed judgments that you mentioned is the most concerning, and you spoke about enforcing an equitable, fair, and timeous allocation of work.
Yes.
And you mentioned something which you all know is true, that if you give people work late, then they don't have time to prepare in advance, and if they go to court blank,
yes,
blindly, then it means they are going to have to read the record after the hearing, and it's going to take time to get a judgment out. Is that what is causing these delayed judgments in the division?
No, I don't.
That work is not being given in time?
Sorry, Deputy Chief Justice. I don't think all of those that are delaying judgments can claim that. I'm simply saying that by being proactive, if you give judges sufficient time, then they would be able to be ready and deal with the matter. I don't ascribe to a method where a judge is sent to court without having read a file, without being able to engage with counsel as to what is this matter all about. That is embarrassing for the judiciary, and we should not operate like that as judges. But what I do think is what has been done about all of these outstanding judgments, and why have they not been delivered? I have, at the time when I served in other divisions, I have had the opportunity to serve under 8 different judge presidents. And I have learned a lot from their leadership. I've also learned a lot what to do and what not to do. And I most certainly think that where a good leader sometimes will take a judge after you've given him or her a complex case for a day or two out of court so that they will be able, when things are fresh in their mind, write it down and move forward. That way, you sort of make sure that judgments get delivered sooner rather than later. I don't think it's justice when you wait so long for any decision to be made.
Of course. Oh, well, let me stop there, otherwise we'll take all day. I just want to bring two things to your attention before I hand over to the rest of the commissioners. One of the law bodies, the Law Society, has made an observation about you, which is not positive. They say you have not enhanced the spirit of collegiality amongst your peers and members of the legal profession who've appeared before you, but there's no detail. Do you know what that is about, and do you have a response?
Deputy Chief Justice, let me respond. I think it reads something that we have been advised. There is no detail, there's no substance in that allegation. In fact, in the 42 years that I have worked from the age of 18 till now, I have never been accused of someone not being collegial. My chambers at times being considered a central station. Colleagues are always flocking there, asking for advice, going away. I have good relations with all of my colleagues. So I was deeply hurt, but also stunned by a hearsay allegation. In the 15 years on the bench, there's never been a complaint about me to this commission. No, I'm lying. There was one complaint I forgot one complaint. That was a prisoner, Mr. Christmas, who said that I should have not dealt with, I should have made known that I cannot deal with a matter where I was the second respondent because it was the National Council of Correctional Services was the second respondent. And of course I could not deal with that matter. And I've alerted timelessly the Judge President, I cannot deal with this matter. I'm second respondent. I know everything about Mr. Christmas, and the matter was not reallocated to anyone else. And on that day, I had to inform him that I cannot deal with this matter. So that was the one and only complaint. But never, ever has anyone, I've never been complained about to the Judge President. As you know, at times we as judges, especially when you're strict in your court and you're firm about certain things that should happen, the people will go to the Judge President and complain and say, I did not like the way that Steyn treated me today in court or whatever. I've never once had a complaint like that. I'm sitting here not knowing what that statement is all about.
All right. Lastly, the BLA has written a very complimentary comment on you and glowing terms about your leadership at the NCCS. But then they say because you have not acted either as the Deputy Judge President or Judge President in this division, or anywhere, I suppose, they don't support your appointment at this stage and, would rather you had an opportunity to act first.
Yeah.
How would you respond to that charge?
Can I just respond as follows, Deputy Chief Justice? You can only, first and foremost, act in the position if it is decided by the person who is in charge to put you in that position. So that is my first comment to it. But the second comment is that as the senior civil judge, you are the de facto JP or Deputy Judge President. You're either in Maritzburg or you are in Durban, and you are in charge. You draft the roster, you allocate the work, and you stand in, negotiate with the staff, you do all the work. So I think it's simply because they look at the title, but they don't look at the experience of whether one had any exposure to that kind of work of leading the division.
The previous candidate mentioned that you have judges' committees, that look into the running of the different facets of the division, which she said have not been active. Have you participated in those when they were active?
Active in what manner? Sorry, Deputy Chair. I didn't listen or to my previous colleague's interview.
No, I was just saying, she mentioned that you have judges' committees, which is usual in all judges, in all divisions of the High Court, including the FCA, that you'll have a finance committee, a housing committee, and so on, where judges, they take initiative in the running of their own court. But she said that yours, and she supposed because of the disruption caused by COVID, have not been active in a while. Now, I wanted to know, because I know that one gets administrative experience from their involvement in those committees. Have you had an opportunity to participate in them when they were active, whenever that was?
I've participated in many committees. I've been chairing the budget committee, where you have in-depth insight into the cost running of the division. I have also chaired the research committee, where you have to evaluate and appoint researchers to the division. I've served in as I've indicated, the acting judges committee, but moreover, I have been, and that is post-COVID. So the statement is not quite correct. Let me just say that post-COVID, the decamping or decanting, as the Office of the Chief Justice have listed as committee, had met on numerous occasions. If it wasn't for those meetings and pressing for the needs of judges and what will be required in the new building, then we would have been even worse off than what we are today. I'm pretty sure that the JSC knows that the Durban High Court is presently renovated. So in order to move the Durban High Court to the Magistrates Court, we as judges had to meet on a constant basis, and we were in this committee was Judge Kruger, myself, Judge Wyatt, Judge Olsen, and Judge Khadebe. We had to give our time and efforts to this and ultimately draft long memorandums with the assistance of Judge President Mlambo, who assisted because our JP at one stage withdrew and he didn't want to serve on this committee. And we had various run-ins with the Department of Public Works, with the members of the Office of the Chief Justice. I think the last time two of the CEO and the COO had told the staff not to let the liaison committee, as they then reduced us to, be informed of anything that's going on for the judges. So essentially, this is why we're sitting here today, and there are only 14 chambers for the judges on the ground floor and 4 other chambers on the 12th floor. We are split, and it leaves us a disjointed sense amongst us judges. Also, if you look at the list of judges and you look at who are the 4 judges that are most junior, they are now separated. It's almost like a segregation, which I definitely do not ascribe to, but it is because our views were not taken on board by the powers that be, and eventually this is where. So yes, that committee has still been very active post-COVID. In fact, we have been to sites, we have put in a lot of work, and I think that knowledge is very important in taking the division forward, because we will have to move back to the High Court. And who will know? Who will have the institutional knowledge of what is going on there? I can tell you that 3 of my colleagues on that committee will by then be retired, and because they will soon retire. And that's where that knowledge has become very important in how we operate, yes.
Yeah. So in sum, you have actually been involved in the running of your court?
Yes.
Thank you very much, Judge Steyn. Judge Mngadi?
Thank you, Deputy Chief Justice. Good afternoon, Justin. We have met outside before you came in and we greeted each
Good
other.
afternoon, Judge Ngadi. We did meet indeed.
Thank you. Well, maybe before I ask some of my questions here, I'll just, you have mentioned a number of things.
Oh, I'm sorry, Judge Ngadi. We are going to impose the same rules that apply to the rest of the commissioners. Only 2 questions from you. And that goes for Commissioner, she's a commissioner while she's sitting here, Commissioner Smelane as well. 2 questions for everybody in the room. You've been warned. Carry on.
So my first question, Judge Stein, will refer to the things that, according to you, they seem not to be attended to in the division. I'll mention it
Sorry,
just a minute.
I didn't hear the first part, the things.
The things that, according to you, they appear not to be in order or not being attended to in the division. I will mention those things, make a comment. That is my observation relating to that issue, and then I'll move on, not allowing you to comment on that because I'm allowed only 2 questions. The first thing, you talk about reserve judgments.
Yes.
My understanding of this is only that out of about 28 judges in the division, is only about 3 colleagues who are having a high number of reserve judgments. And secondly, I'm well aware that even the previous JP, or even the JP before that, made a lot of effort to put pressure on these colleagues to deliver their reserve judgments. And I'm aware that, although I'm not certain, but at least some of those 3 colleagues, they have already been reported to the Judicial Conduct Committee for failing to deliver those long-standing reserve judgments. Secondly, you refer to the issue of no meetings being held. Firstly, I'm well aware that because we have got 2 sort of divisions, Pietermaritzburg and Durban, so there are logistical problems in arranging a meeting of all the judges. And the standard practice is that in each and every December, there will be a meeting of all the judges. In the interim, it's only if there is an issue which is urgent and which really needs that all the judges, they should be called in one and the same meeting. And again, in these meetings at times, as we pointed out, there are issues of other colleagues abusing those meetings, power plays, and all that, no progress being achieved by calling a meeting. But the current, even the previous JP, Japi, and the current acting JP, they have got an open door policy. If he is in Durban or in Pietermaritzburg, you can walk to his chambers at any time and discuss openly with any issue you want to discuss with him as a judge. You are given respect and he accepts you. And again, on each and every issue, he communicates with all of us, the judges, by email, and even give us time within which to respond or make an input. So that is indeed being attended to. And then talking about judges, if you say there are judges who are permanently appointed, but they need to be guided to write judgments, I don't know what you are referring to. Then you talk about team spirit in the division. Again, I'm not sure what you are referring to, because by nature of our duties, we as judges, I will only work with you on a matter if I'm sitting with you and we are dealing with those matters. Otherwise, I'm not sure exactly what team spirit you are referring to, but I regard myself as a junior judge in the division. I can communicate and discuss a matter with any judge, even the most senior judge. And if I'm sitting with him, I can dissent if I'm dissenting in his matter, and there will be no ill feelings. And again, amongst colleagues, even previously, I pointed out that, in my view, there is good working relationship between senior and junior colleagues. So I don't see any problem. I don't know what team spirit you are talking about.
DCJ.
Is that Commissioner Singh?
Sorry.
Bernard?
It's Commissioner. Barnard, sorry to interrupt Judge Magaji. Is there a question going to be put to the candidate? Because we are late in the day already.
No, there is a question at the end of what, after I've pointed out, relating to what she raised. And then I move on. We are talking about the acting judges committee. This committee, my experiences was acting as a gatekeeping exercise. Whereas the leadership of the division, including the previous JP, they tried to open it up in the spirit of transformation in the division, that they must consider even candidates not recommended by this particular committee. But they did not ignore the committee totally. They still took into account what was recommended by the committee. But the committee felt that they had a decisive decision regarding who is supposed to be appointed as an acting judge, which indeed, in my view, that was completely not correct. And then,
Judge Mngadi,
and then
would it be
referring
safe-
to the issue
Judge
of...
Judge Mngadi, would it be safe to assume that you dispute everything this candidate has said? Because we really don't have time to go bullet point by bullet point through everything that she
But
said.
I can't understand it, Deputy CJ, because she was given a chance, bullet point by bullet point, to go through all these points. If I, on behalf of the division, am not allowed to respond to that, and then I can't understand what is the use of the exercise.
What is the question? Because I have yet
But I'm
to hear a
responding
question.
to what she raised as issues relating to the division. And I'm
Please,
about to
we
finish.
ki-
If you can
kindly
allow me
ask-
2 minutes.
Kindly ask a question of the candidate, because up to now you have not asked a question.
Thank you, Judge Stein. And then again, you refer to that matters are not given to judges on time, which result in reserved judgments. Again, I don't know what you're talking about. Because if it's an opposed application, I receive the file about 10 days before the date of hearing. And if it's matters which are on the motion court roll, I receive the files about 2 days before the date of the hearing of the motion court rolls. And again, you talk about the liaison committee relating to the renovation of the Durban High Court and relocation to the Magistrates Court of the judges. I was involved in the process, and in fact, it was driven by the leadership of the division, in particular Madondo. The liaison committee, they were resisting the relocation. They were raising a long list of issues, and then that's when it came to a stage that the leadership decided that in order to have progress in the matter, then all these concerns, a long list of concerns raised by the liaison committee, they should not be attended to. And then even now, as we are talking about, that renovation is in progress in Durban, and maybe in about a year's time or so it will be completed. I don't know whether you then want to make maybe a comment on that before I move to my second question. In fact, I have not been allowed to answer any questions.
Judge Stein?
Thank you, Deputy Chief Justice. If I may, in short, respond. The last question, well, two of the things. Judge Mngadi is referring to as to what the acting judges committee wanted and what the acting judge president had said. As far as I'm aware, and that is in written communication, is that an email was sent by the acting judge president to the chair of the committee. Judge Mngadi has never been part of the acting judges committee, and most certainly have also not been part of the communication. So I'm not aware whether he's in possession of the email, but of course, I'm a stickler for rules, so I have all correspondence here available, and if need be, I will read exactly what has been stated in there. That's the one issue. The second issue as to the liaison committee, and I assume that Judge Mngadi respectfully is referring to the decamping committee. Let me also just say that the Judge Madondo was quite willing that Judge Mlambo, as JP, could assist us in all of this. In fact, the whole impasse came because Judge Jappi was not prepared. and let there be
Just
light.
give it a minute, it will come back.
Thank you. May I
No,
proceed?
not yet. We need to make sure that the commissioners on the virtual platform are also on.
Okay.
We are here, DCJ.
You are?
Yeah,
Okay.
yeah.
Then carry on, Judge Steyn.
No, we hear.
Okay. May I proceed with,
Yes,
with
yes.
your permission? Thank you. The issue is, and I need to be very pertinent about this, and with respect to my colleague on the right, he was appointed in June 2018. That's the time when you were appointed. As for indicate you, one of the things that a member of your team will do is walk up to you and say, Judge Mngadi, I've noticed that none of your decisions are reported on SAFLI, and you are going for your interview to the JSC. It's important that they can read your judgments. That is a kind of team spirit that I'm referring to, where you assist your colleague, where you help your colleagues, and where these things have then been dealt with. But I want to go a bit further than that. And that is the fact that meetings are abused. Since January 2009, we've always had, usually termly, orderly meetings. We've had agendas, we've had minutes, unfortunately, that fell on many of us females to be the minute taker. And these meetings have never ended up in any division. In fact, we talked frankly and we debate the issues. That's what lawyers do. We debate issues. Those are the things. I'm sitting here with the last meeting and of the 3rd of December 2021. That is one which you did not attend. And the decisions all relate to the work we do in the division. So meetings are important. It's not a matter of dealing with going to a senior colleague or the deputy judge president or the acting judge president to go and ask for advice. It is sometimes things that need to be a collective to decide. But you've now raised the issue of you've always received your opposed motions timelessly, at least 2 days. Of course it has to be given 2 days before it. But recently in this year, will it surprise you, Judge Mngadi, that by 5 to 10, I've received an opposed motion. The council were already waiting in court, and it was never allocated to me on the Friday afternoon, never. So what can a judge do but walk, and that simply is by running your division. You need to be proactive. You hand out these things without embarrassing your judges. It is not a difficult task. I've done it so many times in my life. So I believe in the paper trail. So I have, again, also the matter. It was the 22nd of March. I have the case number, the counsel, and what happened in court. So, yeah, if you were so fortunate to always receive it on time, let me just say that there are a number of judges who were not so fortunate.
Thank you, Judge Steyn. Commissioner Simelane?
Thank you very much, DCJ. Good afternoon,
Good afternoon,
Judge Steyn.
Commissioner.
I will try and save you time, maybe just ask one question. Judge Steyn, in your understanding, what is your understanding of the term transformation of the judiciary or transformation of the bench, which is often used quite loosely between the organization, your PLA and Natal? So firstly, please explain what is your understanding of the term. And as far as you know, as my second question, is our division transformed in light of that definition? Thank you.
Thank you, Commissioner. Let me just start off by saying that my understanding, please forgive, I'm going to give you my understanding. My understanding of constitutional transformation, first and foremost, it's not an easy question to answer, Commissioner. What I understand as transformative constitutionalism is infinitely more than just a question about race. Our constitution recognizes the reality of all of the where we come from in the past, and so restructuring and transforming the judiciary should be aligned to the values of the Constitution. That will be my first issue to raise. So, any judicial system that holds sacrosanct the values of equality between the sexes and also race will not discriminate against any group regarding that. Section 9 of our Constitution guarantees equality and prohibits race or discrimination. And coupled with equality, Commissioner, is that concept is deeply rooted in the concept of human dignity. I will acknowledge this. I will also acknowledge upfront that in the past, citizens in this country were denied human dignity, and it caused severe hardship. However, bearing in mind, in 2022, with our democratic order, with our constitution, a policy that will never allow a particular member of a particular gender or particular sexual transformation or a particular ethnicity group to discriminate on that basis will offend against our Constitution. You've asked me whether our division has been transformed. At the moment, most certainly, if you look at the number of women on the bench, then I've indicated that we're still lacking behind. There are more men than women. When you look at the racial composition, well, since 2009, I've been the only white woman on that bench. There is, again, more of my, if you look at the Indian and African, and I think as sisters, we don't really look at that because then we're immediately busy counting little blocks. Our division is most certainly transformed in the manner that we consider the human dignity of those that appear before us. So transformation is not simply a matter of looking at and ticking certain boxes. It is by far more than that.
Thank you, DCJ.
Right. Commissioner Nyambi?
Thank you, DCJ. Afternoon, Judge Steyn.
Good afternoon, Commissioner.
You are aware that we have interviewed two judges with solid experience like you.
Yeah.
What qualities do you possess that will put you in good stead to triumph over them that we must seriously consider?
Okay. I thank you for the question. My qualities lies in my leadership ability and my track record of leadership. As indicated at the onset when I listed my vision, I didn't get the opportunity to explain to you my leadership qualities. My leadership qualities is I've been a leader since a very young age. I've been the head girl of my school. I moved into the Department of Justice. I've moved through the ranks of it. I've been a senior a magistrate with lots of experience, and then a senior prosecutor, and later on also in my work at UCT. I've been recognized by chairing various committees. I've been the chair of the and mood coordinator. I've been serving on the appeals court of the university. I've served. So my leadership qualities are really developed for a long time. But one thing that I have not shared and had the opportunity to express to this commission, because I haven't given a presentation of it, I have served on the Jali Commission as a commissioner, investigating sexual harassment, maladministration, and corruption. And in the commission itself, which was very difficult, I have, my leadership skills have been honed. I have served under Judge Charlie, who has been a great mentor and has guided me, but moreover, I have developed over time, and when I moved to the KwaZulu Natal division, my judge president, Shabalala, at that stage when I was appointed, was way ahead of his peers. He empowered women long before it was good to do so. When I arrived in KwaZulu-Natal, shortly after I've arrived in 2011, he asked me to chair the forum, and let me just say it was called the Provincial Integrated Justice Forum. It was a precursor to the Provincial Efficiency and Enhancement Committee that we have now in terms of the Superior Court Act. I've chaired that. All the stakeholders that are presently in the PEC were all represented at that forum. Eventually, by the end of 2012, I handed it over to Judge Jappi because I was allocated and assigned a very difficult criminal trial. And soon after that, the Superior Court Act came into operation and things changed. So the leadership qualities I'm bringing to this division spans over literally more than 40 years. I have excelled at UCT. You don't normally, and it's not a few, I think there are a few of you that are from the academia, would understand that in order to be bestowed a prestigious award like the Distinguished Teachers Award, it is an award that gets awarded across the disciplines of the university. And they consider and evaluate you about what you had brought to the curriculum, what leadership you had showed that went beyond teaching. So I have done all of that over a long time, and I most certainly have done so also in the time when I acted as senior civil judge in KwaZulu-Natal.
My last question. I listened to your vision, and before I can conclude that I got lost when Judge Mgadi raised the counter view. So if you can share with us your best and worst moment as a judge in KwaZulu-Natal High Court Division.
I was really hoping you wouldn't ask me that question. I think the worst experience in KwaZulu-Natal was losing a very dear and near colleague who sat here in front of you in 2016 to become one of these leaders, Judge Nguni. I think the shock and horror in the division of his untimely passing last year in September left us all with a sense of grief, particularly because the wellness of judges ought to get more attention than what it is presently getting. That for me was the worst. As for the best, I think for me the best is when staff members, and I'm not speaking of people with important titles, come to me as Ma and look at me to assist them in doing things, empowering them to study further, help them with their assignments. Those times are far greater than any other accolade that may come your way. I'm a very simple person, and I really get joy from those things by serving people more than anything else.
Thank you, Judge Stein. Thank you, TCJ.
Thank you, Commissioner. Commissioner Matolo-Tlepu.
Thank you very much, Deputy Chief Justice. Good.
Oh, sorry. Yeah, it is actually your turn. I called her out of 10. Carry on, Prof.
Oh, thank you very much. Good afternoon, Judge State.
Thank you, Commissioner. Good afternoon.
I have two questions for you, but let's start more with a more substantive one. And I'm asking this in relation to your experience at the magistracy and as a prosecutor,
Yes.
as well as I saw that there's a judgment that you penned some time back. I think it's Naidu versus Chetty. I'm not sure if you still remember that, dealing with domestic violence, but it's fun. I wanted to deal with that, but anyway, if you don't remember it, let's ask it more broadly. In practice, there seems to be a manner in which magistrates, in particular, deal with domestic violence cases, where they issue interim orders, and of course later on they confirm them. And some of the orders that they provide will be that the alleged perpetrator should actually be removed from the complainant, right? And you might find that the perpetrator and the complainant are actually residing in the same place. I just want to hear your view, whether is there any conflict in relation to how the domestic violence is actually carried out or implemented with the right to housing of the people who are actually being evicted without an application for eviction being brought to them. Is there any conflict there? And if there is, how can we resolve this issue? Because on the one hand, you want to make sure that the complainant is safe. But on the other, to keep the complainant safe, one of the ways is to remove the perpetrator. But the perpetrator also has constitutional rights to housing, not be deprived of their home and all this. How do we resolve that particular conundrum?
Thank you for the question. I think there are various cases which we can focus on of domestic violence where the perpetrator has not been removed, and we ended up with a person on the other side that passed on, because the violence escalates to the point whereby women get killed, and I say women because it's mainly women who are at the receiving end and are the victims of domestic violence. It is a very difficult question to answer, because you are dealing with two competing rights. Do I consider the right of the person that has to be removed, or do I consider the right of the wife and the children? And which of these two rights will trump each other? For me, it really falls down on a practical level to the safety of the family first. But I also, in the same breath, would like to say to you that we see sometimes when there are interdict applications later on, and you hear that there was a previous domestic violence order, you will finally see that the problem that you have is that it also gets abused. We are busy with a divorce action, and one of us want to benefit from this. So it's not, in that regard, I do think that there are various NGOs that do great work, and it is really a socioeconomic problem as to how we address that. There is no easy answer. I'm sorry.
No problem. Something that is really in my head as well. But I appreciate your answer. The second question that I have for you, when you were stating your vision, you sounded to me as a person who has a lot of complaints with what is currently going on in the division. And I'm not sure, I'm not saying that you have. Mm-hmm. I'm just saying the way I perceived what you said. I just want to ask, because the thing is, there are two leaders. Well, both of them, they are actually on an acting capacity, right? The people who are making the leadership crop. Do you believe that these two leaders are bad leaders, and they have not done what is supposed to be done to address some of the concerns that I thought came out from your vision? Not having meetings and all those things that you mentioned, that your colleague on the right wanted to respond to.
Let me first and foremost say, when I articulated my vision, It is not an indication of a complaint session at all. It is the vision I, as a leader, have for KwaZulu-Natal. I would do certain things differently. So the way to deal with one's vision is to say, here is my plan, this is what I will include in my plan, and if I ever come back to you, I will say to you, I either had success or I did not have success. So no, if that was the way it was understood, I want to categorically state here that this is not meant. I'm not here today to criticize any of my colleagues. That will go against the harmonious work that we can do as a team, and that will go straight in line with what I say, that one has to have a team spirit. So no, there's no complaints. In fact, in 2016, I've assisted Judge Madondo. We had mock interviews in my chambers. I've reached out when he asked me to help him edit the traditional court book. You will see there's a thank you note for what I did. I have nothing against either him or Judge Poyo. In fact, Judge Poyo and I have always been good friends. Yesterday, we were on the same plane. We were taking selfies when we landed. So I literally have a good collegial relationship with both of them.
No, thank you very much, Justine. Thank you very much,
you.
DCG.
Thank you, Commissioner.
DCJ, follow up, please.
Yes, Commissioner Bernard?
Thank you, DCJ. Justine, you earlier mentioned that that by the one incident where by 5 to 10 you received an appeal motion just before court, and in other words, in short notice. Now, that specific problem is clearly a problem for you. Did you take that up, that sort of trend of allocating the judges, matters with short notice? Did you take that up with any of the two leaders to try and sort it out so that it would not be a problem here today?
Thank you, Mr. Barnard. You're referring to two leaders. There was only one leader when it happened. I indeed was looking for the leader on the day that it happened, and by the time I went to the chambers, he was not there. I have taken it up, indeed, so it's a known fact. Previously with Judge Madondo, when he was still very young as the Deputy Judge President, I remember very well, I was in motion court on the Wednesday, and the Monday afternoon in Maritzburg at 4:15, I left 4:30. His secretary called and says that you have an opposed motion for tomorrow. And I said to her, but I am in motion court on the Wednesday. And so the Tuesday I went to him and I said to him, we cannot work like this. We should receive things timelessly. And this is what happened. And he says, Esther, it won't happen again. So we've definitely talked about it. And I want to assure you, I'm not someone that bear grudges. I deal with the issue straight on. I believe that this is the way to resolve conflict, is to rather talk to your colleague than wait until it explodes in a big thing.
Thank you, DCJ.
Thank you, Commissioner Bernard. Commissioner Matolo Lepu. Oh, sorry, Commissioner Moimang.
Thank you, Deputy Chief Justice. Just two from my side. The first one relates to one of the judgments that you have referred, Judge Steyn. Good afternoon.
Good afternoon, Commissioner.
Yes. The first one relates to one of the judgment, State versus Zuma. And then the second one will be the matter of the acting policy.
The acting policy, sorry. I did
Yes.
just, yeah. Okay.
How did you resolve the three areas that were identified in this matter of Zuma, where three issues were raised? The issue of the NPA having acted outside the scope of its powers, and then two, having acted in breach of the NPA prosecution policy.
Sorry, I didn't hear that. The NPA policy, yes?
Yes, and then the third one, that their decision was irrational. How do you use the values enshrined in the Constitution, like the rule of law and also the supremacy of the Constitution to maneuver around these areas? The second one on the policy, I just want to get clarity as to that. Did you say that there is no draft policy that guides the appointment of the acting judges? And if there is none, what input can you give us to ensure that there is clarity in terms of guidance around the acting policy? Because I thought there was a policy adopted that was guiding the appointment of acting judges. Thank you.
Thank you. I will start with the first question first. It's always difficult to go back to your decisions that you have made, and particularly because we've made it also as a bench. But you would have noticed from my list of publications that I've been fascinated, besides my background, but how the new National Prosecuting Authority Act, the 1998 Act, will find application. And again, I've published with Professor van Zyl-Smit in critiquing the Act. So when the matter was argued, certain parts of the judgment, as much as we did that as a collaborative, we divided. And we've literally tried, and so once you write it as a court, as you know, particularly because here you don't have a scribe and then you have 4 judges concurring. Here you have the whole court. So the judgment remained the judgment of all 3 of us. So it would be very unfair of me to claim any part and try and explain anything. But I can tell you that if you look at the articles written, it was unfortunate for us also that counsel for Thales has also read this article that I've written in my previous life when I was an academic, and was constantly referring to this and making submissions, which literally placed you in an invidious position. But one has tried and balanced it. The undue delay of cases and whether there should be a stay of prosecution ultimately was the most important one in the Zuma matter. And then coupled with that, there were the aspects of whether Mr. Sean Abrams acted unlawfully when he considered to reinstitute charges not only against Mr. Zuma after the earlier withdrawal, but the SCA decided on that. I will call that the Miché withdrawal, but also the position then as to how Thales now came back into the play. So under those circumstances, one have tried to balance the right to a speedy trial, but also the conduct of the NPA and the lawfulness of the conduct. And I'd like to say that we've worked through all of that and balanced all of that. Coming back to the issue of whether there is now a document regarding the criteria of acting judges, such a document indeed went out to the profession. I think the complaint, which my colleague on the right, Judge Mugadi, referred to, was the fact that that document was the document that was drafted not by the committee, but by the acting judge president. I have to say that the acting judge president, in his response, and I have to defend him here, he did say that he consulted with the acting deputy judge president, who's also a member of our committee, And that wasn't made clear to us. So I need to defend Judge Madondo in that regard. He did say in that email that he discussed it with the acting Deputy Judge President. I hope that answers it.
Thank you, Judge Steyn. Thank you, Deputy Chief
Thank you,
Justice.
Commissioner.
Thank you, Deputy Chief Justice. Good afternoon, Judge Steyn.
Good afternoon, Commissioner.
You have applied for a position of Judge President, and I'm just thinking. I listened to your vision, as Commissioner Marumokha says. It was a bit of a inward looking about your division, what is happening. I just wanted you to tell me, for me to be comfortable, that your appointment will actually bring a difference to the province. Firstly, I just want to, because I see the GCB, they say, one of the things they said, you are very proficient in English, and KZN, the majority of people speak isiZulu. Can you do that? Can you speak isiZulu?
Is that the question?
Yeah.
Commissioner, let me just say that inherently language is a sensitive issue, and it is very much dependent on your environment where you grew up. I think only Commissioner Lucas will know where I grew up. I grew up in a small town place called Kennard in the Northern Cape. So I speak, in fact, English is not my mother tongue. I'm very flattered by what the GCB says. I'm Afrikaans speaking. English is also my second language. I've also learned a little bit of because it was compulsory German for 3 years, but I can't speak the language. As for isiZulu, there need to be a desire also to learn the language, and that desire developed with me when my secretary, Tobeka Zungu, Ni Zungu Samalani now, started working for me, and I really wanted to learn the language. I've started off by having the great R books from isiZulu. I was not successful in that, and then there was COVID. And she has a lovely son who visits me at times, so I have now ascribed to a new program. It's called Duolingo, and I'm making huge progress. I could impress at least a 4-year-old with telling him about some of the animals and things, but I'm far from being proficient in isiZulu. But it is definitely my aim to do that, because every time I'm invited to functions where one of my friends have to translate to me, I want to know firsthand what he said, and I literally can't wait for the day when I can. I've now tried when people are greeting me in English, and I say, why don't you say to greet me in isiZulu, in my own province? So this is a work in progress, and I hope to at one day meet with you again and say, I can now speak the language.
Okay. A follow-up question. You know, KZN is a rural. There's a lot of. It's a rural. There's a lot of rural places, and one of the things why I would support you is for you to make sure that women in rural areas get access to justice. And from your vision, I haven't heard that much, that how are you going to bring access to justice to the rural women who really need it, not the issues in your court, but that's the reason that will motivate me to support you.
Thank you, Commissioner. Access to justice is paramount for every person. KwaZulu-Natal is a vast province. One thing that one should bear in mind is that the access to justice is already, if you look at the list of the regional courts, there are 76 regional courts in the province of KwaZulu-Natal. There are 4 more who are dealing with backlog cases. So the judiciary is going out to the people. Bear in mind, as the judge president, it is your duty also to coordinate the lower courts, and you have to liaise with the heads of the lower courts to make sure that there is access to justice. We have circuit courts that go out, but let me just be frank with you, and I'm not just listing any problems, but sometimes one must also list these things so that can improve. Most of our circuit courts, and that's not putting blame anywhere, we receive this from either the Department of Justice or the Department of Public Works that are not doing what they're supposed to be doing. So you have a circuit court in Matuba, you have no water there. You have another circuit court in Scottsboro where the judge running the court will have to wait for the regional court magistrate to first finish his court before she can go and deal with the cases of the High Court. That is not access to justice. It has to be more. But I firmly believe that one has to go out to the people. We are here to serve the people. And the first thing is that if one is in charge of this, that you go out to these 76 regional courts and you also see whether there is not need for more. That's not infringing upon the rights of whoever is in charge of the lower courts. That is simply making sure that everyone has fair access to justice. So I'm fully agree with you, and this is also why I've referred to the family law court. Access means nothing to the people unless they have truly access to justice.
I could go on and on, but thanks, Judge President.
Commissioner Bernard, did you exhaust your questions?
No, DCJ, I have questions.
All right, go ahead, please.
Thank you. Judge, while setting out your vision, you stated the plight of women and children is close to your heart.
Yes.
Now, when there's litigation on behalf of a minor, and it's run for a number of days, if in mid-trial then there's this, the matter of recusal comes up, what factors should a court take into consideration, and how should the process unfold before the court makes a decision on recusal?
Okay. Thank you, Commissioner. You referring to a matter that is presently ready to go on appeal, since leave to appeal has been granted. So I will try and not say too much so as to influence any appeal court that will have to deal with it. Let me start off by saying how seriously I take the plight of women and children. When I joined UCT and had to decide on a dissertation, without hesitation, I decided on witnesses, the stepchildren of the criminal justice system, and I focused on rape victims and child witnesses who did not get what is be expected from them. So this is not something new that I consider the plight of women and children. It has been with me all my life, wherever I've worked. To bring it back to the matter, what was given to the matter in this particular case was just, in short, excerpt from the trial, which is clearly not indicative what happened throughout the trial. When one considers any recusal, and let me say this up front, in 21 years on the lower and high court bench, I have never recused myself. This was the first time that I had to recuse myself. And one reason why this is so important, you as a judge have to be impartial at all times. And if you look at the code of conduct very clearly, and also to the case law and the jurisprudence as it developed around it, a judge must recuse him or herself from a case if there's a real or a reasonable perceived conflict of interest, which wasn't in this matter, but a reasonable suspicion of bias upon objective facts. Throughout this trial, certain objections were made, certain things were said by the counsel, and ultimately it led to the point of, on this specific day, irrespective of who the plaintiff is, this plaintiff is entitled to have an impartial, unbiased person presiding in this matter. At least it should feel for the plaintiff. She should perceive that. And in this matter, once the final straw that broke the camel's back was when counsel stood up and after the objection say, the court will decide in favor of the other side. There was no pronouncement of any order that will be made. I've adjourned the matter. I've seriously reflected on the matter. I've discussed it with my judge president. I sought jurisprudential leadership. I discussed it with some of my senior colleagues. But none of that is their decision. I went back to my chambers, and I thought there's one way of solving this. Maybe if one offers to counsel to withdraw that, one can again restore the impartiality, at least for the party, the litigant. It will appear that you are still unbiased and impartial. Unfortunately, I could not salvage it. I offered it to the counsel, but he did not take it. So it's not clear to me whether you're aware, Mr. Barnard, that on the 26th of July 2021, a letter was received by my chambers. Have you seen that letter?
No, I'm not sure that I'm
Okay, can I quote to you, because this refers to the case that you've said, and I'm just going to quote without revealing the identity of the senior counsel, but this is what it says. Your judge recused herself, citing my conduct. Quote, that conduct has been the subject of disciplinary proceedings before the Society of Advocates of KwaZulu-Natal. I was convicted of unprofessional conduct. End the quote. So I wanted to say to you that this was something that went over days, and it reached the point where no litigant would believe reasonably that I'm bringing an unbiased mind. And it would not be fair to that plaintiff, because that plaintiff may very well be in a position where you should decide in his and her favor. This was a her, and it just didn't happen.
Judge, where I'm coming from is from the position of someone who's in leadership and is leading the court. And my question is going in this direction, in the sense that you adjourn the court and you come back into court and you make a remark, something like, does the counsel have something to say? But then what happens is there's without asking the parties to address you on it, a recusal is ordered. And that's the big question here, is when you're in a situation, even as a leader, even out of court, anywhere, and you have these difficult parties, and I'm accepting, even just on a short reading of that record, of the extract of that record, I'm accepting there's unprofessional conduct by one of the legal practitioners. But the point is this, is that before the court orders recusal, there's no opportunity for the parties to address the court, and there's a child involved. That postponement could probably created a delay of I don't know how long, and the child's rights can't be enforced, whichever way the court would go eventually. And then there's even legal authority for it that one should. There's I don't know if you're aware of it, the authority going back as far as 1952, which says the grounds of recusal relate purely to what happened in the course of the trial. Neither counsel has been able to find any reported case. I'm reading from a case, Rex versus Silber, 1952. Neither counsel has been able to find any reported case in which an application for recusal has been made in the course of a trial and on the ground that the judicial officer has shown bias by his conduct of the proceedings. And this is not surprising, since the ordinary way of meeting any apparent bias shown by court its conduct of the proceedings would be by challenging his evidential decision in an appeal or review. So the point I'm just making here is, it doesn't seem to me that counsel on either side, whether it's the transgressing counsel or the other side, were given an opportunity to address the court even on this harsh decision, which created a tremendous delay in a matter which had been running for several days. So I'm questioning the ability or the way that this was gone about, and I'm relating it to a situation where you maybe as a judge president in a court where some difficulties could arise. There could be different arguments within your division, and you are supposed to play a calming role and so on. One of the basic principles, I put it to you, and that's the question, is to hear the parties on either side before you take any decisive decision in the way that you have.
Commissioner Barnard, I think no judge, particularly no experienced judge, will take this decision lightly. You're referring to the fact that here is a child involved. How would it be if the decision went against that child? The fairness and the impartiality that that child is entitled to it is very important. We must bring an impartial mind to the proceedings. Once that impartiality is placed into question, and the opposite of that is an unbiased mind. Once that has come into question, I have taught the law students for many years about recusal and how to go about recusal, and we have drilled SARFU into them over and over again, because it's the apprehension of bias. But let me not go to the cases of the 50s. Let me go to the cases of the Supreme Court of Appeal in 2009, Volume 2, SACR. I think it is the matter of State versus Dube, where the Supreme Court so eloquently stated that where one can no longer bring an impartial mind, and that means that it will be based and it must be clear, manifest to all. Now, that manifestation, once your own counsel had said, you will decide in a particular way, it could not go any further than that. It was many recusal applications, and I don't know how many you've had, but in 21 years on the lower and the high court bench, I've had plenty of recusal applications, because it is a known fact that some counsels sometimes will look for a different bench and in the hope that they will decide differently. So this decision was really a very difficult decision, and it did not matter that this matter was a child. For me, it was more concerning that it was a child. And if one decides against the plaintiff, that mother will never know where justice lies, because she had seen her counsel saying, Judge, you decided this matter already, and you know what you're going to do. And that is apprehension of bias in the worst form.
Commissioner Bernard, I'm just wondering if further interrogation of this matter does not, well, I actually think that you are traversing the merits. We are right there now, because here is Judge Stein defending herself. She's even citing authority. We may be traversing the merits of a matter which she warned ahead is sub judice. She's given her explanation. Should we not just leave it at that? We can make of it what we will.
DCJ, the judge is saying that there was an application for recusal, and I do not understand that there was any application for recusal.
I didn't say that.
You were talking about applications for recusal now just moments ago, Judge.
No.
That's not what I heard.
Mr. Ban, sorry.
Yes.
I didn't want to be rude. I've interrupted you, Deputy Chief Justice. Let me apologize. I did not say, I've said many of the recusal applications that we deal with. I did not say that there was an application here, Mr. Barnett.
So there wasn't an application in this instance?
I've indicated it was a matter that required a miro moto recusal.
And you didn't give the counsel on either side chance to address you on that?
I've given counsel the opportunity to withdraw that. If it was withdrawn, it would have been the end of it. I've indicated that to you, Mr. Barnett.
Thank you, DCJ.
Thank you, Commissioner
Thank you.
Bernard. Minister?
Thank you, DCJ. I just want to ask you with regard to your role in the NCCS. As you are aware, in the public, the parole system is being criticized. How do you think we should balance the restorative justice part and obviously the public criticism that, in particular, lifers do not deserve a second chance in society?
Thank you, Minister. Well, as you're aware, just shortly before you took over as Minister of Justice, I've organized a conference on parole and the policy surrounding parole. Parole is also, because I've published a lot of chapters on prison systems, and parole is something that is very important. I do understand that when we deal with restorative justice, there is a perception out there that once the prison door has closed, then that person should remain in a correctional center. And what is then ignored is the fact that through the rehabilitation, through the various programs, anger management, through the programs, the psychologists working with them, lifers also deserve a second chance. For me, perhaps and I'm mindful of the fact that judicial overreach shouldn't happen. I shouldn't make statements. For me, I think the one thing that we have not considered in South Africa under our prison system is when we have life imprisonment with parole and life imprisonment without parole. In State versus Sangweni, one of the decisions, my reported decisions, where I've dealt with the life imprisonment that replaces the death penalty, and in which instances we should consider life imprisonment. I think it is worthy of a consideration, Minister, but parole in itself have various facets to it, and whether a lifer is genuinely rehabilitated is one of the very important questions to ask. I know that we as a council have debated this issue for many times because lifers also deserve a second chance. And if they have done everything that you require of them to rehabilitate themselves, what more can you offer? But perhaps if we diverge and we have life imprisonment and life with parole and without parole, it may very well help to solve the problem. I've also like to say that in the Jali Commission report, we've made recommendations regarding parole. Those recommendations were not taken on board by the Department of Correctional Services.
Lastly, what has been your experience while you were with the NCCS of reoffending or the level
recidivism,
of, amongst the lifers in particular?
Okay. Thank you, Minister. That was one of the issues that was also discussed during the parole conference. And if we look at the department, whether they have any statistics regarding recidivism, you would notice that they don't keep statistics of someone coming in through the door and the door being a revolving door and someone leaving the door again. So first and foremost, this is where we have to start. We have to look at which one of these prisoners come back. And I understand there is a tendency to say, but maybe we failed in the rehabilitation if the person is coming back. That shouldn't really be in consideration. I think that if we want to address recidivism, Then we need to have proper statistics, like we have statistics in OCJ. And once you have the statistics, you can work from that and see, and you can measure your success in the rehabilitation.
Thank you, DCJ.
Thank you, Minister. Any further questions from the virtual platform? No. Well,
None from me,
Thank you,
DCJ.
Commissioner Singh. Well, we've reached the end of your interview. Judge Steyn, thank you so much for making yourself available, and go well. I'm not going to invite you to give a closing statement. There's just no time.
I just want to thank the Commission for this opportunity of presenting myself to them and for being here. Thank you, Deputy Chief Justice. Much appreciated.
Thank you.
Thank you to the Commission.
Good
I'm
evening.
sorry, my mic was not on.
Good evening, Deputy Chief Justice.
We are so sorry for keeping you on tenterhooks all day, but it's just impossible to control these proceedings, you know?
I fully understand. It seems to be almost a rite of passage to come here and wait.
Yeah.
It's what you've
happened
got to go
me
through.
many times.
It's not a problem, really.
All right. You hold 2 degrees, a BUris and LLB from UP and UNISA.
That's correct.
Mhm. And you started working as a lawyer in 1991. No?
No,
That was with the Department of Trade and Industry.
That's correct. As an
As an assistant.
admin clerk.
What did you do there?
Deputy Chief Justice, I was an assistant administrative assistant, and I was involved in objections to company names. In those days, and I'm talking that's many, many years ago, in terms of Section 45 of the Old Companies Act and Section 20 of the old or the current Closed Corporations Act, entities could lodge objections against company names or closed corporation names or trading names and I was the person that had to deal with those objections, consider them, make recommendations, and either uphold or dismiss the objections.
All right. There's a bit of adjudication of they say no experience is a waste.
No, that wasn't the waste, definitely not.
So you started your legal career as a public prosecutor.
Yes, that's correct.
In 1993.
Mm-hmm.
And you were there until 1999?
I was there, I resigned, I think in January 99. I started with pupillage on the 1st of February 99, that's correct.
Mm-hmm. And thereafter you joined the society, the KZN Society of Advocates.
Yeah, I started practicing on the 1st of July 1999. It feels like a lifetime ago.
Yeah, that was a long time ago. And that's where you've been until now.
Yes.
You've had acting stints as a judge in the KZN division, not so?
Yes, that's correct.
A number of them I see.
Yes, not counting this last week where I started with a new session on Monday, I've calculated it as 64 weeks.
Ah, that's a long time. Before I ask you a little bit about that experience, what kind of practice did you have? What kind of practice do you have?
Deputy Chief Justice, I think last time when the Chief Justice asked me that same question, I referred to it as a generalist practice, where you do a bit of everything. You know, when you start out practice, you do whatever you get briefed to do. And I've done obviously a lot of family law work. That's just the nature of being a woman. You get approached to do those types of matters. A lot of delictual work, third-party RAF matters. Pietermaritzburg is a small bar, so you basically get to you become a jack of all trades. I've done cases involving cattle leases, fire cases, bank work, commercial work. It's really a mixed bag of everything.
Have you been able to produce written judgments as an acting judge?
Deputy Chief Justice, I've calculated that over the period that I've acted, I've written 67 judgments. 16 of them were extempore. Of the 67, 16 were extempore. My maths are leaving me now about how many are formally written judgment. But yes, I've produced quite a number of them over the last 3 years.
All right. Were you able to produce all of them within the requisite time, promptly, that is?
I try and do it as promptly as possible. Some of them I've been able to deliver. I think in the last session I dealt with a special urgent application on the Friday, and I gave judgment on the Monday. There's some of them that I can produce within 2 weeks. Some of them took me just under 3 months, and unfortunately there's 1 or 2 that took me just under 4 months to produce. But those were quite complicated matters and involved a lot of research. Yeah. But I will stay up till the early hours of the morning if it means getting something out when it has to go out. So, and I've shown that I can work under pressure to produce judgments if I need to do it quickly.
All right. Do you have any reserved judgments? Well,
No.
old one, that is.
No, I don't.
Okay. I see that all the law bodies that have sent in comments about you approve your candidature.
It must say it's pretty nice to read through their comments. I'm very appreciative and I'm very grateful for their comments. It really means a lot to be recognized by them.
Thank you, Advocate. DJP Madondo, do you have questions for this candidate?
Thank you, DCJ. Ms. President, while we have been together, I can say good afternoon once again when I'm sitting here.
Well, we've been together almost all day.
Yeah.
So, yes.
Am I correct to say, should you be appointed, you will be the first white female judge on the KZN Pietermaritzburg bench?
Yes. And I'll also be the first female advocate from the Pietermaritzburg bar to get appointed to the Pietermaritzburg bench. It's never happened before.
Yes. Would you say, or obviously, would you say your appointment will enhance diversity on the bench?
I think so, yes. Definitely.
Are you supportive of the transformation of the legal profession? If the answer is in affirmative, why are you?
Judge, I'm definitely supportive, and I think if one looks at what I've set out in my questionnaire and also in what is contained in the reports by the GCB and OFT, and I think maybe Natal as well, I've been involved in the bar structures for for many, many years, and I've been on the pupillage committee since 2016. And I pride myself on the fact that I was actively involved every year when it came to interviewing aspirant pupils for the pupillage program the next year to insist and to make sure that there are especially black female candidates approved and given an opportunity to do pupillage. Apart from that, I tutored or lectured civil trials. I'm a strong believer in the transference of skills. I've got an open door policy. The pupils that I taught during my times when I was teaching them civil trials, up until, well, not physically today, but currently they seek my advice. I sometimes get WhatsApp messages late in the evening asking for a quick question when they've got a brief or motion court the next day. And I just believe on continuing trying to transfer the knowledge I have. It's my duty. It's why we're in the profession. It's one of those professions where, although you basically training someone who could one day be your opposition or even take work away from you, you still feel obliged to make sure that you develop advocates and develop people that can become competent and a force to be reckoned of with when they appear in court against you. And even now, when I appear in court as a judge, I see them appear in front of me, and it's an amazing feeling to see young advocates that 2 or 3 years ago I was lecturing appearing in front of me, and you can see they're really making progress. And there's more and more of them. Even a month ago, one of the judges in our division commented and said it's quite amazing to see how many young black female advocates are suddenly appearing in court, and it's because it's now we're seeing the fruits of selecting young female black advocates to do pupillage and start their practice, and they're starting to now appear in court, and they're doing very well, and it's amazing to see the progress that's being made.
Well, those who have commented, they say you frequently assist indigent litigants. Can you share with this commission what type of assistance you offer to them?
Well, the assistance, I obviously do my share of, or in the past did my share of pro bono work, but when it comes to indigent litigants, especially in matters the delictual matters against the Road Accident Fund, against the Minister of Police, those types of cases, you're sometimes dealing with the poorest of the poor, someone that got arrested in a rural area and locked up for 5 or 6 months, and you've got to go to court, and they can't afford to brief counsel. And I've always made arrangements with the attorneys that I will, at the end, at the completion of the case, only charge whatever is allowed on taxation. I've never signed a contingency fee agreement. I'm not impressed with these performance fees or whatever. I don't even know how it works because I'm not interested in it, where you now take money out of the capital of a person that's successful. I think they call it a success fee or whatever. I just never entered into any of those types of agreements because I don't want to take any of the capital away of the indigent person. And I've quite often been approached by attorneys to say, my client really cannot afford to pay your full fee. Are you willing to reduce your fee? And I've done it without hesitation on many occasions.
Okay, thank you. I also intended to ask you about your involvement in the police advocacy training and offering support to junior advocates. Maybe you have covered it, unless you have something that we left out at the time when you refer to it.
I think I've covered that, Deputy Judge President.
Okay, thank you, DCJ.
Thank you, AJP. Acting Premier?
Thank you very much, DCJ. Good evening,
Good evening,
Advocate Bezedo. The question I wanted to ask you was in relation to the briefing of junior advocates, but I think you have actually spoken to that, so I'm not going to ask. I'll just ask, I think having listened to what you are telling us now, it's also clear then that you are exposed to the fact that black attorneys and black advocates don't get briefed as a white attorney or a white advocate would be briefed.
No,
in other words, the briefing patterns are quite skewed. Now, what would you think should happen, or what do you think we should be doing to change that situation?
Commissioner, you know, over the last, I don't know how many years, it's come up time and again that approaches must be made to big commercial attorneys firms to change their briefing patterns. I can see there's a difference, but there's still a long way to go because it's one thing briefing, and I've used the term loosely, a baby junior. I know some people don't like that term, but for me a baby junior is someone between 0 and 5 years. And you see they get briefed in motion court maybe to do pretty straightforward matters, and it's from a big firm, and you can see they're trying to change their briefing pattern. But from there, the next jump is to brief that same advocate maybe to do an opposed motion, where they can earn a much bigger fee. Yes, it's a bigger responsibility because they've got to come and argue the matter or brief them for a trial, but I don't see that jump. They tend to brief them for the more simple things so that they can make a tick and say, yes, I've briefed a young black female, but then they don't progress and take it further and allow that practitioner to now develop their skills and maybe give them the responsibility of a post-motion and let them work their way up. And we can always try, and I know the LPC makes lots of inroads in approaching the attorneys' firms, and there's been lots of work done in that regard.
So do you think senior counsels like yourself would have a role in assisting to change this particular briefing patterns?
Well, we already, almost as a matter of course, either bring in juniors as deviling juniors or try and convince the attorney to speak to the client to bring in a junior and pay for that junior a full fee, not a deviling fee. But we can only do so much. It starts with the attorney who's got the duty to instruct. I mean, I can't instruct a junior, the attorney must instruct a junior. I can only try and motivate as much as I can, and usually we're successful, but you also want those junior advocates to be given a chance on their own, to start building their practice and do their cases on their own, and not always live in the shadow of someone else.
Thank you, DCJ.
DCJ,
Yes, Commissioner Malema?
I'm worried where I am. I'm warned about load shedding, so I thought I must ask my one question.
Yes, please go ahead.
Advocate, I'm on virtual. So I just want to ask, by appointing you as a female, not just a female, but also a white female, will we be in line with the requirements of the Constitution and in line with the transformative agenda that we want to carry out in the judiciary?
Commissioner, I think so, yes, for certain, because, well, firstly, appointing me as a woman in the Pietermaritzburg bench, there's, I think, 10 males and only 2 women at the moment. So if I'm appointed, then I'll be the 3rd woman. There's no white females on the Pietermaritzburg bench. So in that instance, I think, yes, it will definitely contribute.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Malema. Commissioner Prof?
Thank you very much, Deputy Chief Justice. Good afternoon, Judge.
I think it's good evening, but yes, good evening.
It's not even yet 6, so I think it's...
Yeah, it's early afternoon. Good afternoon.
All right. I heard you correctly that you said that amongst others, your speciality is family law.
Yes, I've done a lot of, I won't call myself a specialist, but I've done a lot of that type of work, a lot of divorces and what comes with it, yes.
I see that you also wrote a judgment, JVS versus LVS, that dealt with the Children's Act. The issue there was a parental plan. You don't remember it? Okay, no, that's fine. Let me ask you a question generally, because the thing is, I've been waiting for somebody who really understands family law, because there's an issue that I really want to canvass. There is this view that Section 28, subsection 2 of the Constitution, that deals with the best interest of the child. And of course, that is given effect to, among others, by Section 7 of the Children's Act. And we know that the best interest of the child is paramount, right? But it appears to me that the word paramount has been used as this hammer, that everything else that conflict with the so-called best interest of the child, they play a second role. I just want to understand from you. I'm not sure if you are aware of the concept of relational autonomy. Okay, no, let me ask generally then. How do we balance the best interest of the child, having regard to the interests and the rights of other family members in a home situation? How do we balance that? Are the best interests of the children always going to trump over all other members?
Commissioner, thank you for that question. The best interest of a minor child is a tricky horse to ride, because it literally depends from case to case. I think one of the factors that one takes into account when one considers the interests of minor children is also the bonds with extended family matters and extended family members. And quite often you find that, for instance, the aunts and the uncles and the grandparents have also got a lot of input in the raising of that child. And when the two parents start fighting and the poor child is in the middle, and then it becomes, the families also become involved, and then you've got to consider their interest as well. And suddenly, where you previously just focused on the child and the mother and the father, you've got the aunts and the aunties and the grannies and the grandpas that also enter the fray. And you've got to give consideration to all the parties. It's not, you can't just ignore common sense and just focus on what's in the interest of the child per se. You can't see it in isolation, and that's why it sometimes becomes very difficult, because you can't follow a set set of rules. You can't just look at what the Act says and just look at those few factors. You've literally got to look at each case, look carefully at the facts, look at the extended relationships, and then try and make a decision. Sometimes it's difficult, like Solomon's wisdom. You can't, unfortunately, sometimes you've got to make very difficult decisions, but you've got to take so much, you've got to go so much wider than just the child and the mother and the father.
No, thank you very much. Thank you very much, Deputy Chief Justice.
Thank you, Commissioner Noruma Rufai. Any questions from the virtual platform? No.
Just one question, Jay, if I may.
Yes, Commissioner Singh.
Yeah, thank you very much. Good evening, Advocate Bezedno.
Good evening, Commissioner.
I think the open door policy that you spoke about has really been confirmed by one of the law bodies where they speak, they wax lyrical about the open door policy and, non-racialism, etc., etc. So well done on that. My one question, I think I asked you this the last time about traditional courts. Now that the traditional courts bill has gone through the National Assembly and received support, have you done a bit more reading in terms of traditional courts and since April?
Commissioner, I looked through the bill and on the face of it, it looks good, but lots of pieces of legislation looks good on the face of it. I asked one of the researchers at the High Court, and maybe it's a bit naughty to ask her because it wasn't really strictly to do with my work as a judge, but I asked her to just also get the comments of what was said when the bill passed through. I think not Parliament, one of the sessions when it was in Parliament. So I read the comments made by various parties when the bill was being discussed, and concerns were raised by certain parties, and time will tell whether the bill lives up to what is being promised, and I'm interested to see what's going to happen in the future. But it's definitely, it looks good on paper.
Thank you very much. I'm glad that you took interest and time in the last 6 months to look at it more closely. And perhaps this could be a red letter day for KwaZulu Natal in terms of the judiciary, because if you are appointed, as you said, you'll be the first female from the bar in Pietermaritzburg. So I wish you luck. Thank you very much.
Thank you.
Thank you, DCJ.
President Pete.
Thank you, DCJ. Good evening, Advocate Bezedno.
Good evening, Commissioner.
I'm looking at one of your judgments, some Roy May versus the state.
Yes.
It commences at page 91.
Yeah, Commissioner, maybe you can just, I'm just trying to find my place here. I'm almost with you. Commissioner, maybe you can just refer me to the paragraph in the judgment, because I've got my bundle of documents in front of me. Well, I don't want to cause any delays.
Okay, thank you. It was an appeal against conviction and sentence.
That's correct.
And you dismissed the appeal against conviction, upheld the appeal in relation to sentence.
That's correct.
And paragraph 2 of your order then reads, the appellant's appeal against his sentence is upheld. The sentence is amended to read, then the appellant is sentenced to 25 years imprisonment.
Yes.
When you uphold an appeal against sentence, aren't you supposed to set aside the sentence and then substitute it with whatever sentence you consider appropriate?
Commissioner, I seem to recall that I had a debate with the judge that was sitting with me on the appeal, And I know we made a last-minute change, and it might be that that's what it read, and then we changed it. But I take your comment. I seem to recall, because I remember it was literally either the day before or the morning before judgment was handed down that we made a change to the order, and it might have been a change in the wrong direction. But I take your point.
If you are recommended for appointment or invited to act again, that's something that you should bear in mind. You set aside the sentence and substitute it with the fresh sentence.
Yes, no, definitely. Thank you for that, Commissioner. I really appreciate it. Thank you.
Thank you. Thank you, Mr. Chair.
Thank you, President. There are no more questions for you, Advocate Beside Note. Okay. You're excused. Thank you.
Thank you so much.
That is correct.
Obtained from the UDW, as we used to call it.
At that time.
You started your legal career in the Department of Justice as a junior administrative clerk?
That's correct.
And worked your way, became a prosecutor, magistrate, and a regional magistrate, which is where you are now in 2006.
That is correct.
So you've been a regional magistrate since 2006.
That is correct.
All right. You have several acting stints at the KwaZulu Natal Division of the High Court, starting in January 2015.
That is correct.
When you collate all those terms, what do they come up to?
22 terms.
How many written judgments have you produced during those acting stints?
49 criminal judgments, 12 appeal judgments, 6 civil judgments, and 4 review judgments.
Any taken on appeal?
The last count were 3.
Have
On
they
appeal.
been finally decided?
The two were confirmed, convictions and sentences. The ones, 4 of the 6 convictions were confirmed, 2 were set aside, but the sentence remained the same.
All right. Do you have any reserved judgments?
No, not at all.
Okay. You've written a book titled Confident Criminal Litigation,
That's correct.
but you wrote it under an alias. Why is that?
I'm generally known as Anand Miraj. It's the nickname.
Oh,
the
I
calling
see.
name.
All right. No, I'll save this question for later. Let me just hand
Thank
over
you.
to the commissioners to put questions to you. AJP Matondo?
Thank you, DCJ. Afternoon, Mr. Maharaj. Good evening.
Good evening,
Yes.
Acting JP.
Though we've been together the whole day, I will have a few questions for you. If you are appointed, would you say your appointment enhanced transformation? If the answer is, how?
My answer would be yes. How would be is that I consider myself to be South African. I consider myself to be part and parcel of the South African population in terms of racial composition and gender. In that sense, I think that I would qualify in terms of Section 174 sub 2. Given the adjudication experience for the last 29 years from the district court, regional court, and the act instance in the High Court, I think I can bring that ability to the High Court. Transformation in the sense of constitutional transformation in terms of social justice and the decisions you make in the High Court can also be considered as transformation. So I believe I can do that.
Okay, will enhance diversity on the bench?
That's a difficult question in the sense that, you know, the Constitution talks about unity in diversity and that South Africa belongs to all in level. As I said, I'm part and parcel of the South African society, so I would think that I'm part of the diverse group as well.
What's your answer, maybe?
I would say yes, I'm part of the diversity of the country.
Yeah, but
In
taking
terms of
into
experience, in terms of the knowledge of the law, in terms of expediting matters, that would be my answer.
take into account or regard being had to the demographics of the division. The judges of the Indian origin seem to be overrepresented at the moment. What would you say to this?
That's a good question, Acting DJP, but my answer to that is that if you think of me as an Indian, I would ask to say, listen, think of me as a South African Indian. At the end of the day, I understand color, I understand diversity, but if you say Indian, 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 when do we reach a state of non-racialism that the Constitution speaks of? So that is a decision that falls for this commission to decide of whether I reflect the imperatives in 174 sub 2 of the Constitution.
Thank you. Did you have any involvement in community or other organization? And if the answer is yes, what involvement? And with what community or organization?
The answer is yes. The community involvement that I consider as community involvement is the fact that I'm an avid blood donor. I've donated over 103 pints thus far and would encourage people to become blood donors as well as platelet donors. To me, that is also serving the community in terms of helping those who need the blood. In terms of outreach programs, we've been to schools, several schools in fact, to teach youngsters about leadership qualities, the value of education, the value of respect for the teachers, and to consider that education is important for their future lives. I've also been fortunate enough to lecture, I think between 1999 and 2002, at the then University of Zululand, Durban Mlazi campus, where 90% of the students were African male and females, and they've done pretty well, I might add, after receiving their undergrad LLB degree. One in particular that I can think of is now Deputy Director of Public Prosecutions in KZN. In terms of community work, I would also consider the fact that one of our appeal clerks in the regional court, while doing the appeals, became interested in criminal law from reading the transcripts, studied, assisted her with the assignments in guiding her. She is now a prosecutor at the Durban court after receiving an LLB degree. In terms of community work, we've also called PLT students from the business sector to come and experience what court life is about, so they understand how the courtroom functions or how the law functions in a live debate. So those are some of the community things that we have done, or I have done.
Yes, thank you. The LSSA says that on the 29th of September 2011, you ordered the arrest and detention of Warrant Officer R. Nakasa simply because he happened not to be in court during the hearing of the case over which you presided.
That is correct. The circumstances surrounding that is the prosecutor informed the court that the witness was present. When his turn came to testify, he was no longer in court. He was not outside. He had received a subpoena. And on that basis, I issued the warrant pursuant to provisions of Section 187, 188 of the Criminal Procedure Act. He was subsequently arrested. I think he spent an hour incarcerated. Inquiry was conducted. He was exonerated and found not guilty because he had given the explanation that he had told the prosecutor that he was testifying in another court. He subsequently sued the state and myself. That case was dismissed against him with costs, as the court found that I acted within the confines of the law. So the point I want to make with that, he's not above the law. He may be a police officer. He received a subpoena. Prosecutor did not inform me that he was testifying in another court. And on that basis, I issued the warrant. Had she done so, I would have waited for him to testify and then come back to my court. So those are the circumstances under which I actually took the liberty of sending a copy of the judgment where the court dismissed his claim.
But the inference thrown there on the part of the SA that was an abuse of judicial power on your part.
No, with respect, that's not an abuse of judicial power if you're acting within the scope of the law and confines of the law. So I disagree with that.
Okay, thank you. Thank you, TCJ.
Thank you, AJP. Premier?
Thank you very much, TCJ. Good evening, Mr. Maharaj.
Good evening,
Please
Commissioner.
bring the mic closer to you so that we can hear you. Bring it closer. Yes, thank you. Mr. Maharaj, you've had a number of acting stints in the province, both in the Durban and the Pietermaritzburg centers. Last year, during one of your acting stints, you set aside a life imprisonment sentence against a young man who had raped a 9-year-old. Do you remember that case? Okay. And in that, you quoted in your judgment that The lower court had overemphasized the seriousness of the crime. And of course, there's other things that you said. Now, my question here is that, do you not consider a rape of a minor as an overly serious crime?
Just to be sure, the case you're referring to is Amakolo Paulus Kumalo
Yes,
at 141.
correct.
The conviction and sentence was set aside on the basis of the conviction was incorrect on the facts, as well as the conduct of the magistrate presiding at the trial. So regardless of the age of the complainant, if you looked at the record of what the magistrate had done to insult the accused, belittle him, that clouded his objectivity insofar as that was concerned. But on the merits itself, from the evidence on record, the conviction could not be sustained.
But you proceeded to say there were compelling circumstances which included his youthfulness, the youthfulness of the perpetrator, the fact that the perpetrator was asthmatic and he had a low level of education, and there were no evidence of serious injury to the complainant or her emotional state.
Okay, no, I think we are at cross purposes, my apologies. That is not one of the cases you're referring to in the bundle.
No, it's not on the
No.
documents, just one of the cases that you
That was one of the
presided on last year.
cases that was, we went on the basis of State versus Velakazi, where the Supreme Court of Appeal held there are certain factors you can take into account to consider substantial and compelling circumstances in order to deviate from the prescribed minimum sentences, and that is what we did. You must appreciate, Commissioner, that it wasn't a decision alone, it was a decision with another judge, and we both agreed that was what we had to do.
No, I appreciate that, but the question I'm posing is, do you not consider a rape of a minor to be overly serious? Considering the fact that KwaZulu Natal is the capital rape center, with Inanda police station having the highest numbers of rapes in the country.
Yes, it is serious. It falls into the upper echelons of seriousness where children are concerned. But I think, when it comes to the court deciding on the degrees of seriousness, I think that's where the problem comes in. And the court may consider that a rape of a 2-year-old child who has sustained injuries to be more serious than, say, someone who hasn't sustained and is an adult, although rape is rape and it's always serious. So the point I'm trying to make is if one looks at the degrees of seriousness, one would automatically say, listen, the rape of a child would be considered more serious. So we followed the opinion of Velakazi, which we decided that on these facts that the sentence should be interfered with.
So in light of this judgment and the judgment that Judge Mantondo was speaking on, can you see the discrepancy?
Yes.
And can you see when we look at your judgments, the fact that I might be correct in perceiving you not to be able to provide accurate sentencing or accurate judgment to an accurate matter?
That may be a perception, but with respect, I think that one must also consider how we arrived at that decision by taking into account, already decided cases from the Supreme Court of Appeal as well.
I don't agree with you. I think it was very negligent, and the fact that we have such serious challenges with the rape, particularly in that province and in eThekwini, I really do not agree with that. But DCJ, thank you.
Thank you very much, Premier.
Can I make a quick follow-up, DCJ?
Yes.
If you don't mind.
Yes, of course, Commissioner Malema.
Say, when you're being told this is your judgment and you say no, it's not only mine, we authored it, we were two, and then I agree with it. Why do you bring that point? Does it make less of your judgment if you are two on that judgment?
Thank you for the question. The point I was making, Acting President, is that it's an appeal.
No, there's no problem, but we're saying she's referring to you, she's referring you to your judgment. And you say you must consider, I was not alone there. Yet you agree with it, yet you are the judge who made that judgment. When you bring to our attention that there was another judge, does it make it less of your judgment?
No, it doesn't.
When there was another judge that you agree with?
No, it does not.
Okay, thank you.
Thank
May
you.
I also
Thank you, DCJ.
Yes, Commissioner Breitenbach, is that you?
Yes, thank you, Mr. Judge. Thank you. Sorry for just shouting. Good afternoon, good evening, Judge. I'm on the virtual platform, sorry.
Well,
Oh, yeah, in the front.
they're not showing you on even on the TV screen.
I'm sorry, I've got a really poor signal, there's lots of load shedding, and so I'm scared I'll lose connectivity. I'm trying to be on two devices.
No, that's fine. We can hear you.
Okay. You mentioned, sir, that, that what you consider the reasons why you interfered with the sentence. I'd like to hear those reasons because I tend to agree with the previous speaker that the rape of a child is unbelievably serious.
I don't have the judgment before me.
You don't
If
remember?
I recall correctly, the sentence was one of life imprisonment. The Court of Appeal reduced it to 25 years, and the reasons were given as to why I found substantial and compelling circumstances. So those are the reasons that I can only stand by and fall by.
Thank you.
Thank you, Commissioner. Commissioner Marumachai?
Thank you very much, Deputy Chief Justice. Good evening, sir.
Good evening, Commissioner.
Will I be correct to assume that criminal law is your specialty?
I would agree with that.
Yes. I just want to, you know, I've been troubled by the Criminal Procedure Act, especially the schedules to it. I'm not sure how many schedules are there. Like
7.
7. When one looks at them, you see that they tend to repeat crimes.
In each
A crime will be repeated and all those things. I want to hear from your view, are these schedules properly structured to ensure that both the magistrate and the prosecutors do not struggle to quantify a particular crime, especially for the purposes of bail? That's the first question. The second one, when we go to Schedule 6, that really requires those exceptional circumstances. What is your view on that? How does one get to this concept of exceptional circumstances? Isn't it one of those things that are making it very difficult for people who might otherwise be deserving of bail to not be able to get bail? Just want to hear your views in relation to that.
It's a good question. The question of Schedule 6 in terms of the seriousness of the offense, and it comes to bail, and obviously the onus is on the accused person to establish exceptional circumstances for him or her to be released. This is the problem which came about with the legislature. The legislature decided to schedule these offenses. The legislature decided that these are the offenses that fall within the purview of Schedule 6. The interpretation of Schedule 6 is not impossible to get bail. It's just that it's more difficult because of the offenses are considered to be serious. They wanted the courts to be more circumspect in taking factors into account to decide whether bail should be granted or not, especially, as you said, rape cases, murder cases, robbery cases, and things like that. So the fact that exceptional circumstances are there, it's a value judgment which the bail court dealing with has to make. You must appreciate the legislature has never defined what exceptional circumstances were. We rely on case law. We rely on cases from the Supreme Court of Appeal or the Constitutional Court to give the court an idea that, listen, these are the factors that may be considered exceptional. For instance, there's a weak case against the accused. Consider that exceptional, or he may have an illness, or he's not a flight risk and he's put up a lot of money as surety, perhaps that can be considered exceptional. So it's never been defined. I agree with you, the legislature needs to be more clear as to what exceptional circumstances ought to be, rather than leave it for the court to decide on case-to-case basis what would be exceptional circumstances.
We have loved to get your reaction on the schedule and the ordering, but for the sake of time, I will leave it there, DCJ.
Thank you, Commissioner. Commissioner Rogers?
Thank you, TCJ. Good evening.
Good evening, Commissioner.
I just want to take you to the objection that you received very late by Mr. Sitofile. Did you receive that objection?
Yes, yesterday at 5:30.
Yes.
Yes.
But the reason why that objection was allowed is because apparently even on your last interview, it was drawn to your attention. You were asked about.
Yes, I did.
Now, Mr. Stoffel, I just only read this. Mr. Stoffel is saying, special attention is hereby drawn to the fact that on 2 numerous occasions, we previously objected to Mr. Maharaj being recommended to be appointed as a judge on the basis of very serious, justifiable ground of having been very harshly slammed by the presiding judge in a most damning judgment against Mr. Maharaj on irrefutable, fraudulent, and corrupt hardcore evidence on record, and as such being the most damning and unchallengeable findings against him. And he attaches the judgment to this. The point is, that is my question, because I just do justice to Mr. Stoffel and to yourself. First, you accept that there were those findings made in that judgment, and what is your response to the commission in view of those findings made in the judgment?
The judgment that was attached, Commissioner,
yes, he attached it.
it's not a full judgment in terms of some of the pages were missing, as I see, but I will accept that's the judgment of the judge from there, which was ventilated in the last interview in 2018. As I said, I don't agree with the finding, but I accepted it. I didn't appeal it as a result of the council deciding that, listen, accept it, move on, and that's what I did. But I don't agree with it, as I said before.
Yes. Look, the point...
And I don't know Mr. Stofile. I think the address is given from Mtata. I don't know the gentleman, never met him. These complaints were given after the closing date, but I accept that you're entitled to ask on that. I don't have an issue with that, but I don't agree with that.
Yeah. No,
I'm sorry, what was the last part of your...
I said I don't agree with the judgment.
With which judgment? I'm sorry, I got distracted for a second there.
Sorry.
What is it you don't agree with?
I don't agree with what Mr. Sofile is saying, as well as I don't agree with the judgment of the court.
Oh, okay.
Both.
No, but the point, I'm sorry, I mean, it's just that I have to put this to you.
No, I don't have an issue with that.
The point is that there is a judgment, and in that judgment, there are findings made by that court, which prima facie suggest a corrupt, in fact, a fraudulent conduct on your part, on the face of it, and they have not been set aside, they have not been appealed. So that's why I wanted you to have an opportunity on that. Thank you, CJ, that's it.
Thank you, Commissioner Nokesi. Just a quick follow-up on this line of questioning. I was just curious to find out why you did not declare this incident in your questionnaire, because the usual thing is to mention such things and say if the case was withdrawn against you, or if you're convicted, it was,
Okay.
Findings were made in your favor.
In 2018, I made the full disclosure of that judgment. When I went through the forms, I didn't consider it to be embarrassing, or I didn't consider it to be anything that I needed to restate, because I've already said so before in 2018.
So you have previously made a disclosure to the JSC?
Yes,
All right.
in April of 2018.
Okay.
Can I just say something as follow-up to the question there? Can I say something, if I may, just to complete it?
Yes, you may.
I've been acting since 2015 up until 2021. If that was an impediment from that time, then it begs the question, why am I allowed to act for so long in the High Court if people have this objection? In fact, I sat on appeals with Judge Kuhn. I've scribed 2 judgments with him, so I don't see it as an impediment, but I take the point you needed to bring it to my attention, and that's the best I can take it.
CJ, I'm sorry because of this. I would like to say the point of Mr. Stofile here is that he raised this judgment. It has never been rescinded. The findings that have never been challenged, they exist. So remember, when you're an acting judge, there's no opportunity for members of the public to object to you. That's why you put so. I just want to leave it here, straight to say, if you accept that there were such findings and they have been raised now as an objection.
That's fine.
Yeah.
Thank you. Commissioner Steinberg?
I just want to go back to the rape case for a moment, Mr. Maharaj. Did I hear the Premier say that you found substantial and compelling circumstances to reduce the sentence because the child wasn't harmed emotionally or physically?
That is what the Supreme Court of Appeal had indicated in terms of the seriousness of lack of injuries. They didn't prove injuries.
I'm not asking you about the Supreme
Yes, that's correct. That's correct.
I find that astonishing. Is it possible that a 9-year-old little girl can ever come out of a rape without emotional or physical damage?
Commissioner, what the courts look for is medical evidence that had not been led by the state during the course of the trial and things like that. So that was one of the factors that was considered to be substantial and compelling, that the state did not lead evidence of the seriousness in terms of injuries to the complainant.
And you had evidence that the child didn't suffer emotional
Nothing.
harm?
Nothing. And that's evident from the judgment that was sent in the last interview.
Well,
One would expect them to have led evidence of emotional trauma, evidence of the doctor, to say this, and this is one of the serious cases, and they did it.
I'm just not sure if you need evidence when you have a 9-year-old little girl. May I just ask one more question?
Yep.
The review from AFT is
Sorry, I didn't beg your pardon?
the review from Advocates for Transformation, which you would have seen.
That's correct.
Yeah.
I follow you.
It's concerned that you have very little civil law experience. So I want to ask you, sitting in that division, if you got, for example, allocated a case which was challenging a tender that the municipality or, the
Public management,
made,
finance.
how would you feel confident to approach it? How would you approach it?
I would approach it on the basis of the papers. I would research the law relating to the Public Finance Management Act. So while I agree with you, the issue of civil was minimal. I think it was 2 months in total. I managed to get the statistics for the civil work done. But I would approach it on that basis, that I would read the papers, follow what's in the heads of arguments, research the law relating to that, and then make a determination. I must also appreciate, Commissioner, that when you're invited to the High Court, the Judge President will tell you, listen, I need you to go to the Circuit Court to do crime. I need you to do the backlog of crime. So I would do that. It's only in the last couple of months where you do crime, you do appeals, then you would get opposed or special opposed, or you get a civil trial. So I was invited primarily to clear backlogs in terms of the criminal matters. So I agree with you, 2 months may seem compared to criminal work, but I believe that you can still make a determination on the papers and research.
What is the law? Which law do you use when an applicant brings a review? say, of a tender?
In terms of the Public Finance Management Act or the Municipal Finance
A review.
Management Act? I would get that information from the papers. But I haven't done with cases dealing with tenders, as it were. Or hasn't been one brought before me to say, listen, you must consider whether this tender was lawfully granted or not.
So you're not aware of the promotion of Administrative Justice
I know
Act?
PAJA, Promotion of Just Administration Act, I'm aware of that.
All right. Okay, thank you.
Any questions from the virtual platform?
Yes, DCJ.
Go ahead, Commissioner Bernard.
Thank you. Mr. Maharaj, when it comes to judicial temperament, what are your strengths and what are your weaknesses?
It's a good question, Commissioner. I think my strength lies in the fact that I keep an open mind about everything. My weakness would be, if I had to say that, would be that as a result of, punctuality, because I go to work at between 6:30 and 7 and court starts at 9, I expect the parties to be there. So sometimes litigants or witnesses or maybe even the attorneys may be reprimanded for coming in late. But of recent, I decided I'll go to court at 9, write in the court book the reasons why we cannot start at 9 and leave it at that. So insofar as that temperament is concerned, I think I've toned down trying to insist people be at court at 9 o'clock because the dynamics are different nowadays in terms of traffic, in terms of transportation, etc. So that would be my weakness and that would be my strength.
Thank you, Deputy Chief Justice. May I follow up just with a further question?
Yes.
On the same issue?
Yes.
Yeah, so have you ever been abrupt or angry or lose your temper in court? Because I notice advocates for transformation say that you've not quite acquired the abilities and temperament necessary for appointment to the bench.
No, I don't understand the temperament. Your temperament is referring to your behavior. I've been in the High Court, as I said, from 2015. I've never had any written complaints to the Judge President or to the Magistrates Commission or to the JSC while acting, or even for that matter in the regional court. So I don't know where they come with the temperament. Perhaps they interpret firmness to be temperament or something that's deserving of censure. I don't know. So in the absence of a particular complaint specifically referring to whether I insulted someone openly, it's difficult to say. Just to follow up on that, if you look at the BLA or you look at the nomination from Mr. Ori, one of the assessor who sat with me, it gives a different picture of being polite or being courteous. So ATF says temperament in the wide sense of the word. So I think I've mellowed in time. I think my patience is fine. And I do the best I can, but I've never insulted people or been abrupt to the extent where you humiliate someone or violate their dignity. So I've never had any complaint, written or otherwise, against me.
Thank you.
Follow up, DCJ?
Yes, you may follow up.
Judge, I'm a little bit unsettled in relation to the question that was posed regarding your civil experience. I mean, in all fairness, yes, you ought not to be punished for not knowing all the areas of law. But I thought if somebody challenges you on your experience of civil law, at least your starting point, even if that is not civil law in itself, because it does deal with some parts of criminal law as well, is the Uniform Rules of Court and the Superior Courts Act, to say, look, I'm going to familiarize myself with the working framework of the space where I work. Then anything else I can research. And I mean, when you look at the Uniform Rules of Code, Rule 53 deals with the very same question that she was dealing with. Before you even go to PAJA and all those things, you need to prepare a record and so forth in terms of tenders. I was just concerned about that. It's just a comment. You need not
No,
to.
that's fine. Thank you. I appreciate that. Thank you, Commissioner.
Thank you very much, DCJ.
Thank you. Any further questions from the virtual platform?
Not from me, Deputy Justice President. Thanks.
No, thank you.
Oh, I forgot about you, Commissioner Batolodle.
Okay, thanks.
Please put your question.
No,
So she has
Deputy
nothing. Oh. All right, then that means no further questions for you, Mr. Maharaj. Thank you so much for making yourself available for the interview.
Thank you,
You are
DCJ. Thank you,
excused.
Commissioners, for your time.
Good afternoon, good evening, Advocate. Or is it Professor? I'm so sorry. I'm so sorry. How are you?
Good evening, Deputy Chief Justice and Commissioners. Thank you, I'm fine.
Good, good. Ooh, you have a whole lot of educational qualifications. It's going to take a while to get through them. B.Juris, LLB, LLM, and a doctorate.
Yes.
You started as a police officer
Yes.
in 1982.
Yes.
But you would have been fresh from high school then, I imagine. And you rose through the ranks and became a sergeant, but then you left in 1988.
Yes, Deputy Chief Justice.
Now, there's this gap in your employment chronology between 1988 and 1996. Am I right to assume that you went back to school? Because I see 2 degrees in that intervening period.
Yes, Deputy Chief Justice, I went back to university full time.
And then you decided to become an attorney. You did articles and indeed joined the sidebar
Yes.
until 2002.
Yes, Deputy Chief
Then you did various other things. You worked for provincial government as the head of Department of Safety and Community Liaison. Then you were municipal manager for 2 municipalities. Then you taught. You were a university lecturer at Northwest.
Yes, Deputy Chief.
What did you teach there?
At Northwest, I taught interpretation of statute, property law, and family law. Yes.
You were a senior lecturer, then you became senior lecturer at UNISA, still teaching the same subjects.
When I arrived at UNISA, Deputy Chief Justice, I taught civil procedure and law of evidence for 4 years, and thereafter moved to public law, where I taught constitutional law and local government law.
And then you became associate professor, full professor ultimately in 2021.
Yes, Deputy Chief.
But then you decided to join the bar,
Yes,
and that's where you are.
yes,
So I was right to call you advocate then. That's your other title.
yes, Deputy Chief Justice.
All right. How many acting stints have you had in the High Court?
I have acted now for 40 weeks, Deputy Chief Justice.
And have you managed to produce written judgments during that period?
I've now written 53 judgments.
And that's in addition to all these articles, these publications you list as an academic.
Yes, Deputy Chief.
So many of them.
Yeah.
Were you able to produce your judgments on time?
Yes, Deputy Chief Justice, right now I do not have any outstanding judgment.
Are you acting at the moment?
I'm still acting.
All right. Okay. Some of the law bodies have raised the concern that you may need more experience as an acting judge. It may not be an opportune time right now. Would you say you are ready for permanent appointment?
Deputy Chief Justice, I believe I'm ready because I've been able to cope with the pressure and during the time when I was given time to act, I've never disappointed. And I remember even at one stage, one of the senior judges who was going somewhere gave me her motion court role, and on that week alone, I had to do 2 motion court roles, including my daily duties. So I think I'm able now, Chief Justice.
Yeah. All right. I'm going to hand over to the rest of the commissioners to put questions to you. AJP Madondo, do you have questions for Professor Matenjwa?
Thank you, Mr. J. Good afternoon, Mr. Matenjwa.
Good afternoon, Acting Judge President.
So, because you have said something about your acting appointment, then I'll start from there. Because in April, you were interviewed before this commission.
Yes.
And this same problem was raised that your acting stint was not adequate at the time.
Yes.
And we have indicated at the time how many times had you acted?
At the time, I've acted for 25 weeks, and now I've acted for 40 weeks. And at the time, I've written 23 judgments, and now I've written 53 judgments. And at the time, I had not yet attended the aspirant judges training course, and now I've attended aspirant judges training course. So I submit that I have progressively acquired the relevant experience.
So you received an award for being a best researcher. Am I correct?
It's correct, Acting Judge President. In fact, the NRF, it's different from the award. The NRF, I obtained the NRF as an international recognized researcher. The award is what I received when I presented a research paper at an international conference in Spain, where my paper was voted as a best paper.
So this skill you have acquired, will it be beneficial to you in the performance of your judicial functions?
The skill I've acquired will be beneficial because I have received advanced training on research and writing skills and critical analysis. And that skill assists me to deliver my judgment in time to perform the court deliverables of a judge, that of writing judgments.
Okay, in other words, that will be a valuable asset.
Yeah.
You also obtained an LLM degree with specialization in human rights. So with such qualification, or will such qualification be of any assistance to you in the performance of your judicial functions?
My qualification on fundamental right have assisted me and created consciousness on human rights and respect for diversity, and enable me to protect human rights better. In my judgment, then, it will assist me to write judgment in line with the human right, as it is stated in our Constitution, that our democracy, that human right is the cornerstone of our democracy. And all judges actually are required to promote the spirit of human right when writing their judgment. So it will be of assistance to me.
And you also have an LLD.
Yes.
Will it also assist you?
It will be of assistance to me because during the process when I studied for LLD, then I acquired extensive research skills and critical analysis, which will assist me in writing and also performing my duties.
And AFT is of the view that you do not demonstrate the abilities and experience of a High Court judge. Do you know on what basis does it say this?
No, sir, I do not have any clear picture why there is this criticism, because if the criticism was clear and specific, then I'll be able to respond to it accordingly. But I believe I've always conducted myself with integrity and interacted with both colleagues and litigants and counsels with integrity.
Yes, also the BLA says that it does not support you because you have not acted for the minimum of 3 terms.
Yes, I have now acted more than 3 terms because I have now acted for 40 weeks, which translate to 4 terms and which also translate to full year acting stint.
And you have also authored a number of legal articles.
I have extensively published, and I've even published an academic book published by Judicial law book.
So, according to your assessment, do you need more time for acting purposes?
According to my assessment, I'm now ready, because if I consider that I have served articles, practiced as an attorney, I've served pupillage, past pupillage, currently practicing as an advocate. I've also worked as a senior academic. So combining all that should make me an all-round potential judge.
Okay. Thank you, TCJ.
Thank you, AJP. Premier?
Thank you very much, TCJ. Good evening, Professor Matendra.
Good evening, Commissioner.
You've just indicated that between the last time you were interviewed and this interview, you've now accumulated 40 weeks. 40 weeks, you said?
No, in total, because when I was interviewed in April, I have acted for 25 weeks, but now I've acted for 40 weeks.
All right. Now, within that 40 weeks, inclusive, within that 40 weeks, how many times did you preside over motion court, and how many times were you able to hear urgent matters?
Almost the practice that started almost whenever you are in motion court, then you'll hear urgent matters. I was in motion court almost every week.
Every week of the 40 weeks?
Every week of my acting stint.
All right. Okay, I promised you one question, DCG. I'll stop there. Thank you.
After Commissioner Merumagai.
Thank you very much, Deputy Chief Justice. Good evening, Advocate Matunja.
Good evening, Commissioner.
I must declare that I do know Advocate Matunja. In fact, he has external for some of my courses, and I've also been an external examiner for at least one of his LLM students, if I remember correctly.
Yes, now I recognize you, Commissioner.
I want to ask you a question. I know that your research academically, it has revolved broadly around constitutional law, but mostly in relation to local government and the structures of local government.
Yes.
Currently in South Africa, we are seeing a disregard of certain processes in relation to procurement in the local government sector, and all the legislation that governs the operations of local councils and municipalities. I just want to understand from you, what can be done to ensure legally that those who are entrusted in running municipalities, especially from a procurement point of view, are able to understand, first and foremost, the laws that govern them, but most importantly, they are held accountable for the misgivings that they do at that level of government?
Thank you, Commissioner. My view is that this problem is not only located to local government. However, what exacerbates the issue in local government is that local government, in my view, it's over-regulated. Over-regulated as it is, people normally who are sent to local government might even, some of them, might even find it difficult to interpret and understand thoroughly those legislation. Not all of them, but some of them.
Thank you very much, DCJ.
Commissioner Singh?
Yes, sir. Thank you very much, and good evening, Advocate Matenga. And just for the Commission to know that I've known him for many, many years. But I just want to follow on the good professor there, on how do you think this extensive knowledge that you've acquired, and it's commendable that you've done such research, will contribute to the judiciary dealing with issues of corruption and maladministration? And have you come across any matters that you've presided over where you've had to use this research that you've acquired in making a judgment? Thank you.
At a bigger picture, Commissioner, research, especially at a senior professor level, should have an impact. In other words, it should contribute to the development of knowledge and dissemination of knowledge. So in my field, I have done that. For instance, if you have read one of my papers about judicial entrenchment of constitutionalism, before everyone tackled the issue of appointment of Chief Justices under the theme of judicial independency. So I'm the one who bemoaned that, and as it stands, the current Chief Justice and the Deputy Chief Justice are no longer appointed according to the previous dispensation. So what I'm saying, Commissioner, is that at the senior professor level, you're right to make impact, but whether what I've written have an impact on corruption, that I won't dwell, because my writings firstly was on multi-level governance, and thereafter my writing concentrated on constitutionalism and democracy.
Thank you very much, DCJ. Thank you.
Thank you,
Dr.
Commissioner.
Matendra.
Commissioner Baloyi?
Thank you, TCJ. Good evening, Professor Matendra.
Good evening.
Yes, I just want to check my maths, that my maths is correct. You say you were admitted in 98, and then you were with the firm Botha, and then in April 99, you went on to practice for your own account. So you were with Botha for 1 year, the firm
Yes,
Botha
yes.
Incorporated. And then with your firm, it was 99 to 2002, which is about 3 years, I think.
That's correct.
So that's 4. And then you went to the bar in 2021, that's 5. So that's 5
Yes,
years.
yes.
And of course, in 2021, we can fairly discount for the COVID that happened, the lockdowns and the effect on our work. So even at the bar, it's not a full year really. In 2021, you accept that at least?
Yes.
Okay, all right. So the sum of your practical experience in court work, if at all, the sum of it is that 4 or 5 years plus the 40 weeks that you have acted.
That's correct.
Am I correct?
Yes.
All right, okay, thank you. Thank you, TCJ.
Any more questions from the virtual platform?
And for me,
No,
DCJ.
thank you.
Thank you.
None, thank you.
Thank you. Professor, it's time to part. We don't have any more questions for you. Thank you, and you're excused.
Thank you very much.
Ms. Mlaba,
Good evening, Justice.
how
Good
are
evening,
you?
the commissioners. Okay. Coping.
Okay. You are an attorney.
Yes, Justice.
Since 2003.
Yes,
You did your articles between 2001 and 2002.
Yes, that's correct.
And before that, you had been a legal collections officer in the KZN Finance Corporation
Yes.
for a number of years, 6 years.
Yes, that's correct, Justice.
And you had charted your legal career with 2 degrees, BA Law from the National University of Lesotho, I almost said Roma, and an LLB from the University of Natal.
Yes, that's correct, Chief Justice.
Which is also my alma mater. You have acted as a judge in the KwaZulu Natal division for a few times, starting in April last year.
April 2021, correct, yes.
And how many acting stints have you had, and what do they add up to?
They add up to 46 weeks, Justice, yes, beginning from, as you said, April last year. Yeah, up until now.
All right. What kind of work do you do in your practice?
It's commercial litigation, personal injury claims, conveyancing. Yes, basically that's what I do.
And I see that you've said you've handled the whole range, or well, almost the whole range of cases one gets in the High Court. You've done criminal trials, civil trials, motions, opposed and unopposed appeals.
Yes.
Even full bench appeals.
Yes, I've sat in 1 full bench appeal.
How many judgments have you, written judgments? Have you
Written
produced?
judgments, I'd say plus minus 30, 35, between that.
Any of them reported?
I'm not aware of any that have been reported. I'm not sure if it counts, if it appears on SAFLI. 2 of them appear there.
Yeah, well, it is reported. I see that you have not yet been taken on appeal.
Not that I know of,
So
no.
one would assume that you're still on the right track.
I hope so.
You have partly had matters. They would have been, you would have continued with them last month.
I did during recess.
Were you able to
those 2
finalize
weeks.
them?
No, I did not finalize it because on the 2nd week, my accused, the 3rd accused, didn't see eye to eye with his counsel. And so we had to adjourn to allow the accused to secure legal representation.
All right, and there's a civil trial that you say has not been set down for a trial date yet. That's a part head?
It is part head,
okay.
yes. Yeah.
You don't have any reserved judgments, you say?
No, I don't.
Okay. You sit in a number of bodies, adjudicative bodies. You chair the disciplinary committee for the National Home Builders Registration Council since
Yes, that's correct,
2018.
yes.
And you are also deputy chairperson in the Municipal Bids Appeal Tribunal. And you are a member of the appeal panel for the Department of Economic Affairs, Tourism and Environmental Affairs. You also consider appeals there. And you are a CCMA commissioner.
Yes, that's correct, Justice.
Okay. Wow. You think you are ready to become a permanent judge now?
I believe I am ready, Deputy
What
Chief
gives
Justice.
you that conviction?
Well, throughout my career, I've worked towards joining the bench at some stage, and that is why I've availed myself to serve on those other adjudicatory positions. I believe that they have, together with my experience and qualifications, stood me in better ground to be able to discharge the duties of a judge at a high court.
Yeah. All right. I'm going to hand over to the commissioners to put questions to you.
Okay, thank you.
AJP Madon.
Thank you, DCJ. Mr. Simlaba, good evening.
Good evening, Justice Matondo.
So in the period between 2003 and 2009, did you appear before the High Court on your own account?
Yes, I did on several occasions for applications, not so much on criminal matters, but at the motion court.
Would you say that your appearance was frequent or occasional?
It was frequent, although on some occasions, as I said, I would brief counsel. Yes.
But that would not be in conflict with what you said in your questionnaire, because you say it was occasional.
Can you please direct me, Deputy JP?
No, what is that's what the LSA allege you have said.
It's 6.1 in your questionnaire.
Thank you, Commissioner. 6.1.
It's court experience.
Yes, I've ticked occasionally.
But now we say it was frequent.
Well, my apologies. I did appear on a number of occasions, yes. And occasionally, yes, I would brief counsel for the High Court appearances.
Okay. The LSA is of the view that despite that you have extensive experience in quasi-judicial environment, labor law, and convention, you still need adequate experience in handling applications of post-motion and trials. What is your view?
My view is that I'm not sure if they are correct. How I feel is that since 2001 in April, when I started acting as a judge, I have had exposure as a judge at the motion court. I have handled several applications, and during that period, I've not had any major issues in handling those matters. I also sat at the Durban High Court, and I believe that the workload there is much heavier than the Pietermaritzburg Court. I'm saying that because while at the Pietermaritzburg motion court you would have plus minus 30 or 35 matters to deal with, at the Durban High Court you would have plus minus 45 matters to deal with, and those would include Rule 43 matters that you do have to finalize on that day. So I do believe that and that's the reason why I wanted to act more, and the reason why I did not apply for the April interviews. I wanted more time at the High Court so that when I do apply and when I do sit, I do so confidently with the knowledge that I can handle those matters. And I'm not saying that I know everything right now, but I believe I do have the potential, and with the assistance of the judges in both Pietermaritzburg and Durban, which has been very forthcoming. I have approached judges and they have assisted me where there was doubt on my part. So I do believe that if I am appointed, I will continue to do so. I am ready.
So then, in your own view, your acting stint has given you sufficient exposure and experience that it can be said that you are now ready for an appointment.
I do believe that, Deputy Chief Justice, JP, I do believe I'm ready. And my experience will count, and the exposure that I've had on sitting as an adjudicator in these other panels, I do believe I am ready.
Thank you, DCJ.
Thank you, JP. Premier?
Thank you very much, DCJ. Good evening, Ms. Mlaba.
Good evening.
You're welcome.
Thank you, Acting Premier.
The LSSA, in their recommendation, they're indicating that the extensive experience you have, and they're raising it as a concern, is only on quasi-judicial environment and labor law and conveyancing, which I think on its own is not a problem. Now, I want to know, what do you think your 46 weeks of acting has taught you that you did not get in this platform?
Yes. At the High Court, I deal with issues that do not come before me as a disciplinary chair. For instance, at the NHBRC, applications do come before me that I don't deal with as a panel member or a deputy chair at the municipal bids appeal tribunals. At the court, at the High Court, you deal with different sorts of applications, and you really have to apply your mind in different areas and forms of applications. So, having had these 46 weeks at the High Court, it has exposed me to more issues that I will need to sit and decide and evaluate when I am a judge. It's not restricted only to a particular area of the law, like you would if I sit as a commissioner at the CCMA, where I deal mainly with the labor-related issues. So the area is more vast at the High Court.
Okay. At the High Court, did you have or did you sit for any criminal and civil matters, and are there any that you can remember on the top of your head?
Yes, I have sat for criminal matters. One of the judgments that I wrote, or one of the matters that I sat on, is one of the judgments that I've attached in my application, which involved kidnapping and killing of a baby. It was a prominent case, and in my gallery, in my courtroom, I would have organizations and political parties from different political parties, because it had such a public interest. And that's not the only one. The other one that I set, a criminal matter, was for the murder of a retired school principal who was murdered by her gardener. That also created a public outcry. And really, with the assistance of the assessors that I choose to work with, we really, I do believe that I did justice in the handling of those matters. With regards to the civil trials, yes, I have conducted a few civil trials. I'm not sure if I did, I don't think I did include one of the judgments for those, but yeah, I've handled civil trials. I have been allocated trials, one of which is still pending. It's Part Head. It's one of those that I've indicated. I've also, as I said, had arguments on motion courts where I've reserved judgments and then went away to apply my mind and write a judgment on those.
Thank you very much. Thank you, DCJ.
Commissioner Club?
Thank you very much, DCJ, and good morning, Ms. Mlaba.
Good evening, Commissioner.
I'm going through your CV, following the comments made by the Law Society that you appear to have extensive experience in a quasi-judicial environment, labor law and conveyancing, but you appear not to have adequate experience in handling applications, opposed motions and trials. And because of that, they don't support your nomination. Now, that took me to your form, sorry, your questionnaire. 6.1, in fact, 6, court experience. 6.1, you say that in the period between 2002 and 2009, you appeared in court frequently, but in the subsequent years, your appearance was infrequent. I think
Yes,
it's the point that JP Matondo, acting JP Matondo raised.
Yes,
And when we go to 6.2, where you are asked to list the proportion of your litigation work in terms of the fields that are mentioned there, criminal law, of course, you say it's minimal. 6.2.2, administrative law, but you list the experience you acquired, in the quasi-judicial environment. 6.2.3, constitutional law, the same thing, experience acquired in the quasi-judicial environment. Labor law, and so on, and so on. Apart your acting as a judge, and I don't get this thing that convinces me that you are a skilled legal practitioner. I don't get it. I want to take you back to your questionnaire again. During the period when you were on your own, NF Mlaba attorneys, 2010 to 2018, is the period where you appeared in court infrequently. So, and then in 2021 and 2022, since 2021, April, you literally spent all your time on the bench. And again, there's nothing to show that you did anything besides acting on the bench as an attorney. Now, I'm trying to get this thing that will convince me, because I don't appoint you, I don't recommend you on the basis of the stints that you had on the bench. We are looking for a skilled practitioner who has an advantage of having acted. I think acting gives you an advantage, but want a skilled practitioner, and of course, acting stint is an added advantage. It's not the other way around. You know, being on the bench and acting as a legal practitioner being just an additional thing. So I'm trying to get this thing that makes me to say, indeed, on this day, I was part of the GSC that recommended you to the bench. What is it that I would advance as a reason? It then takes me to the next question. What attracted the JP or acting JP to invite you to act as a judge if you have so little to demonstrate, that you are a skilled practitioner? I'm not too sure if I'm trying to, this thing is going through my mind, and I'm trying to sift this thing so that I'm convinced that you are a candidate that deserves to be appointed to the bench. Thanks. Was my question clear, colleagues?
It was, I just didn't like it.
Opinion decision?
No, never mind. I was
Okay.
pulling your leg.
Okay, thank you,
DCJ?
Yes, Commissioner Singh?
Sorry, if I may just come in just to add to the question and to that very same question. May I?
Yes.
No, thank you very, very much. Good evening, Ms. Mlava.
Good evening, Commissioner.
I note these what's described as quasi-judicial bodies that you served on. And I'm trying to, in my own mind, place a weight on the importance of those positions vis-a-vis sitting as a judge on the bench. For example, the NHBRC. Now, just as a follow-up to Commissioner Kaba, and just to emphasize the fact that, did you deal with the membership of members on the NHBRC, or did you actually deal with the unscrupulous membership and the quality of houses that have been built by some of these members of NHBRC? And the same can be said for the other body that you served on, which is there's one other body that you described that you serve on, the bids appeal, the Municipal Bids Appeal Tribunal. What was your actual role? So that I can put a weighting and a comparison between that role and sitting as a judge. So I thought I'll just add to what Commissioner Mlava had said. Thank you. Thank you, DCJ.
Okay, thank you, Commissioner. Just perhaps to start with the latter question. At the NHBRC, I sat there as a chair of the disciplinary committee. My job was to listen to the parties. The NHBRC has their own prosecutors who then charge home builders who have failed to comply with the council's rules. And mainly the two areas which are frequently contravened is failure by the home builders to enroll construction prior to the commencement of that construction. So when a home builder has failed to do that, they would be charged, and they would then be called to appear at that disciplinary inquiry. So that's the disciplinary inquiry that I would chair and make a finding together with two assessors who are experts in construction. The other contravention that they would be charged for would be non-compliance with the building standards that have been formulated by the NHBRC. So those are the two charges that I would hear and then make a finding based on. So my role in that quasi-judicial forum would be to chair those hearings. At the MBET, the Municipal Finance, MBET, the Municipal Bids Appeals Tribunal, their tribunal was set up to assist with the appeals where aggrieved tenderers who were not successful in their tenders would then be allowed to appeal, and they would look at whether or not the municipality has complied with the SCM procedures. Depending on the grounds of appeal, we would look at whether or not those grounds are valid for that award to be either set aside or confirmed. So there I would sit as a deputy chairperson of those hearings. Now, the first question by Commissioner Kaba is struggling to locate as to where my litigation experience is. I served my articles at a law firm, De Villiers, Evans and Petty. Their specialty was commercial, municipal, and property law. Every day, as a candidate attorney, I would go to the magistrate's court in their applications court. For those 2 years, I think I rotated 8 months in that field. And while doing that, my job was, as I said, appear at the magistrate's court in their applications and also assist my principal in the drafting of pleadings, preparing for trial, and attending court. That would be the litigation experience that I would have gained while I was serving my articles. And then I moved over to Ngidi Golotela in Peter. And as a professional assistant, I continued to appear mainly at the Pinetown Magistrates Court, the Chatsworth Magistrates Court, as well as the Durban Magistrates Court. And there, their main client was Itala Finance Corporation, and I would then, I was allocated that portfolio and various types of applications. There are various types of applications that I attended to, both at the Magistrates Court as well as the High Court. And then I opened my firm together with a partner, Mngomamlaba in Kumalo, where I also continued with commercial litigation. And there I branched out to conveyancing because as a law firm, a new law firm, we needed more work. And so I studied because I had interest in property law. I sat for the conveyancing exam and I passed, and then with the difficulty of us getting into the panels, my experience in conveyancing was then the private transfers because we were struggling to get into the panels of the banks and the estate agents. So I would not have experience in bond registration, but transfers, registration of transfers. But still, my job was to continue with litigation, and that is when I also got interest in labor, because we got into the panel where we allocated labor work. And also I appeared together with counsel at the labor court where we're doing labor relations issues. And that is where in 2009, so that occurred from 2004 up until 2009. where in 2009, I then attended training at the CCMA, and because of the extensive nature of that training, it was 6 months, I resigned from the firm because it would not be fair on my partner, and I concentrated on the training. And as I said, my goal was to end up at the bench. So to me, there was an opportunity to get to the CCMA because as a commissioner, I believe you discharge more or less the same duties as a judge would discharge at the High Court. So I attended the training, I got accredited as a commissioner, and I sat at the CCMA. So and then I reopened the firm NF Mlaba Attorneys because I still wanted not to miss out on the practice. But I must say, during that period, my appearance at court was limited because of the nature of the work that I used to do at the CCMA. I would go to the CCMA maybe twice per week and maybe one other bargaining council, and then I would have time at the office dealing with my matters, and that is why that litigation experience was then reduced to some extent. But overall, commissioners, I would like you to consider my experience from the time I was admitted or even before up until that period, and also taking that into account as well as the stints that I have had at the High Court. I do believe that I am ready to discharge the duties of a judge.
Thanks.
Deputy Chief Justice,
continue?
Can I follow up?
Yes, Commissioner Matolo Lebo.
Good evening, Ms. Mlaba.
Good evening, Commissioner.
I just want you to explain, because I think the commissioners need to understand that being a chair of the NHBRC, council appear before you, they raise, it's as much as it's a quasi-judicial, but tribunal, council appear before you, and they raise points in limine. You have to do a judgment. Can you just please explain to that?
Yes, thank you, Commissioner. In all these forums that I sit to chair and also as a panel member, as you know, everyone has a right to legal representation. And so in these forums, the parties would sometimes appear on their own, but in most cases, because issues that are involved, they do believe that they are complex. They do instruct attorneys, and counsel would appear before me, and they would raise all sorts of issues, sometimes points in limine, which you then have to rule before you even get into the merits of the matter. So, as I said, my goal and end goal was to end up at the bench, and so I believe that by serving on those panels, I would gain more experience in adjudication of disputes.
Can I continue? So, do you agree that acting as a judge is of secondary importance?
I agree. It is important if you want to end up in the bench.
And then the last
you would
question,
have to have initial experience before you get to act as a judge.
would you also agree that you come to the bench armed with court experience acquired mostly between 2002 and 2009?
Mostly 2002 to 2009,
Yes,
and also from 2004 up until 2018.
Thank you. I have no further questions, DCJ.
Commissioner Nyambi?
Thank you, DCJ. One question from me. Evening, Ms. Mlaba.
Good evening, Commissioner.
If you can share with us two qualities of a good judge and mainly focus on those that you think you possess.
That I think I possess.
Yes.
Okay. Thank you, Commissioner. A judge has to be knowledgeable in the law. A judge has to have integrity. A judge has to have an open mind. A judge has to uphold the values and the spirit of the Constitution. A judge has to be able to act with integrity, to act and handle matters without fear or favor or prejudice. In order to do that, you need to acknowledge what your prejudices are, so that you are aware when you're dealing with matters that you need to be objective, because if you do not know of what your prejudices are, they may affect your handling of the whatever matter that is before you. I believe that I treat people with dignity and with respect, irrespective of their social status. I believe that everyone is deserving of the protection of the law, and everyone is accountable to the same laws. And I believe, and I do believe that I am a person with integrity, both in my professional capacity and personally. I think those are the important qualities of a judge.
Thanks, Ms. Mlaba. Thank you, DCJ.
Commissioner Balwani?
Can I make a quick follow-up, DCJ?
All right, go ahead, Commissioner Malema.
I heard you describing what one would call what characterized a good judge, and you went to town about it. Do you think you fit in all of those things that you just described now?
Thank you, Commissioner. I do believe I fit in most of them. As I said, I was asked to pick two that I think I do fit, but I do believe I fit in most of them. I have the grasp of the law. I do not profess to know everything about the law, and what I do enjoy with the profession that I'm in is that where you are not clear, you do have an opportunity to research, and so that by the time you need to issue a decision or to deal with the matter effectively, then you would be confident that you are able to deal with that matter effectively. I do believe that everyone is entitled to justice, and which is why, and also effective and expeditious justice at that. And that is why I do not believe, or I do not have any reserved judgments. Yes,
You see, the issue, sorry for my interruption. You were asked to give two, and then you went to town and invited this problem for yourself.
Oh.
Now, and in answering again now, you create another problem for yourself. You say most of them. Which ones do you think you're not fitting? Of all those, the ones that you have listed. And today we want to finish early, I'm sorry, so that's why I'm interrupting you.
Okay, thank you, Commissioner. As I said, I do not know, or I'm not conversant with all the areas of the law. And that is a point that I need to work on. As to integrity and the rights afforded by the Constitution, I do believe I work towards that, and I do treat people with dignity and respect.
Thank you very much, DCJ.
Commissioner Balloon?
Thank you, DCJ. Good evening, Ms. Mlaba.
Good evening, Commissioner.
I think when you were answering the acting premier, you said you were not sure if you had included, you were asked about your civil matters. Just to point out that you have included 2 civil cases, Ikubu versus APSA, you have that, and then you have NMI Group versus MEC Public Works. I'm just mentioning.
Okay.
Now, am I correct in my computation of your period as an attorney? I have calculated it to 16 years. Does that sound
Yes,
right?
that sounds correct, Commissioner.
So you've been an attorney for 16 years?
That's correct,
All
Commissioner.
right. And you say you've acted for 42 weeks?
Yes, for 46 weeks, Commissioner.
46, you say. I'm sorry about that. Yes. Now, if you would just explain in what way do you consider that the adjudicative tribunals that you serve in the way that you've described, how that has contributed to your skill, or to give you a skill that you think puts you in good stead of at least starting off as a judge?
Okay, thank you, Commissioner. Sitting in those forums has allowed me to be able to conduct hearings and observe the principles of procedural fairness. I afford parties an opportunity to state their case. That is important. I afford parties to ventilate issues, and I know once that has been done, then I would have enough information that would assist me to make a finding or a determination of the issues that have been raised. It has allowed me to know that whenever you deal with a dispute, what is your job as a decision maker? You need to sift the relevant facts from what the parties may submit, which may not be relevant to the issues that you need to decide on. And you are able to guide the process and take charge of the process, and also to guide the parties when they perhaps give information that is not relevant, without being in a respectful manner, without making the parties feel like they are, really out of what they're supposed to be doing. And then at the end, it has also assisted me to be able to evaluate the evidence that they would have led, and then make a finding based on that.
Thank you, Ms. Mlaba. Thank you, DCJ.
Commissioner Notice?
DCJ. Ms. Mlaba, I'm asking you this question. Are you aware of the principles set out in Plascon Evans?
Yes, Commissioner.
Can you just summarize?
Okay. The Plascon Evans rule allows a court or a judge to make a final determination of a matter based on the evidence that you would find in the affidavits, even where there is a dispute of fact, because ordinarily, where there is a dispute of fact, the parties would then be asked to lead oral evidence. However, in motion proceedings, where parties give their evidence via their affidavits, the judge is then allowed in terms of that rule, to make or to finalize or to give a final determination of a matter.
What does the rule say? How do you do that? What does the rule say?
Okay, so where the applicant has made averments or allegations and the respondent does not or admits those allegations by the applicant, and also based on the averments and allegations by the respondent, then the court will feel that it can, even though there is a dispute of fact, make a final determination of the matter based on the averments by the respondent as well as the admissions by the respondent of the applicant's allegations.
If as a judge, in the process, you write a judgment, but in your order, you omit to state, for instance, you want to grant costs for the plaintiff, but you don't write that, you omit and deliver the judgment, only realize later. What would you do to remedy that situation?
I'm sorry, Mr. Nokesa, I didn't hear that question.
You are a judge, you have prepared a judgment, but in your judgment, you omitted an order that we have in the body of the judgment intended to grant, like granting cost order, but you simply don't make that, you don't specify in your order and deliver your judgment. But once your judgment has been delivered, you realize, oh no, I have not stated that costs are granted. The question is, how would you go about to rectify? What should you do?
So the judge would have made an error there, and the rules of court allow for a judge to correct that order without even the parties making an application for that error to be corrected. So you would then, as a judge, vary your decision by an addition of that which you have omitted to put in your order.
Commissioner Marumachai?
Thank you very much, DCJ. Good evening.
Good evening, Commissioner.
You highlighted the plight of women indirectly who are opening their own law firms, and the fact that they are not given the work that ultimately will ensure that at the time when they are judged, they can be judged objectively based on the work that they have done, and I appreciate that. But it appears as if, to some extent, you were exposed to labor law. Am I correct?
Yes, I was exposed, Commissioner.
Yes. I want to ask you a question in that area of law, because perhaps maybe when you get this job, you might be seconded to that court, and the JP of that court is actually here. There is an issue in South Africa in relation to disciplinary hearings, where there is no law apart from one of the schedules that allows people who are accused of some workplace transgression and they are placed into disciplinary hearings for them to be able to bring their own legal representative, right?
Yes.
But employers are allowed to go and seek out somebody who is legally trained to chair the disciplinary hearing. I'm wondering, what is your view, if any, if you have thought about it, in relation to the power play, where the law says, no, you can get another employee or somebody within the organization, but the employer is allowed to bring a legally trained. Do you think there is parity there, there is fairness? What is your general view in relation to that?
Okay. So, Commissioner, if I understand your question is, the employer is allowed to bring a legally qualified person to chair the hearing, not to represent the employer.
No. Okay. Remember, the employer is the one who's doing the disciplinary hearing, so it does not necessarily need a representative. I mean, they will just call witnesses. Maybe one of the managers will come and give testimony. I'm just talking about the chairperson of the commission.
I'm sorry, but that's a totally unfair question. And really, it's wrong. I don't think you need to answer that. Through you, DCJ, please.
Yeah.
Thank you.
I'm inclined to agree with you.
Sorry, Deputy Chief Justice, I think it is a question that just elicited a thought.
She's standing for the High Court. If you want to ask her labor-related questions, wait till she applies for the Labor Court.
Judge, I understand that. When you speak, I listen because I respect you. It is just a question, and she can just reflect on it. It's not something that is...
You asking her if it's fair that an employer employs a lawyer to chair a misconduct inquiry. Am I right?
With due respect, Judge President, it is just a question. We will just reflect on it. Thank you very much, Deputy Chief Justice.
Put the question, let her answer, and we can have this discussion during deliberations.
It's not a question that I will go to war with Deputy Chief Justice. It was just a question based on the experience that she was exposed to. If it can be left alone, then I'm fine with it. It's not something that I was really committed to asking. I thought it was a fair question because of her experience. But I accept.
As I say, if you still want to put it. She'll give whatever answer she has, if any, and we can discuss the merits of her answer during deliberations.
No, thank you very much. I think she understood the question. She was ready to give an answer to it. And if she does, then I'm fine with it. Even in the deliberations, I'm not going to raise it. It's not necessary.
Okay. Can I proceed?
Yes,
Okay.
Ms. Mlebo.
Okay, thank you, Commissioner. Well, for me, I think there is an employee on this side, and the employee, when it's an internal inquiry, the employee would then be allowed to bring representation. However, that representation must be by a fellow employee who may be a union member, who would somewhat be knowledgeable in the conduct of the disciplinary inquiry. And on the side of the employer, it would perhaps, the initiator or the prosecutor would be a manager who is able to conduct the disciplinary inquiry. The chairperson, it should not, to me, I do not think that it is unfair, because the chairperson's role is to make a finding once the chairperson has heard both sides from the employer and employee. And that chairperson has to at least have basic knowledge, which I think it may be the reason why the employer would get someone who is legally trained, who would understand the process and guide it and conduct it fairly. As long as the chairperson is impartial and applies and gives reasons for his decision and gives an opportunity to both parties to state their case, I think it would be, it's okay, it's in line.
No, thank you very much, Judge. Thank you very much, Deputy Chief Justice.
Any questions from the virtual platform?
Thank
All
you,
right.
Justice.
Thank you. Is there a request to put a question? No? Oh. We have reached the end of your interview, Ms. Mlaba. Thank you so much for joining us. You are excused.
Thank you to the commissioners as well. Thank you.
Let's clear the room for deliberations, please.